YouTube live. My lord, quote number 11. I'm sorry, my lord. Quote number.
ಅದೆಲ್ಲ ಮಂಡೆ ಹಾಕ್ಬಿಡಿ.
My lord, quote number 11 matter. The order of attachment tomorrow, my lord. Emergency.
ನಾಳೆ ನಂದು ಇಲ್ಲ.
ಅಲ್ಲ ಅಲ್ಲ ನಾಳೆ ಅಲ್ಲ
ಅವ್ರ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಅಂತ
ಅವ್ರದ್ದು ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಬಂದ್ಬಿಟ್ಟೆ ಅದಕ್ಕೆ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಬಂದಿದೆ ಅದಕ್ಕೆ ವಿತೌಟ್ ಮೇಕಿಂಗ್ ಆಸ್ ಪಾರ್ಟೀಸ್ ಅದಕ್ಕೋಸ್ಕರ
ಮಂಡೆ
ಅಲ್ಲ ನಾಳೆಗೆ ಬೇಕು ಸ್ವಾಮಿ ಯಾಕಂದ್ರೆ ಇಲ್ಲ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆಗೋಗ್ಬಿಟ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ ನಾಳೆ ಅದೊಂದು ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಮ್ಯಾಟರ್ ಮಾಡಿ ರಿಟ್ ಪಡಿಸಿ.
So tomorrow also I'm only sitting up to 12 o'clock and I have got
quote number 11 matter. I'm sorry, my lord. I owe apology.
I 2:30 ತೊಗೊಳ್ಳೋಣ ಕೊಡಿ ಇವತ್ತು.
Please.
ಇಲ್ವಾ? 2:30 ನೋಡೋಣ 2:30.
But serial number 10 and 11
please,
4
please.
minutes.
Serial number, hotel number 11 for Monday, please.
Lords, hotel number 11, my lords. Serial number 10 and 11 for after vacation, my lords.
ಆಯ್ತು ನಾವು ಮಂಡೆ ಹಾಕಿದ್ದೀವಿ ಫರಾ.
Please.
My lord, I appear for the petitioner. My lord.
Yes, madam.
Not in this by a mistake, typing mistake, I think. My lord, the matter stands covered by the Maramalki judgment. There were 3 judgments in that category, my lord. And this
ನೋಡಿ ತಪ್ಪಾಗಿದೆ.
para 4, son. Para 4.
ಈ ಕವರ್ಡ್ ಬೈ ಸುಮ್ಮನೆ.
Para 4 and that and the adjournment ಏನು? My lord, this Maramalki judgment would have to be applied, my lord. ಹೌದು, ಅದರಲ್ಲಿ 3 ಕೆಟಗರಿ ಇದೆ ಸ್ವಾಮಿ.
My lord, in this case, forest, if forest land Maramalki will not be valued ಅಂತ ಇದೆ. ಅದಿದ್ರೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ ಇವರು.
ಅಲ್ಲ, ಚೆಕ್ ಮಾಡ್ಲಿ, ಅದಕ್ಕೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲ, ಚೆಕ್ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ. ಆದ್ರೆ ಇದು
at the time of enquiry ಹೌದು ಅದಿದೆ, ಎಲ್ಲಾದ್ರಲ್ಲೂ ಇದೆ.
ಆದ್ರೆ impugned order, my lord, is cancellation order, my lord. It's on the ground that there is no valuation of the standing trees, my lord. That observation may please be made. That is all I pray for. Because
ಹೌದು,
ಯಾಕಂದ್ರೆ ಇಲ್ದಿದ್ರೆ ಇವ್ರು ಪೆಟಿಷನರ್ಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗತ್ತೆ ಸ್ವಾಮಿ.
ಪ್ಲೀಸ್.
Yes, sir.
Yes.
I will add those.
Please.
Yes.
Will add to those 2 conditions.
Yes, my
ಆ condition.
lord. Those judgments
Yes.
which pertain to this, my lord, I will put it.
ಅಲ್ಲಿ ಪ್ಯಾರಾ 8 ಗಿಂತ ಮುಂಚೆ the authority shall also, before para 8, shall also examine during the course of the inquiry as to whether there are standing trees in the granted land, ಆಮೇಲೆ ಇಲ್ಲಿ ಏನ್ ಮಾಡಿ ಗೊತ್ತಾ, 3 ಆದ್ಮೇಲೆ 4, 5, 3 ಆದ್ಮೇಲೆ 4 ಒಂದೇ 4, 3 ಆದ್ಮೇಲೆ 4 ಇದ್ದಿದ್ದನ್ನ 5.
Oblige.
Yes, sir.
For the petitioner.
Was notice, emergent notice was issued by this honorable court, my lords, regarding the order passed by the.
Yes, Ramesh.
Await notice ಅಂತೀನಿ.
Await notice, huh? await
Notice
notice.
issue. Yes, my lords.
Await notice. Release this matter in preliminary on date court immediate after vacation. Next.
Much of.
Yes, Harish.
That about 58 peoples have been granted with land in the year 1980 by allotting block number 1 to 58. I purchased the block number 2 after the alienation period is over in the year 1999.
Ah.
Lord, all of a sudden somebody claiming that it is allotted to block number 59. That is nowhere available in the revenue sketch. Kindly see the annexure A. Only 58 blocks are there. Now Milord shares is claiming that there is a block number 59 and applied for POD. Now Milord, without issuing notice to us, overlapping POD is done, that too next to my land. Kindly see Milord, that annexure A is very clear that it starts from block number 1 from the top and ends at 58. And in
Now,
this,
all right, surveys conducted
Yes,
on an assumption that block
conduct-
number 59 is there.
yes, Milord, kindly that even the revenue
All right,
authority,
what order you have challenged now?
Milord, there is no notice to me at all.
And
And
what is
it
the
is-
order and the challenge? Who has
Uh,
passed this order?
Milord, I have challenged that POD before the joint development, that is JDLR,
Ah.
and by filing a revision petition, and there was a stay. Then it was dismissed, and against which I am before your lordship. Milord, kindly see annexure, Milord, for the time being annexure D, Milord. Even the revenue authority surveyor also says that there is no documents to show the flow of title. Kindly see this, annexure D.
Yaldo title private respondent da.
Howದು?
Annexure, D,
Annexure D, Milord.
page.
Page number 29.
Yeniga 40 is done with an assumption that there is a property bearing block number. 59.
Block number 59. And that is overlapping with my land.
Oh, fictitious block number.
Yes, they say that there is.
ಡಿ ಸೇಸ್ ಮಿಲಾಡ್
Ah,
ಅನೆಕ್ಷರ್ ಡಿ ನಲ್ಲೇ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವ್ರು ಕ್ಲೀನ್ ಆಗಿ
ಏನ್ ಹೇಳ್ತಾರೆ?
ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧಿಸಿದ ಶಿವಮೊಗ್ಗ ತಾಲೂಕು ನಿಧಿಗೆ ಹೋಬಳಿ ಕೊರ್ಲಹಳ್ಳಿ ಸೋನ್ಸೋ ಏಕವ್ಯಕ್ತಿ ಪೋಡಿ ಅಳತೆಗಾಗಿ ಬಂದಂತೆ ಭೂಮಾಪಕರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿ ಭೂಮಾಪಕರು ಅಳತೆಗಾಗಿ ಸ್ಥಳಕ್ಕೆ ಹಾಜರಂತೆ ರೆವಿನ್ಯೂ ನಕ್ಷೆಗೂ ಸ್ಥಳದ ಅನುಭವದ ಅಳತೆಗೂ ವ್ಯತ್ಯಾಸವಿರುವುದರಿಂದ ವ್ಯತ್ಯಾಸದ ಬಗ್ಗೆ ಅನುಭವದಂತೆ ನಕ್ಷೆ ತಯಾರಿಸಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ಭೂಮಾಪಕರು ತಯಾರಿಸಿರುವ ನಕ್ಷೆ ದೃಢೀಕರಿಸಿ ಸಲ್ಲಿಸಿದಲ್ಲಿ ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು ಎಂದು ತಿಳಿಸುತ್ತಾ ಸದರಿ ಉಲ್ಲೇಖಿತ ADLR ಇಂದ ಮಾಡಿಸ್ಕೊಂಡ್ ಬರ್ಬೇಕಿತ್ತು.
Ah,
ADLR ಇಂದ ಸರ್ಟಿಫೈ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. So accordingly they have done. ADLR has long back it has been done, my lord. Durasta has been done.
Kindly.
that has to be supported by revenue records and title documents.
My lord, the
Where is that block number? 59?
JDLR has passed detailed order, my lord, wherein he has clearly stated some grants have been fictitious grants. That is the
All right, then you have to hold an inquiry to ascertain whether his grant is genuine or not. Under 40, you can't create one more block number, which was not in existence.
detailed
Secure
order has matter
Revenue
request.
records, secure revenue records.
Yes, my lord.
ಇದು ಯಾರು ಮಾಡಿದ್ದು? Third respondent ಮಾಡಿದ್ದ?
Yes,
JDLR.
40 na?
also.
And this is confirmed by regional joint director.
ಅಲ್ಲ, third ಅಲ್ಲ,
ADLR fourth
fifth ಅಲ್ಲ ಅದು.
change ಆಗಿದೆ.
Fifth, Milord. ADLR is fifth. That is confirmed.
This is done by ADLR. And you preferred an appeal before?
Joint development, joint director in the revision under section 56.
Appeal was before whom?
That not appeal, Milord. I have challenged it to a revision before the joint director of land records.
Regional joint second R2.
But directly revision ಮಾಡಿದ್ರು.
ಹೌದು, revision
ಯಾಕೆ?
ಮಾಡಿದೆ. revision ಮಾಡಿ, ಯಾಕಂದ್ರೆ time ಆಗಿತ್ತು ಅದು. Because of there is some delay. So revision is exercised. There was a stay and it, while dismissing it, stay was vacated.
ಬರ್ಕೊಡ್ರಿ.
That is the observation because of inordinate delay.
All right, heard the counsel for petitioner. Learned AG directed to accept notice to respondents 1 to 5. Petitioner has purchased a portion or entire.
3 acres, entire 3 acres in block number 2,
Has purchased block number 2 in survey number 31.
31 bar 2.
Through registered sale deed dated 19/7/1999. Petitioner's vendor,
Nagaraj.
Nagaraja,
ಹೌದು.
applied for
number-
grant and the authorities have granted this land in favor of petitioner's vendor. Petitioner is aggrieved by the survey done by survey undertaken by fifth respondent on an application submitted by one Geeta Mani who had applied for 4D, alleging that she's also granted a portion of the land in the same survey number under block number 59. Next, petitioner is aggrieved. Petitioner contends that this block number 59 is a fictitious and no such block number is available in survey number 31. Referring to the annexure A,
Revenue sketch, my lord. Allotment at the time of allotment to the
revenue
grantees.
sketch would point out that in all, there are only 58 blocks. You would also point out this creation of block number 59 is not supported by any revenue records and title documents. Therefore, the survey sketch prepared by fifth respondent requires examination at the hands of this court as petitioner apprehends that creation of block number 59 virtually overlaps with petitioner's property.
Some portion of
Some portion of petitioner's property which is situated in block number
2.
Having examined the records, this court is of the view that petitioner is entitled for some protection pending consideration of so and so. For the reason stated supra, the execution and operation of Akarban Durasti made by fourth respondent in survey number 31/51 by assigning a new survey number 96 to an extent of 3 acres is hereby stayed pending consideration of the caption petition.
Fifth respondent, fourth respondent, fifth.
You have notice to respond number 6. Yenadu?
While dictating your last fourth, fifth.
Durasti by fifth respondent.
Private respondents.
Correction madbidi.
Martin.
1 to 5 is taken.
1 to 5 learned AG issue emergency notice to R6.
R6 to 10, my lord.
R6 to 10, yes. What about office objections, Harish?
That is the sketch in a typed copy ಹಾಕುಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Office objection overruled. ಅದು ಒಂದೇನಾ?
ಎರಡು sketch in a typed copy.
Office objection overruled. Yes.
It is not legible.
ಏನ್ ಅದ್ರದ್ದೇನ್ ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ legible ಕೊಟ್ರೆ ಒಳ್ಳೆದಿತ್ತು.
ನೀವೇ ನಿಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ರೆಡಿ ಮಾಡ್ಬೇಕು ಅಂತೀಗ. Digital. It can't be done. All right. Yes, next.
Correction ಮಾಡು.
Yes, sir.
I appear for the petition council member. The present petition has this case and the next connected case, both are connected. So Lakshmi kindly, they are the cultivating the land in question since for more than 35 years. And then their application for under form 53 is pending consideration from last 30 years. May I request, my lord, for a minute, Lakshmi kindly, the first order of this honorable court is at page 31, maybe kindly be seen, my lord. 31 and also the order of the first order is at the annexure.
All right, yes, Harish.
My lord,
Now,
it has
the
been
point-
seized with,
Huh?
it has been seized by the land tribunal matter.
Land
court.
grabbing, huh?
Yes,
Okay.
land grabbing court. my lord.
Oh, no, your Lakshmi kindly.
Your applications are pending since.
No, your Lakshmi, that's why may I request the order of this honorable court. Your Lakshmi kindly appreciate the point for consideration here. Page 38 may be kindly be taken, my lord. The order of this honorable court in the 13th March 2018. We have all these petitioners, this case and next case, all the petitioners are questioning the legality and correctness of the revenue authorities. In fact, in this matter, we have questioned the order of that is the Assistant Commissioner, Annexure B, that is at page 37. Later, we have had a writ petition. The order of the writ petition reads, the order of the revenue authorities has been extracted in page 48 by the learned judge of the honorable court. 47. Your Lakshmi kindly appreciate this. Page 47, Mela. In correction, 47. 47, Mela. This is dated 13th March of this honorable court with a referring all these issues. Ultimately, the operative portion on reading of the aforesaid order, it is noted that there has been no consideration of the pleading and the contentions raised on behalf of the petitioner through their counsel. In fact, there has been no hearing of the counsel of the petitioner. A cryptic order has been passed as if it is in the nature of an administrative order, whereas the second respondent authority was considering the appeal filed by the petitioners herein and therefore had to dispose of the appeal as a quasi-judicial authority. There have been no reasons assigned for the dismissal of the appeal, as there is no proper consideration of the pleading and the contentions of the petition. Further, there has been no opportunity given to the petitioner to make submission in the matter. Even the forum in which the order is made is incorrect. The aforesaid infirmities have been resulted in the order being a nullity. In the circumstance, it is quashed. The matters are remanded to the second respondent authority to reconsider the appeals filed by the petitioner herein as a quasi-judicial authority in accordance with the law. This is the order of the learned judge of this court. You may request same order as the another case, another batch of matter. May request, my lord, page 54, annexure D may be kindly be seen. After the passing of this order by this honorable court, may request your lordship kindly see the order of the assistant commissioner, subdivisional magistrate, that is a subdivision AC. This is page 54, annexure D may be kindly be seen, my lord. The last cooperative portion, your lordship, page 55.
55.
May read, my lord. ಮೇಲ್ಮನವಿಯನ್ನು ಭಾಗಶಃ ಪುರಸ್ಕರಿಸಿದೆ. ಮೇಲ್ಕಂಡ ಪ್ರಕರಣಗಳ ಮೇಲ್ಮನವಿದಾರರು ಅನಧಿಕೃತವಾಗಿ ಸಾಗು ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ ಮಂಜೂರಾತಿ ನಿಯಮಗಳನ್ನು ಮತ್ತು ಮೂಲ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ, ಇವ ಲಕ್ಷ್ಮಿ ಕೈಲಿ ಅಪ್ರಿಶಿಯೇಟ್, ಸರ್ಕಾರದ ಆದೇಶ ಹಾಗೂ ಸುತ್ತೋಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮಾವಳಿಗೆ ಒಳಪಟ್ಟು ಅರ್ಹರಿದ್ದಲ್ಲಿ. This is the order of the after the order of remand by this honorable court.
Now the matter has to.
Now till today, no committee is constituted. No, we are not. That is the point for
Yes,
you.
my lord, before the land grabbing
It's
committee.
not that as if ನಿನ್ನೆ ಮೊನ್ನೆ ಬಂದವರು they are asserting their.
Yeah, my lord, in before the land grabbing court.
What happened before the committee?
Kindly see, my lord, land grabbing court, my lord. 78 say page number 78 may kindly see.
That is all.
They are admitted, they are not in position.
We never.
When they are enlarging the bail, they are admitting that they are not in the possession.
They are not in possession.
Please, my lord, they are admitting in the bail application.
ಯಾವಾಗ? When they are not in possession.
2021.
Their claim is from.
Earlier, they are
What
claiming,
is
my
the
lord.
date of application? Form number 53, when it was filed?
They have not produced it before this one. Form number 53 is not
No,
there.
no, now that the matter is remitted back to committee
madam.
has to decide.
Please, my lord.
Then
But here it has been already allotted to the some veterinary department. All the property has been allotted to the
What
veterinary.
is the status?
Therefore, my lord, I'll get
What is the
the
status?
proper instruction, I'll get the.
But still you have to decide their claim.
Yes,
Because here,
exactly.
my lord, in the land
No, if
grabbing
committee-
code,
No, correct, fair enough. If committee were to hold that they were actually cultivating and they had, and if they are able to substantiate that they were entitled to seek a regularization, even if this land is lost,
please,
you have to carve out some other land and you have to give it. to
Yes,
them.
exactly, that is the point.
please, my lord. It is
That you
correct,
have
my
to
lord.
do.
But here what happened, my lord? They, in this survey number, my lord, they are not in position.
No, but if.
They are admitting.
Harish,
We are, no, sorry, you are.
maybe, wait, sir, wait. Probably in 2021, you might have disposed of them.
Please.
That is not the issue. Question is, when the applications were tendered, and in the application, what is the date that is indicated that since how long they are in possession?
I will get the,
Those materials are important, and if they are able to substantiate
please, ma'am, please.
before the committee that they are entitled to seek regularization, in the interim, you cannot divert and then say that they are not entitled.
Please, kindly have to
Yes, sir.
Tuesday, my lord, I'll secure the records before this honorable court and we'll see, my lord.
Tuesday.
Tuesday, my lord.
Let them not dispose of such. In fact,
Your possession is
remove
our
this-
own.
no, we never reviewed that. That is the point for your, I brought to your lordship kind notice. Survey number, they have what we have shown in our schedule, that is 167. Their schedule, there now what we have, the land grabbing court is 142 and 147.
No.
We have nothing to do. In fact, now in the index itself, in the
Several survey
Your
numbers
Lordship-
involved in the land grabbing court. Several survey numbers. are
Page number
involved in the
60.
land
Exact-
grabbing court.
ಆಮೇಲೆ there is a-
130 is also there. 130 is there.
ಇದಿದೆಯಾ?
ಇದೆ 130 ಇದೆ.
ಹಾ?
130 ಇದೆ.
ಈ
No, no, your lordship.
ಈ petition ಅಲ್ಲಿ what
ಅವರೇ
are the
produce
survey
ಮಾಡಿದ್ದಾರೆ.
numbers ಅದೇ? Just a minute.
Please, sorry, sir.
ಯಾವ್ದೇ ಸರ್ವೆ ನಂಬರ್ ಇದೆ ರೀ ಈ ಕೇಸಲ್ಲಿ?
Pardon.
Form number 7 is filed. What are the?
Form
details of survey?
53 is filed before the pending consideration before the, since from 25,
Survey
30.
numbers, which are the property details?
The stage may 16 may be kindly be seen, madam. Page 6. 16. 16 some. There is this,
Survey number 179, block, new block survey number 167, 171.
page number 58 is bani some. Land grabbing court order ge.
Harish, whether
Yes.
the same lands are part of land grabbing proceedings?
Yes, ma'am. Yes, ma'am. All the survey numbers.
Our
involved
claim
in this
ಮಾಡಿರೋದು
land grabbing
142.
proceedings.
The last page kindly.
Land grabbing is,
Now the land grabbing court.
ಎಲ್ಲಿದೆ ಅದು order?
Now 58 may be kindly be seen, my lord. Page 58, we ourselves. And there is the petition, oh, the petition.
Only proceedings, the
ಹೌದು.
only proceeding pending before land grab.
Land grabbing court ಅಲ್ಲಿ ಇದೊಂದೇ proceedings.
Was there-
ಇದರಲ್ಲಿ there is a, in fact, my lord, there is a specific direction to conduct a spot mahazar ಮಾಡಿ ಅಂತ ಹೇಳಿ DC direction ಕೊಡ್ತಾರೆ. Spot mahazar ಇವತ್ತವರೆಗೂ ಮಾಡ್ಲಿಲ್ಲ. Land grabbing committee constituent from last 30 years. They are agriculture coolies, my lord.
Heard the learned senior counsel appearing for petitioners, learned AGA appearing for respondents 1 to 7. Learned AGA has strongly objected in granting interim order in the case on hand. To justify his statement, he submits that these petition lands are already resolved to be diverted to be utilized for
Place for veterinary department.
veterinary department. He has also brought to the notice of this court that petitioners have admitted in unequivocal terms in the proceedings pending before land grabbing court that they are not in possession of these petition lands. Next, this statement is effectively countered by learned senior counsel by placing reliance on the proceedings of land grabbing court evidenced at Annexure E. You would point out that the subject matter of land grabbing proceedings pertains to survey number 142,
Exactly.
while petitioners herein are not at all asserting any possessory rights in respect of survey number 142. This next, having taken cognizance of the order passed by this court in earlier round of litigation evidenced at Annexure C, and having regard to the fact that Assistant Commissioner, in compliance of direction issued by this court, has set aside the earlier order and the matter is now remitted back to the committee for fresh consideration as to whether these petitioners are entitled to seek regularization, this court is of the view that petitioner is entitled for some protection till next date of hearing. For the reasons stated supra, respondents are hereby directed not to take any precipitative action till next date of hearing. Liberty is reserved to state to file vacating applications by furnishing documents on the next date of hearing. Read this matter in preliminary hearing after vacation court.
Oblige.
Next,
Same connected matter, same submission.
same, ಎರಡು same.
Same. Both are.
Compliance ಏನು?
Complaints, form 53, but all are referred in the orders of this court and earlier,
No.
earlier order of the Honorable Court.
Huh? Prayer ಸರಿ ಇಲ್ಲ.
ಎದಿರಲ್ಲಿ
ಆಯ್ತು ನಾವು ಕೊಟ್ಬಿಟ್ಟಿದ್ದೇವೆ. Office objection overruled.
oblige.
Yes, next.
Not under challenge, Lord, mutation entry. Right from 1933, my Lord, 1933. They have been in
33.
possession of the property. That is Veeranna Devaru was the original propositors.
Use the mic. You're not audible.
1933, my lord. Since 1933, we have been in possession. Veeranda Devaru entry is there in the mutation entry. That was restored by the order of the Assistant Commissioner in the mutation. Subsequently, this fourth respondent, this fifth respondent, Lord, he got the mutation entry in his name. That is fifth respondent is our family member. Sixth respondent is the purchaser now during the pendency of the appeal and also during the pendency of the suit. Now the
Suit is pending.
suit is pending. Partition suit is pending.
Who has filed partition?
We have filed a suit for partition, petitioners. We have filed a suit for partition. The partition suit is pending.
On the day you file partition suit, in whose name this property is standing?
We are under the mortgagee. We are the mortgagee of the in possession of the property right from 1933, my lord.
RTC.
Well, we are in possession. Even now we are in possession.
You're still not answering my question. I asked you, the day you filed a partition suit, the property is standing in whose name? In RTCs.
Veeranda Devaru. Veeranda Devaru. That is, your lordship may kind to see.
Who is Veeranda Devaru?
Veeranda Devaru was our original propositors. Veeranda Devaru. We are claiming under him.
ಈಗ ಯಾರ್ದಿದೆ ಈಗಲೂ ಯಾರ್ದಿದೆ
ಇವಾಗಲೂ ಇವರು ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಹೆಸರು, ದಟ್ ಈಸ್ ಫಿಫ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೆಸರಲ್ಲಿದೆ.
Yes, purchase pending suit.
Pending suit. This sixth respondent now. Purchase pending, purchase the property pending suit.
Now, Veeranda Devaru's name is removed and this purchaser's name is mutated.
Veeranda Devaru is removed.
ಅಲ್ಲ
and also-
ಮಾಡ್ಬೇಕಾದ್ರೆ ಯಾರು ಮಾರಿದಾರೆ ಅವ್ರ ಹೆಸರು ಇಲ್ವಾ?
ಇಲ್ಲ, ಸಿದ್ಧಲಿಂಗಯ್ಯ ಸ್ವಾಮಿ.
Where are the RTCs?
RTCs are produced, annexure G. That is in the name of Siddhalinga Swami. That is the fifth respondent here. That is, he is our member of the family.
Where is that mutation where now purchaser's name is ordered to be mutated?
That is at annexure. Annexure P, my lord.
Page.
One.
It's 125. 125 page.
125.
ಯಾರು ಮಾರಿದ್ದೀಗ?
The Siddhalinga Swami, that is fifth
MS.
respondent, he sold the property to Mallikarjunappa Halappa Trust. Our right is recognized right from
Not to
1930.
elect order ತಗೋಬೇಕಾಗಿತ್ತು, ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ?
Please, my lord.
Why you are not filing an application seeking injunction?
Well, injunction is still pending, my lord. Injunction is still pending. The court has not considered that IA. The matter is still pending in the court.
2019 partition suit.
Correct. The matter is still pending. That IA is still pending.
Whether purchaser is impleaded now.
I impleaded. Impleaded also in the appeal also impleaded.
Seek appropriate relief against him.
I will seek up. In the meanwhile, madam, there is a change of mutation order. Mutation entry has been made. This has to be stayed, my lord. Right from 1933, we are in possession.
You are in possession.
Please, madam. That our right has been recognized.
Where are the earlier?
Page 46, my lord. Kindly see, my lord, page 46. Page 46. 147/1 5 ಎಕರೆ 5 ಗುಂಟೆ ಜಮೀನು ಮೂಲತಃ ಲೇಟ್ ಮರಿ ಬಸವಯ್ಯ ಬಿನ್ ಚೆನ್ನಬಸಯ್ಯನವರಿಗೆ ಸೇರಿದ್ದು. ಇವರು ಪ್ರತಿವಾದಿ 1ರಿಂದ 4 ಅವರ ತಾತನವರು ಸದರಿ ಮುನಿಬಸಯ್ಯನವರು ಪ್ರಸ್ತಾಪಿತ ಜಮೀನನ್ನು ಲೇಟ್ ಅಲಿಯೂರು ವೀರಣ್ಣ ದೇವರು ಮೇಲ್ಮನೆದಾರ ತಾತನವರಿಗೆ ನೋಂದಾಯಿತ ಭೋಗ್ಯ ಪತ್ರದ ಸಂಖ್ಯೆ ಸೋಣಿಸಲಿ ಭೋಗ್ಯ ಮಾಡಿದ್ದರು. ಆದರೆ ಸದರಿ ಭೋಗ್ಯ ಬಿಡುಗಡೆಯಾಗಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ ಕಂಡು ಬರುವುದಿಲ್ಲ. ಹಾಗೂ MR 87/2001 ಖಾತೆಗೆ ಪೂರ್ವದಲ್ಲಿ ಮೇಲ್ಮನೆದಾರರಿಗೆ ಯಾವುದೇ ನೋಟಿಸ್ ನೀಡಿ ವಿಚಾರಣೆ ಮಾಡಿರೋದು ಸಹ ಕಂಡು ಬರುವುದಿಲ್ಲ.
ಎಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಜೊತೆಗೆ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಇಲ್ವಾ?
ಇದೆ ಫೈಲ್ ಮೇಡಮ್.
Where is the family tree?
Family tree of the very first page, page 18 minute, page 19. ವಂಶವೃಕ್ಷ ತೋರಿಸಿದ್ನಲ್ಲ, page 19. 19.
Plain ಜೊತೆಗಿಲ್ವಾ?
ಇದೆ. It's there. See, along with the writ petition I filed, page 19.
ನಾನು ಪ್ಲೇಂಟ್ ಕಾಪಿ ಜೊತೆಗೆ ಇದೆಯಾ ಅಂತ ಕೇಳಿದೆ.
ಇದೆ ಪ್ಲೇಂಟ್ ಕಾಪಿ ಜೊತೆಗೆ ಇದೆ.
ಎಲ್ಲಿದೆ? ಇಲ್ಲ
ಪ್ಲೇಂಟ್ ಕಾಪಿ I have produced, but I produced very same family tree in the plaint, along with the plaint.
You represent which branch?
I represent, that is Mallikarjunaya. That is on the left side, madam. First, my HB,
Now,
HB,
who has alienated?
please, madam.
Who has sold this land pending suit?
This Mallikarjun Swami. Mallikarjuna Swami, he sold the property.
Elli avaru where is?
I'm sorry, Siddhalinga Swami, he sold the property, madam.
Branch ಅಲ್ಲಿ ಎಲ್ಲಿದ್ದಾರೆ?
Branch, second branch, Chandrasekhara branch alle, see Siddhalinga Swami. He sold the property.
ಬರ್ಕೊಡ್ರಿ. Are the counsel for petitioner? Peruse the records. Petitioner is aggrieved by the impugned order, impugned mutation, thereby mutating the name of
In name of seventh respondent.
seventh respondent. ಎಲ್ಲಿ seventh respondent ಎಲ್ಲಿದ್ದಾರೆ?
Is 125, page 125.
ಇರೋದೇ 6 ಜನ.
125.
ಸರ್ ಯಾಕೆ ಪ್ರಿಪರೇಷನ್ ಆಗದೆ ಬರ್ತೀರಾ?
ಇಲ್ಲ, ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಇದೆ.
ಎಲ್ಲಿ seventh respondent?
ಪಿಟಿಷನ್ ಅಲ್ಲಿ
seventh respondent ಎಲ್ಲಿದ್ದಾರೆ?
I'm sorry, sixth respondent. Sixth respondent. I'm sorry.
Sixth respondent, pursuant to sale deed executed by respondent number 5,
Respondent number 5 to 6.
respondent number 5. Pending consideration of partition suit in OS 86 of 2019. Prima facie, this court has noticed that respondent number 6 has purchased pending consideration of a partition suit. Though petitioner assailed the order by filing an appeal under 136(2) and a revision before Deputy Commissioner under 136(3), both the authorities have not taken note of pendency of suit. Pendency of partition suit in OS 86 of 2019. Petitioner asserts that the suitable property is a joint family ancestral property. Petition property is a joint family ancestral property, and therefore respondent number 5 had no authority to sell the land which is subject matter of partition suit. Matter requires consideration. These mutations need to be examined in the light of pendency of partition suit. For the reasons stated supra, the execution and operation of the annexure T,
Annexure T is the order.
ಅದನ್ನ ಕೇಳಬಾರ್ದು.
The impugned order.
ಆ ಮ್ಯೂಟೇಶನ್ ಅನ್ನ ಸ್ಟೇ ಕೇಳಬೇಕು. ನಿಮ್ಮ ರಿವಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Annexure
ಅದನ್ನ
T
ಸ್ಟೇ ಆದ್ರೆ
ಕೇಳ್ಬೇಕು.
ಏನಾಗುತ್ತೆ?
Annexure T by mutate, correct.
ಸರ್
Annexure.
ಈಗ your revision is dismissed.
Yes.
If I stay that order, how it will help you? You have to seek a stay of that mutation.
check screen.
ಯಾವ ಮ್ಯೂಟೇಶನ್? MR ನಂಬರ್ ಏನು?
MR number.
ಆ ಮ್ಯೂಟೇಶನ್ ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ 125.
Page
But you have not challenged that.
Page 125.
The execution and operation of the impugned mutation bearing MR number,
MR number, H27.
huh?
H27.
H27/2022-23. 37 ಇಲ್ವಾ? ಅದೇನು?
37, ಅದು ಅಷ್ಟೇ 37. H37
And
also.
MR H37/2022-23 issued by ಯಾರು? ತಹಶೀಲ್ದಾರ?
ತಹಸೀಲ್ದಾರ್.
Both respondent Tashildar stayed are hereby stayed pending consideration of the caption petition.
Much.
Learned AG is directed to accept notice to respondents 1 to 4. Issue emergent notice to respondents 5 and 6.
Much.
Yes, sir.
Time for Kivita, respondent number 5 in this matter.
Yes, Shivkumar.
Not annexure A and B is questioned. But the petitioners are owners in possession of the property
Yes, sir.
and they have got the registered sale deed standing in their name. But the authorities have not examined any of the documents of title that I have been in possession, and my vendors themselves had effected partition in respect of the properties and then sold the property. I have put up constructions on the property also. But I have got the photographs also. But if my lords could kindly turn to page 292 for a moment. The sketch is produced. The adjudication pertains to 8 guntas in 2/4. 292.
290.
ಇನ್ನೂರ 92.
Yes.
ಕೆಳಗಡೆಗೆ 8 guntas.
2/3 ದಲ್ಲಿ.
2/3 ಅಲ್ಲ, 2/4.
ಅದು 8 guntas.
ಅದು 8 guntas.
Ah.
Now, this is the extent of the properties which was the subject matter where there was alienations made by the then inamdars. And we purchased the properties. But kindly turn to the photographs at 297 onwards. There are houses constructed on the properties.
Yes.
Then there is a conversion in regard to this property. Conversion is effected in page 294.
Yes.
But these properties are converted. Who sells this property?
After conversion, you have purchased after conversion.
After conversion, layout has been formed, sites have been formed, we have sold it. Now, what happens is this. There is a sponsorer for all this litigation. For a moment, who sponsors the litigation? 327. A joint developer, DS Max. He becomes interested in this.
Yes.
Turn to page 329.
Yes.
329. But 331, there is a earlier Inamdar's title. Turn to the third paragraph there. These are all disputes persons which have caused the dispute in this present proceedings. PS and Sharma so-and-so and the family have entered into a registered partition deed on 17/5/2012, which is registered as document number so-and-so before the sub-registrar Jigni Banerghatta Anekal, Bangalore, and allotted a share to his daughter, BM Manjula Sharma, daughter of BSM Sharma, in respect of 2/3, which measures 8 guntas, 2/1, 23 guntas, situated at Bommasandra Attibele, Anekal Taluk, Bangalore, and Bangalore, along with the other properties, and further registered release deed on 17/5/2012, which is executed by BM Manjula Sharma, daughter of BSM Sharma, in favor of BSM Sharma, in respect of survey number 2/1, 23 guntas, situated at Attibele Hobli, so and so. But this Manjula executes the sale deeds in respect of these properties, then approaches the authority to cancel the MR extracts. But the order,
You're tracing title through this lady?
yes, that's the basic title. But
Okay, now-
kindly turn to page
All right,
52.
you are agreed by what?
I'm aggrieved by page 52, Annexure B.
What is that?
The assistant commissioner cancels all this and gives a finding that the properties are of the erstwhile Inamdar. Inamdar was granted this land and there was an order passed by the Inamdar. Accordingly, in view of the Inamdar's order, properties vest with the state. There is a grant order. Accordingly, I transfer the mutations.
Grant in whose favor? The one who had challenged.
In favor of her father, BSM Sharma, and his father.
Yes, sir. You appear for whom?
I am appearing for BSM Sharma, the respondent number 5 in this case. My humble and respectful submission. Lordship may kindly come to page number 62. 62, the impugned order passed by the assistant commissioner is in respect of land in survey number 2/2. Admittedly, the petitioners are claiming under Manjula Sharma. Manjula Sharma is the owner of survey number 2/4. I have prepared a flow title chart. I may be permitted to pass on.
Copy.
ಅವ್ರು ಕೊಡ್ತೀನಿ.
So you admit the partition?
I have no grievance against them. They are claiming title under me. Myself and my father was granted, the extent of land. Lordship, kindly see the title.
Now you appear for BS Sharma.
Yes.
Manjula is daughter.
Manjula Sharma is my daughter.
Yes.
Lordship, kindly see 1 acre 29 guntas was granted to my father, Mr. Venkat Subbaya, under the KVOC Act.
Yes.
Venkat Subbaya. Subsequently, this land is survey number 2 is subdivided as 2/1, 2/2, and 2/3. My father is shown as the owner of survey number 2/1 and 2/3. Myself and my brother have partitioned the property in the year 2011. Myself, my BSM Sharma got 23 guntas in 2/1, 8 guntas in 2/3. Subsequently, kindly come to second page.
Yes.
Myself and my daughter have partitioned the property. In this partition, my daughter got 8 guntas in 2/3, which is subsequently renumbered as 2/4. Kindly come to the next column. My lords. He has transferred in favor of different persons. The petition number 1 to 5 are claiming under Manjula Sharma. Their land is in survey number 2/4. Insofar as 2/4 is concerned, we have no claim whatsoever. My lords, what has happened? My father was granted, my lords, 1 acre 29 guntas. RTC continued in the name of my father for 1 acre 29 guntas till 2007-8. My lords, while mutating the kata in respect of the subdivision, what they did, my lords, the 1 acre 29 guntas is reduced to 1 acre 22 guntas. My lords, I have approached the assistant commissioner for mutation of kata for remaining 7 guntas. Because the persons who are claiming title to the land in survey number 2/2, my lords, were not granted any occupancy rights or regrant was not made in their favor. Therefore, assistant commissioner held, we are entitled to get the kata for remaining 7 guntas. There is no finding whatsoever against the
Where
petition.
do you find it in the sketch that remaining 7 guntas according to you?
I have got the order.
I-
Page 274 may be seen.
So I have the document, I am permitted to place. Sir.
Audit now these buildings, the photographs evidencing existence of buildings. These buildings are found in which survey number?
2/4. I have no claim over that land. I have
But
no
look at the
grievance against
order.
them.
The order affects my rights.
Lordship may kindly come to the impugned order. Lordship may kindly see the operative portion of impugned order.
You are not asserting over
We are not asserting any right over the land in survey number 2/4,
measuring 8 guntas.
measuring 8 guntas.
Now Shivkumar's client has purchased the entire 8 guntas.
Entire 8 guntas.
Why the survey numbers are assigned if it is a converted land? That's where the problem
No,
lies.
no, 2/2 is not converted.
2/3 is converted.
2/3 is converted, subsequently numbered as 2/4. 2/2 is not converted.
So 2/1 is an agricultural land, even now.
Or
See, there are none
2/1
of them are
subsequently
agricultural
converted.
lands.
No, no.
But 292 where you are saying none of these lands are agricultural lands.
Shivkumar, he admits your title, he admits your sale deed, he admits your vendor's title. Now what is the confusion? What protection you
And I
want?
will not make any claim over their property.
Look at the orders, my lord. The orders affects my rights.
Now 62 note
This
there. Kindly
statement,
come to page number
if he had
62.
approached the authority correctly,
Ah.
then things would have been different.
All
Both
right.
the authorities hold otherwise than me.
We'll clarify, Shivkumar. We'll protect your right under the sale deed and under your vendor,
Yes.
Manjula Devi.
Now what they have done
Show me
is,
from 62.
he has hurriedly gone.
Now what's the ambiguity and what is your apprehension?
No, my lord, my
Please.
apprehension is that these orders, they approach the Tahsildar and they want the order to be passed so that I can be dispossessed. Coercive orders and coercive steps are being
No,
taken.
no, he admits on record, on instruction is.
Let him file it in writing, my lord.
Clients
Look
are
at the
present.
orders that are passed.
Lords, my clients are before this court. On instructions, I am making this submission. Will not make any claim over the land in survey number 2/4 on the basis of this
2/4, 2/4.
2/4.
And you also admit their sale deeds.
Yes, my lords. They are claiming
Obtained
under
through
me.
your daughter, Manjula.
Please, my lord. Please, my lords.
I think we can give a quietus and then we can modify this order.
Please.
Now, what's wrong with the order?
So, my lords, order is, Lordship may kindly see the operative portion, 62.
MR 17 ಅದು ಏನದು?
MR 17.
ಅದು ಹಳೇದು.
ನನ್ನ
That's what
ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ
affects us.
ಕೊಟ್ಟಿದ್ದೀನಿ ತಾವು ಲಾಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಾನು ಈಗ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟನಲ್ಲ ಅದ್ರಲ್ಲಿ MR 17
ಈ ಕೊಟ್ರೆ
Page 62.
ಎಲ್ಲಿದೆ ಇನ್ನೊಂದು?
ಅಲ್ಲಿದೆ
ಒಂದ್ ನಿಮಿಷ ನೋಡೋಣ.
ಸರ್ MR ಕೊಟ್ಟಿಲ್ಲ ನನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ MR 17 ತಾವು ಪೇಜ್ ನಂಬರ್ 14
Of your booklet,
ಅದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಸ್ಟಿಚ್ ಮಾಡ್ಬೇಕಾದ್ರೆ MR ನ ಸ್ವಲ್ಪ
page 14.
14
Yes.
MR ಅಲ್ಲಿ 2/1, 2/2, 2/3 ಅದ್ರಲ್ಲಿ 2/1 ವೆಂಕಟ ಸುಬ್ಬಯ್ಯ ನನ್ನ ತಂದೆ ಹೆಸರು, 2/2, 2/3 ವೆಂಕಟ ಸುಬ್ಬಯ್ಯ, 2/2 ಗಂಗಣ್ಣ ತಿಮ್ಮಾರೆಡ್ಡಿ, ಸಂಪಂಗಿ ರಾಮರೆಡ್ಡಿ, ಪಿಲ್ಲಾರೆಡ್ಡಿ ಇವ್ರ ಹೆಸರಲ್ಲಿ ಆಗಿರುವಂತದ್ದು. ಇದು MR 17 is not in the name of Manjula Sharma. ಇದ್ರಲ್ಲಿ 2/2 ಎಂಟೈರ್ ಎಕ್ಸ್ಟೆಂಟ್ ಅವ್ರು ಮಾಡ್ಕೊಂಡ್ರು. ನನ್ 7 ಗುಂಟಾಸ್ ಏನ್ ತಂದೆ ಗ್ರಾಂಟ್ ಆಗಿತ್ತು ಅದ್ರಲ್ಲಿ 7 ಗುಂಟಾಸ್ ನನ್ನ ಹೆಸರು ಬರ್ಬೇಕಾಗಿತ್ತು. ದಟ್ ಈಸ್ ಮೈ ಗ್ರೀವೆನ್ಸ್.
Manjula Devi sub 2/3 now.
2/3 ಮಂಜುಳಾ ಶರ್ಮಾ ಅವ್ರಿಗೆ ನೆಕ್ಸ್ಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಬಂದಿದ್ದು ಅದು ನೆಕ್ಸ್ಟ್ 2/4 ಆಗಿದೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಅವ್ರ ಸೇಲ್ ಡೇಟ್ ಎಲ್ಲ ಪಿಟಿಷನ್ ಸೇಲ್ ಡೇಟ್ಸ್ ಎಲ್ಲ ಸೇಲ್ ಡೇಟ್ ಅಲ್ಲೂ 2/4 ಬರ್ದಿರೋದು.
2/4.
2/4 ನಾನು ಟೈಟಲ್ 4 ಅಲ್ಲೂ ಕೊಟ್ಟಿದ್ದೀನಿ. ಸೇಲ್ ಡೇಟ್ಸ್ ಆರ್ ಅಟ್ ಪೇಜ್ ನಂಬರ್ 63, 72, 81, 93, 113 ಎಲ್ಲ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲೂ 2/4 ಬರ್ದಿರೋದು.
I think we can give a quietus to this. I
Please,
think.
please, my lord, please clarify that will not make any claim over the land in survey number 2/4.
Monday ಮಾಡ್ಬೋದಾ ಶಿವಕುಮಾರ್ sir?
Monday.
Monday will pass a detailed order.
Yes.
Will clarify.
Please, please.
Appreciate. List it in preliminary on top of the list.
Great.
Please.
Grateful.
Yes, Pradeep. ಅವ್ರು ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು ಮಾಡ್ಬೇಕಲ್ಲ
ಇಲ್ಲ ಕನ್ಕ್ಲೂಡ್ ಆಯ್ತು. They have
Oh, yes, you have filed. Only reply. Pradeep, anything more you want to add?
Just a few points, my lord. I'll not take long.
Yes, please, yes.
My lord, say,
File additional synopsis also. If you feel,
please.
if you want, you can file it.
This honorable court
Yes,
expressed and in fact directed the contesting respondents to demonstrate that they will be able to succeed independent of the defense taken by the defendants who had appeared before the trial court, and also independent of the 41 Rule 27 applications now that have been filed by us. But much of the citations that have been relied upon by the respondents pertain to the issue with regarding to a de facto guardian.
there are no pleadings.
There is no pleadings. In all these citations where
Yes,
the matters have been dealt by the Privy Council and also Supreme Court, Honorable Supreme Court. The fact of sale, which had affected the right of the defendants, had come up before the Honorable Court there. The one which
before this court,
in the citations which have been relied upon by the respondents, the fact of sale in those matters was the subject matter.
correct.
In our matter, the sale deed 17/1/1946 did not see the light of the day from 1989, from 1946 till 1989, and also all over through the litigation.
All right, in the judgment cited by the respondents,
Respondents, yes,
the subject matter of the suit is a challenge to the sale.
yes. At least the disputed sale deed was discussed at length. And defendants had an opportunity to attack those sale deed on the grounds that were available to them. Here,
Yes,
here, the sale of the year of the date 1946 never came up before the trial court. And also, even when the matter was remanded, plaintiff did not choose to bring those documents before the trial court.
now,
Now,
Pradeep,
yes, ma'am.
any vague reference while cross-examining or in their evidence, any one sale deed date is reflected in the entire proceedings?
No,
Not
my-
even their sale deed also.
no, my lord.
Original, not even 1946, their one title deed is also not mentioned. Either in the class examination or along with the written statement.
In defendant number 5, in his written statement,
All right, in RTCs, probably there is a reflection of at least sale deed number in one of the RTCs.
my lord, sir, defendant number 18 has filed a written statement where he has mentioned sale deed numbers also.
Or different number 18.
Yes, yes.
At what paragraph?
Defendant number 18. Number 18. ಅಲ್ಲ ಇದು ಕೊಡಿ. Defendant number 18 at paragraph number 10 states how he has acquired the title.
Para 10 of the written statement.
Yes, madam. May I kindly read just a portion of it, madam?
Yes.
This defendant submitted the plaintiff suppressing true facts of the case. This defendant has purchased the property bearing old survey number 45 and after number 56, further at present survey number 56/3, total extent of measurement of 1 acre of land through sale deed dated 27/7/1995, registered in Bangalore North Sub-Registrar Office in volume number dash and dash. Further, this defendant has purchased property bearing old survey number 45, new number 56, extent of measurement 1 acre 1 guntas under the sale deed dated 31/7/95, and also 2 acres 1 guntas under the sale deed dated 31/7/95. So defendant number 18.
Did he mount to the witness box, this defendant?
No, my lord.
He didn't mount. Whether there's a cross-examination on this, there's no cross-examination.
No, he.
All right, but there is, this part of it.
The defendant number 5A to 5C, they have cross-examined. In fact, they have also filed the written statement and they have stated in the written statement that they have acquired the suit property to a certain extent. Defendant number 5.
Defendant number 5.
5.
Whether sale deeds are reflected in written statement filed by defendant number 5.
Yes, defendant number 5 has not mentioned the date of the sale deed, but he has denied the title of the plaintiff.
Or the synopsis code, the report synopsis code. All right, now you refer to these RTCs and
Please, madam.
try to
RTC.
figure out the dates of sale deed in at least in RTCs, in each of the RTCs. Total how many lands?
From exhibit P3.
3 to 8.
P3. The first of the RTC, my lord.
ಅಲ್ಲಿ sale deed ಇದೆಯಾ ಕ್ರಯ ಅಂತ ಇದೆಯಾ?
ಕ್ರಯ, ಹೌದು. ಲಕ್ಷ್ಮಮ್ಮನಿಗೆ ಕ್ರಯ 4 ಎಕರೆ.
ಡೇಟು?
ಡೇಟ್ ಇಲ್ಲ. ಪಕ್ಕದಲ್ಲಿ MR 32 of 62-63.
Oh, that is there.
Mutation entry is there. And again, Srinivas, RR number 144. C. Ramakrishna, RR number 190. MR 11 of 79-70. Lakshmaya bin Nanjappa, Vibhaga. And again at P4, exhibit P4, Lakshmaya bin Dodnanjappa, and there was also a Podi subdivision. ADLR MPR 200 of 86-87.
There is a 40.
Podi.
In which survey number?
Survey number 45.
Exhibit P3.
P4.
Oh, exhibit P4 has undergone subdivision.
Yes. ADLR MPR 200 of 86-87 Rante, Podi Merege. Exhibit P5 also.
Yes.
That is another Podi is also mentioned there. Exhibit P7. The survey number is not seen here. 12 acres, 32 guntas. 12 acres, 32 guntas.
P7?
P7 pertains to
56.
survey number 56.
Ah,
56. Even there, KM Sitappa 3 acres, RR number 646. And there's also entry with respect to a mutation, partition, MR number 11 of 7980, which are much prior to the institution of the suit.
partition is reflected.
Yes.
Yes.
Exhibit P6 is with respect to,
Allah P7L partition is reflected.
yes, my lord, partition.
Exhibit P6?
Exhibit P6, 21 acres, 7 guntas pertains to land item number 2, survey number 55.
Ah,
P6, 55. Here also MR numbers are mentioned. MR number 8 of 6869. And the purchaser's name are also is also entered. Chinnagiriappa, Nagaratnamma, Kamalamma, Sadashivaya bin Paranna, IHC mutation. 1 of 8384. Govindraju, Paranna. Again another.
and the sale deeds are reflected.
My lord, sale deeds dates are not reflected, but the mutation entries and RR numbers are reflected
R.
here.
Yes.
Column number 12.2 does not show the name of the plaintiff or his father anywhere. Now, my lord, if the plaintiff has to succeed, he has to first, they have to first satisfy regarding prayer B. Only if they are able to demonstrate that all the sale deeds that have been executed in favor of the defendants are colorable, nominal, and fraudulent documents, only then plaintiff will be able to succeed in getting a declaration. Now, these sale deeds, I'll not go back to the facts, but these sale deeds have not at all been produced before the court. No material particulars are given. Unless plaintiffs satisfy with respect to prayer B, they cannot succeed. It is immaterial now whether the defendants have pleaded in their written statement. Now, I am filing an application at 4127 and producing the sale deed dated 7146, and they contending that it is a void document. If they have to contend the document as a void transaction, they could have just spelled out in their written plaint that such and such a sale deed was in fact executed by our guardian. The document is a void document, and we need not seek cancellation of that document, and they could have proceeded. That would have, in fact, would have been a proper exercise. That is not done. Their case is simple. 37, my father purchases. We have not sold. My father has not sold. We are still possession of the property. And 89, they just file a suit. That is their simple case. May I kindly pass over this few judgments? I not take your lordship to the entire judgment, only the head note. Or
Yes, sir.
And my lords, another argument was put forth that what was the necessity to sell the entire 52 acres. They went to Malur for good, and retaining a property in Bangalore, that too at Peenya, and going to Malur for good for so many years, that would not have been beneficial to the miners. by the time they would have come back, there would have been no property. So the entire extent was sold to their benefit, and there was an FD that was kept there, and they have utilized that money by purchasing property at exhibit P10. That is the first of the judgment. At head note number 3.
Yes.
Mere mentioning and using the word fraud, fraudulent held is not sufficient to satisfy the test of fraud. A pleading / using the word fraud, fraudulent without any material particulars as required in terms of Order 6 Rule 4 CPC would not tantamount to the pleading of fraud. Considering the pleadings and averments in the suit held, the allegations of fraud were made without any particulars and only with a view to get out of the bar of Section 34. This was under the Surface Act. Now, to get out of the aspect of limitation and also possession, that sale deed was not disclosed. All the transactions that has happened inter se between the defendants. At page number 9. (8.1), page number 9.
Yes.
Similar view has been expressed in Tali Prasad versus Jaiswal, and after considering the decision of the Privy Council at Bharat Dharma Syndicate Limited versus Harsha Chandra, it is held that a litigant who prefers allegation of fraud or other improper conduct must place on record precise and specific details on these charges. Even as per Order 6 Rule 4, in all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, particular shall be stated in the pleading. Similarly, in KC Sharma and Company, it is held that fraud has to be pleaded with necessary particulars. In Ram Singh, it was observed and held by this court that when the suit is barred by any law, the plaintiff cannot be allowed to circumvent that provision by means of clever drafting so as to avoid mention of those circumstances by which the suit is barred by law of limitation. Page number 12. But this is with respect to Section 3 of the Limitation Act. Head note B.
Yes.
Page number 12. Section 3, subclause 1, bar of limitation. Held goes to the root of the matter. If suit, appeal, or application is beyond limitation, court or adjudicating authority has no jurisdiction, power, or authority to entertain the matter and decide it on merits. The court has an independent duty to look into aspect of limitation, even though limitation has not been set up as a defense. Now, with respect to prayer B, Article 58 is applicable. 3 years, as your lordship mentioned. So the first of the sale deed, after the attaining majority, was also executed probably in the year 1960s. And they filed the suit in the year 1989. When prayer number B is barred by limitation, prayer A also does not survive. They can succeed only if they are able to demonstrate that all these documents are fraudulent documents and not otherwise. That's at page number 18. Paragraph number 32 and 33. I'll not read that, my lord. Page number 21.
Yes.
Head note number C.
Yes.
Nature of question held affects jurisdiction of court. Section 3 clearly provides that every suit instituted, appeal preferred, and application made after the prescribed period of limitation, subject to the provisions contained in Section 4 to 24 shall be dismissed, although limitation has not been set up as a defense. A plea of limitation or plea of res judicata in a plea of law which concerns the jurisdiction of the court which tries the proceeding, since a finding on either plea in favor of the party raising would oust jurisdiction of the court. Page number 47.
47.
47. Head note A. Issue of limitation. Duty of trial court to consider if said issue is not raised by parties concerned. Failure of trial court to consider the issue in such case. Effect of right to raise the issue in appeal. Held, it is incumbent upon the trial court to consider the issue of limitation on its own initiative, even if the issue is not raised by the parties concerned. Where the issue of limitation was not raised during the trial by the appellant, state and also the trial court failed to consider that issue on its own initiative, held the said issue could be raised even in appeal, also on successive appeals. The last of the citation at page number 57. This is now, my lords, the question whether he was a de facto guardian or a de jure guardian cannot be looked into at this stage, because the document 17/1/1946 does not reveal anything as to how he was appointed. It just says that he is a guardian. He could also be a court appointed guardian. Probably it is not just mentioned in the sale deed.
Yes.
So if he has to be nomenclated as a de facto guardian, he should be placed in a witness box, and I should be given an opportunity to examine him. If that has to be done, our 41 Rule 27 application is to be allowed. Without going into that, my lords, just assuming that he is a de facto guardian, I'm not admitting, but even if we assume, this decision of the Madras High Court in the year 1925 on almost similar facts, here also the maternal uncle sells the property of the minor. He was a de facto guardian, as referred to by this judgment. The Honorable Court mentioned that a sale deed by a de facto guardian for necessity is not a void document. May I kindly take your lordships to the relevant paragraph. Page number 63. Sorry, Mas. At page number 57, the judgment. The first paragraph. The question in this case is whether an alienation by a de facto guardian is valid under Hindu law. The person in question is the maternal uncle of the plaintiff.
Pradeep, where are you reading?
Page number 57, the first paragraph.
You're reading 57.
Only the first paragraph, and then I'll take your lordship's page number 60.
Yes.
57. The question in this case is whether an alienation by a de facto guardian is valid under Hindu law. The person in question is the maternal uncle of the plaintiff, and of course is neither the natural nor the legal guardian. The district munsif dismissed the suit, which was the claim for a declaration that the alienation made during the minority of the plaintiff did not bind him. The subordinate judge reversed this decision, holding that the alienation made by the maternal uncle was a void transaction. My lord, at least in this case, the minor has approached the court by producing that document and seeking a proper relief. It has been argued at length for the respondents that the de facto guardian is unrecognized in Hindu law. It may be at once said that if there is such a recognition, I am satisfied that the recognition is more or less modern, and possibly to some extent the recognition, if it is legally recognized at all, has come about by necessity. The earliest case, as far as I know, is well known case in Hanuman Prasad Pandey versus Masumad Babui Munraj Noveri, where the lordships of the Privy Council said, upon the third point, it is to be asserted that under Hindu law, the right of a bona fide encumbrancer who has taken from a de facto manager a charge on lands created honestly a de facto manager, the end, my lords.
Yes.
End of a de facto manager, encumbrancer who has taken from a de facto manager a charge on lands created honestly for the purpose of saving the estate or for the benefit of an estate is not affected by want of union of the de facto with the de jure.
Yes.
Yes, ma'am. And in the same page, and my knowledge, to the best of my knowledge, this decision has not been overruled. I have checked that, but at the same page, at page number 58, second paragraph. In Mohanud Mondul versus Nafur Mondul, the grandmother purported to sell minor's estate. The court found that she was a de facto guardian, and relying on Hanuman Prasad Pandey versus Musmat and others, it held that not only might a de facto guardian mortgage, but also sell. Justice Banerjee points out that there may be cases where the sale of a part of minor's estate might be more beneficial to him than a mortgage. So even in this case, the sale of entire 52 acres was probably more beneficial than mortgaging it, since they settled at Malur for good.
Yes.
At page number 63, in the first paragraph, from the last 4 lines, first paragraph, last 4 lines, I am clearly of opinion.
Yes.
I am clearly of the opinion that the right of a de facto guardian to deal with the property of Hindu minor has been recognized by our courts ever since the decision of the Privy Council in Hanuman Prasad Pandey versus others, provided that the alienation was for necessity. I may here state that in the present case, the de facto guardian was the maternal uncle who took charge of the minor after his mother's death. And the evidence of DW1 is to the effect that paternal aunt with whom the minor was for a time not in a position to maintain herself. So far as the Hindu society in South India goes, the maternal uncle is treated as the closest relation of a person next to his father and mother. And at all ceremonies and at which presents are given, it is his that it's first handed over. Now this person, Kempu Shetty, was no intermeddler. He has taken these minors to Malur. They were educated there. Exhibits their SSLC certificate and also other character certificate shows that they were in under the care of their maternal uncle. And also later, plaintiff number 1 has in fact married maternal uncle's daughter only, where also their name is mentioned. So they had a complete custody and they took care of the minors for a very long period. And even in the year 2006, their ration card shows that they were residing at Malu. So this is the law on the aspect of de facto guardian. And because their judgment at page number 17 of their compilation. What is this? Hindu law always recognized de facto guardians. Page number 17.
Page 17 of their compilation.
Of their compilation. Illa, continuation page. Continuation. In
Yes. ಆ ಮೂರಿದೆ ಅದರಲ್ಲಿ ಯಾವ್ದು ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ನೀವು? ಬಿಗ ಬಂಚ Bigger buncha.
Talavarti Pappaya.
At page 17. Yes. Want to go through? Correct. I think you have cited them. I'll go through. I'll go. What, Pradeep, from remand now you have come to dismissal? Huh? You gradually graduated from remand order to now you feel that this he has to be non-suited. All right, good. Yes, sir. Short reply.
Same ಮಾಡಿದ್ರು. Synopsis. ಇದು. Synopsis.
The legal once we are done, one is leave and delay in all the.
I have made a chart in how many years pending in all RFA so that your lordship can, that is the synopsis which.
All right. ಒಂದು ಕೆಲಸ ಮಾಡಿಯಲ್ಲ.
Easy ಆಗುತ್ತೆ ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
Correct. No, you close your argument
Yes.
and then I'll pass orders
Yes.
on interlocutory application.
No, I am seriously objecting because.
Correct.
I will submit my arguments on that also because they say they are not aware, but wakalat and order sheet, whatever we have produced, they show that they are aware of these proceedings from earlier also. They cannot say that now to condone the delay, we are not aware of the proceedings.
Correct. Now I'll note down this, otherwise it will be a confusion.
Yes.
Now, in which all those appeals delays condoned? RFA? This is in time.
In time.
Order. One nimsha. RFA? 9/1/2 of 2015. Here also no delay. Next. 342 of? How much is the delay?
8 years. 8 years.
Close to 8 years.
8 years, close. Yeah, 14 is the judgment, 22 is the appeal.
Close to 8 years.
Yes. Next matter also, 343 of 2020.
Next. It's the same, almost same. Yes. Fourteen. Not yet condoned. Idalli close to 9 years.
Yes, next 23.
Another 9 years.
Yes.
Yes. Incomplete address. So appellant in RFA 14 served through paper publication. Earlier round. Allah, but in first round he was repented by council. Yes. ಈಗ 14 ಅಲ್ಲಿ ಮಾತ್ರ ಡಿಲೇ ಕಂಡು. Yes. Then those connected appeals, there is delay of 10 ವರ್ಷನಾ?
14 to 14, 10 years.
10 to 14 years.
10 to 10 years.
ಎಲ್ಲದ್ರಲ್ಲೂ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ ನೀವು? ಯಾವ್ದು ಯಾವ್ದು ನಿಮ್ದು ಯಾವ್ದು RFA? ಅವೆಲ್ಲ ಬ್ಯಾಚ್ ಅಲ್ಲಿ ಬರುತ್ತಲ್ಲ.
ಅದ್ರೊಳಗೆ ಅಪೀಲ್ ಮೆಮೊ IA ನಾನ್ ಕಂಪ್ಲೇನ್ಸ್ ಅಲ್ಲಿ ಇದೆ, ಇವತ್ತಿಗೂ ಸರ್ವ್ ಮಾಡಿಲ್ಲ. ಅಲ್ಲಿ ನಮಗ್ ಸರ್ವ್ ಮಾಡೇ ಇಲ್ಲ. We have asked several times, but he has addressed arguments already.
ಏನ್ರಿ you can't be
ನಾವು
so
ಕೇಳಿದೀವಿ.
irresponsible.
Now that is
You
the,
are very irresponsible, I'll tell you. What is this?
after addressing, I did not object for it. He has addressed arguments already.
Now I will delink your appeal. I am not going to decide your
In
appeal.
fact, 2 appeals were dismissed because of this.
I'll not decide your appeal. Very unfair.
Now by way of reply, we are
Unfair
here.
conduct. Very unfair conduct, I'll tell you. Kodri, igle kodri. Lawyers complicate unnecessarily. You people complicate all this. It is the 5th or 6th hearing, sir, and you are yet to serve a copy. What is this? ನೀವು ಇವತ್ತು ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ ನಾವು ಕೇಳಿದ್ವಿ, ತಾವು ಹೇಳಿದ್ರಿ ನಿಮಗೆ ಪರಿಚಯ ಇದಾರಲ್ಲ ಕೇಳಿ ಅಂದ್ವಿ. We have asked him.
No, delink, delink. I'll not pass order. No, I can't. I can't. They will make it the ground. What apologies, sir? Right now you go and you get Xerox.
I shall.
Another same ground is there, but he has to.
Only parties, inserting parties, my lord, that's it.
They are all pendent late transfers.
Okay.
Whatever happens to main appeal.
Main appeal ಅಷ್ಟೇ.
Yes.
ಆಯ್ತಾ?
All those appellants got a cause of action to.
Now in
an
those,
appeal.
the transfer is appeals batch. There an application is filed seeking leave in all the cases.
Yes, my lord, yes, yes.
And there is a delay application.
Yes, please. And there is no application for any production of any document. Yes.
ಅಲ್ಲಿ ಪ್ರೊಡಕ್ಷನ್ ಏನು?
ಇಲ್ಲ.
ಎಸ್ ಸರ್, ನಿಮ್ದೇನು?
Yes, we have given a written submission. It's only
Lord, before the
Advert to, my lord, only judgment I shall cite and I shall close it, my lord. Only judgment, my lord.
Quadri, or you have served, at least this judgment is served on him,
My lord, I shall
first
serve,
our quadri.
I shall serve it. My lord, wherein your lordship had put a query with regard to the maintainability of the suit with regard to section 31 of specific relief act, my lord. My lord, they have cited a judgment, my lord, wherein it was stated, my lord, the interpreting the provision, my lord, at para 23, it was cited therein, my lord, which the respondent had referred to, my lord. At para 23, it was,
These kind paragraphs I'll go through.
Please.
You just let me know what are the paragraphs, I'll go through.
please, my lord. In this judgment, my lord, it is clearly,
Citation, please.
citation 2021 4 SCC 786.
All right, only paragraphs. I will go
Please,
through
my lord,
later.
I shall go. My lord, in this judgment, my lord, the Honorable Supreme Court, Constitutional Bench of Honorable Supreme Court has interpreted the specific relief act, my lord, very clearly, my lord. Your lordship may kindly refer to para 17 of the said judgment.
Para 17.
Please, my lord, when it comes to the section 31(1), the important expression used by the legislature is any person against whom a written instrument is void or voidable. An instructive judgment of the full bench of Madras High Court reported in Mupadati Pillai versus Krishnaswamy Pillai involved the determination of section 41 of specific relief act, section 33(1) of the act is the parimateria provision. This judgment after referring to section 41, then referred to section 39 of specific relief act 1893, which is parimateria, the provisions of section 31 of the act. The court then went on to notice the distinction between section 35, which is parimateria provision, to section 27 of the and section 39 of specific relief act as follows. It may be noticed that the above section applies not merely to the case of an instrument which is voidable, but also one that is void. Section 35 provides for the case of rescission of voidable contract. It is evident that section 39 covers not only a case contemplated under section 35, but also wider field. That is a case of void document, which under the law need not be set aside. In an extremely, the next paragraph, in an extremely important paragraph, then set aside the principle behind section 39(1). When it says so, my lord, your lordship may kindly refer to the relevant portion, my lord, para 19, my lord. Para 19.
Yes.
The court then continued its discussion as follows. The provision of section 39 makes it clear that 3 conditions are requisite for exercise of jurisdiction to cancel an instrument. The instrument is void or voidable against the plaintiff. Plaintiff may reasonable apprehend serious injury by the instrument being left outstanding. In the circumstance of the case, the court considers it proper to grant this relief of preventive justice. On the third aspect of the question, the English and American authorities hold that where the document is void, on its face, the court would not exercise its jurisdiction, while it would, if it were not as apparent. In India, it is merely a matter entirely for the discretion of the court. The question that has to be considered depends on the first and second condition as set out above. As principles, one of the potential mischief by the document remaining outstanding, it stands to reason that the executant of the document should be either the plaintiff or a person who can, in certain circumstances, bind him. It is only then it could be said that the instrument is voidable by or void against him. The second aspect of the matter emphasizes that principle, for there can be no apprehension if a mere third party asserting a hostile title creates a document. Thus, relief under section 39 would be granted only in respect of an instrument likely to affect the title of the plaintiff or not of an instrument executed by a stranger to that title. My lord, this para 15 in the said judgment is very essential, my lord. Let us take as an example of trespasser purporting to convey the property in his own right and not in the right of the owner. In such a case, mere cancellation of the document would not remove the cloud occasioned by the assertion of hostile title. As such, a document, even if cancelled, would not remove the assertion of hostile title. In that case, it would be the title that has got to be judicially adjudicated and declared, and the mere cancellation of an instrument would not achieve the object. Section 42 of the Specific Relief Act would apply to such a case. The remedy under section 39 is to remove a cloud upon the title by removing the potential danger, but it does not envisage an adjudication between competing titles. That can relate only to the instrument executed or purported to executed by a party or by any person who can bind him in certain circumstances. It is only in such cases that it can be said there is a cloud on his title and an apprehension that if the instrument is left outstanding, it may be a source of danger. Such cases may arise in the following circumstances. This is very essential. A party executing the document or a principal in respect of a document executed by his agent, or a minor in respect of a document executed by his guardian, de jure or de facto. A reversionary is in respect of a document executed by the holder of an anterior limited estate, a real owner in respect of the document executed by the beneficiary, etc. This right has also been recognized in respect of a forged instrument which could be cancelled by a party on whose behalf it is purported to be executed. In all these cases, there is no question of document by a stranger. The title is the name, but if of a person asserting host title, the source of claim of title is different. It cannot be said that to be void against the plaintiff as term void or voidable implies that but for vitiating a factor, it would be binding on him. That is, he has a party to the contract. My lord, the very essential fact is, my lord, this entire judgment quotes about the action in rem, action in personam. Section 31(1) clearly implies that this is an action in personam, which the court holds that. Your lordship may kindly refer to para 21, last sentence, my lord. Para 21 and 27. The principle behind the section is to protect a party or a person having a derivative title to protect from such party from a prospective misuse of an instrument against him. A reading of section 31(1) then shows that when a written instrument is adjudged void or voidable, the court may then order it to be delivered up to the plaintiff and cancelled in exactly the same way as for rescission of a contract under section 29. Thus, it is clear that the action under section 31(1) strictly an action inter parties or by persons who obtain derivative title from the parties, and thus in personam. Your lordship may kindly concluding part of the judgment is at para 27, my lord. The court concludes by stating, my lord.
Yes.
Judged by these authorities, it is clear that the proceedings under section 31 is with reference to specific persons and not with reference to all who may be concerned with the property underlying the instrument or all the world. Clearly, cancellation of instrument under section 31 is as between the parties to the action and their privies, and not against all persons generally, as an instrument that is cancelled is to be delivered to the plaintiff in the cancellation suit. The judgment delivered under the section 31 does not bind all persons claiming an interest in the property inconsistent with the judgment, even though pronounced in their absence. My lord, in this case, my lord, section 31 is clear, my lord. They have made them as a parties to the present suit, my lord. And they advert to in the pleadings that there is an existence of a document. In view of the fact that, my lord, the action under section 31 is judgment action in personam, my lord. Therefore, my lord, having made me as a party, my lord, the concerned parties as a parties, my lord, it was a duty cast upon the respondent to make them to plead and specifically as that for cancellation of the deed, my lord.
You are defendant number 18, Allah.
Allah, I'm not defendant, my lord. I'm a
31,
subsequent purchaser, my lord. The with regard to maintainability of suit and section application of section
Yes.
31, my lord. With this aspect of the matter, I plead your lordship may kindly allow the appeal.
Yes, sir.
Kindly see the synopsis which just now I have given. I'll not repeat anything, my lord. Whichever is relevant, not by way of reply to reply, only to clear the facts. Written synopsis.
Yes.
There are three synopses, my lord. One is combined return argument. Second one is appeal wise. Third one is the application which are pending chart wise. Now, as per this, in page number 1, the relevant facts which are not narrated or repeated, my lord. Now, kindly see, suit for declaration, no dispute. What are the prayers? What is the pleadings? Insofar as the acquisition of property by Subra Shetty, not in dispute, exhibit P1. P2 is the date of death. P3 is the P3 to 8 RTC and all. Now, kindly see serial number 6. Now, when this is with regard to cause of action, serial number 6.
ಎಲ್ಲಿ ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Synopsis first page.
ಯಾವ ಸಿನಾಪ್ಸಿಸ್?
Written arguments and synopsis. Yes. Now, much was argued that as per exhibit P10, that he was a minor, he had no capacity to purchase one of the property as per that exhibit, that is the sale deed, purchasing of a house. Now, kindly see exhibit P10, which says the earning capacity of both Subrai Shetty as well as Hanmantrai Shetty. They have purchased the shares. Exhibit P10 and 11 are the share certificates.
Yes.
P10 and 11.
ಅದು ನಿಮ್ಮ ರಿಟರ್ನ್ ಸಿನಾಪ್ಸಿಸ್ ಎಲ್ಲ ರೆಫರೆನ್ಸ್ ಇದೆ ಅದು?
Serial number 7 and 8.
7 and 8, correct.
Yes. So, it was argued that they had no financial capacity to buy one of the house, and inference is that 1,400 to it was made to 2,000. Therefore, they have purchased the property. From this document, my lord, that submission is negative. This is not on record, my lord. I am furnishing for the reference. Hanmantrai Shetty was appointed. Kindly come to page number 2. This was not produced, my lord, because they have made a reference. Kindly come to, this is the letter issued by the State Bank of Mysore. That he was working as an employee and on the endorsement. Kindly come to next page, first line. Date of appointment.
57.
Yes, that sale deed as of the year 1959, which they were referring. And that property was purchased, and schedule says that it is situated at Malur. Now, kindly see serial number 9, exhibit P40. The photographs which were produced along with the evidence before the trial court shows the nature and vacancy of the property. Yes.
Vacant land.
Yes, Mila. Therefore, to say that from 1989 only there were so many construction is not correct. Now, kindly come to serial number 15.
Yes.
With regard to their negligence and carelessness, my lord, from 35 years from 1989 till date, that too in the year 2022, when the matter was ready for final argument, they have filed application. In support of that, I have only referred that judgment, important paragraph 2023 SCC online, SC 358. I will give that judgment, my lord. I'll read out the exact the observation. In such circumstances, we have absolutely no hesitation to hold that the original defendants failed to raise sufficient appropriate pleadings in the written statement that they have better right for possession of the suit properties. No amount of proof offered without appropriate pleading would have no relevance. Therefore, everything was argued, whatever has happened prior to 1989 without pleadings and all. If the pleadings were to be there before the trial court would have framed proper issues also. Now, according to my submission, my lord, 1989, 2001 suit was dismissed. They were very happy. Till the time appeal was filed and it was remanded. Even after remand, 2 years were there. Some of the defendants have filed. Not even a single sale deed of their own. Not even 1946. No reference, nothing. And the reference which was just now read out is of the year 1994, which is pendent-alia transfer. Now, kindly see serial number 16, submission number 16. That the main arguments is that proper issues were not framed. one thing is that there is no return statement. If the return statement are there and if the proper issues were not framed, then remedy available under order 14. Because they have not filed return statement, they did not even choose. Therefore, Supreme Court says, if the parties understand and went for a trial, later they cannot turn around and say that proper issues were not framed. I will not read out, I made the marking of the judgment. Now kindly come to 17. Who are the defendant claiming which property? For the easy reference, I have made a 17. Now this is very important, ma'am. The suit schedule properties are totally measuring 52 acres, 22 guntas, and decrease passed in respect of entire properties. However, out of 19 defendants, only defendant number 5, 6, 7, 9, 11 and 13 have filed this appeal. Remaining all the defendants have accepted this decree and they have not come before the trial, this honorable court. Therefore, the extent which they are claiming now, only the appeals which are filed, is only around 8 acres. Now to say that the parties who are not before the court and to set aside the entire decree, which is unsustainable. It is as good as partially setting aside decree and in respect of the person who have not even before this honorable court. Now, in so far as points for consideration, this is already covered by my learned senior.
Now, what about those batch of appeals?
Batch of appeals also.
That covers the entire 52 or it only relates to 8 acres?
That is what I have gone through and I made a chart also. Entire appeals were read out and only sites are there. Even that is considered, it will not come to 15 to 20% of the total extent. If 30-40 sites andru kuda.
50, 80 LI.
Alla ade
100 by 80 LI. We will complete.
Nam complete. Idinna we have taken a lot of effort. Who have filed, under whom they are claiming, what is the extent, and 90% of the transaction which they have now filed are all GPA transfers. And in one of the chart which I have made, one person's Lakshmaya execute GPA in 1992. He dies in 1993. But thereafter, on the basis of GPA, more than 100 transactions have taken place, which is it by Suraj Labs.
Whether it's coupled with interest or it is just a plain.
Normal GPA affidavit agreement by their own pleadings. I have narrated everything in the chart. We have gone through the entire appeal grounds. They only say GPA affidavit agreement. Suraj Lamb case straightly applicable. And that too after the death. The person, the GPA dies with the person, still the so many transactions have taken. Which they have not argued for the, because I have submitted before the sample court that we'll make a chart for easier. Individually we have made, and out of these chart, only these defendants who are before the court are only the persons.
Yes.
Now, page number 3, 4 and 5, my lord, which is already covered by my learned senior counsel. 2020. You put it.
Left out transposition, inordinate dealing, and dispendency.
Yes. On 3 propositions regarding dispendency, lispendency, transposition which he has not argued, but I will assist this honorable court because there were 2 other appeals which were withdrawn, and in the meantime a transposition application is filed in the connected matters.
That application is decided or?
No, not yet decided. That is what we have objected for.
Or the transposition application is filed in which appeal?
343 of 2020.
CPC. There is a judgment which covers the issue. Whenever there is a collusion or abandonment of right under 23 rule 2, then only you can come as a transposition, come as a pro forma party.
What are the details of those appeals which were withdrawn?
Which were withdrawn?
505 of 2023.
Why not?
5 of 2023.
23.
24 of 2023.
And also 24 of?
In those appeals, there was inordinate,
Appeals are withdrawn.
yes. In those appeals, there was inordinate delay. We have submitted the detailed objection with proof that they were aware of the proceedings long back. Therefore, appeals were withdrawn. And immediately the applications are filed simultaneously.
Which is that RFA? Transposition application is filed in RFA?
343 of 2020.
343.
Transposition applications were filed prior to withdrawal.
Huh?
Transposition applications were filed prior to
Oh,
withdrawal.
prior to withdrawal, huh?
Simultaneously. After filing the objection to condonation of delay, my lord, the applications were filed, their later appeals were withdrawn.
Yeah.
Transposition, my lord, which I have just now given, when can be entertained? Two conditions to be satisfied. One is,
Anyway, I'm quite open. I'm not good decide that transposition.
yes,
I'll decide the main matter,
Yes,
then I'll
sir.
say that it's not relevant.
because yes,
I'll withdraw the.
only to show the conduct only, my lord, not it is going to affect the appeal. If they are ready to withdraw.
Sorry, I forgot your name. Mahesh ಅಲ್ಲ ನೀವು?
Yes.
ಮಹೇಶ್ ನಿಮ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಏನ್ರಿ?
No,
ನಿಮ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಹೇಳ್ರಿ. ಬೆಂಗಳೂರಲ್ಲಿ
there are,
ಬೆಂಗಳೂರಲ್ಲಿ 35 ವರ್ಷ ಆದ್ಮೇಲೆ ಒಂದು ದಾವ ಹಾಕ್ತೀರಾ, 35-40 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿ ಡಿಗ್ರಿ ತಗೊಂಡು then you have meddled, you have enriched yourself, partially you have succeeded also,
yes,
and I have to deal with those. So see, look at the conduct,
yes, my lord.
and the lawyer who has drafted, a very cleverly drafted, sir.
Yes.
And look, the court, you need one independent court to deal with all this now.
Yes, my lord.
Just, just imagine,
As an impartial
Mahesh,
submission.
Mahesh, if this court is compelled to remit back, just imagine what is going to happen there. Just imagine.
Again,
You need one designate court to deal with this one list for another 20 years.
yes,
So we'll go by first principles, we'll only examine
the validity of.
whether
and
your
test.
suit in absence of zero defense,
Yes, maintain.
maintainable, whether you are entitled for reliefs that were sought in the plaintiff.
Yes,
First, we'll keep it as simple as that.
yes. Ma'am. As an impartial from out of the.
Don't look
this
at their
matter,
conduct. Your conduct,
because-
if I were to really examine your conduct, and I'm going to
Even
refer to
after-
some of,
Even after remand, my lord,
wait, let Mahesh complete, let Mahesh complete.
even after remand, my lord, 2013 also, two of them have filed return statement, and if one of the deed
Ah,
is come to the light, my lord, either by way of amendment or I would have succeeded or I would have not
Mahesh,
succeeded. my lord.
Mahesh, you should be thankful to all the dependents.
Vice versa is also because
They have
the,
helped you, and you have earned sufficiently.
yes,
You have earned sufficiently. Huh? Based on a decree of medal, they have created third party rights. There are further complications. And these litigations will go for ages now.
Without even proper
Overlapping,
adjudication.
overlapping, there is a sale deed by you. Now we don't know, subject to the judgment that will be rendered by this court, there will be further complications. I thought ಎಲ್ಲ appeal ಅಲ್ಲಿ
Insofar as the written submission, individual appeal wise, I have given the citation to
Right.
cover lispendency, transposition of parties and
ಅವೆಲ್ಲ
inordinate delay.
subject to result.
Yes, yes, ma'am. I have already marked it. I will
Either they
not
will
read it.
succeed,
Yes,
either they will succeed along with dependents,
yes, ma'am.
or their appeals will go.
And in so far as this 30, section 31, which is now read out, this judgment is of the year 2021. The judgment which I have relied upon, which is the latest 2024, and very specifically stated, the word may used in this section, therefore, even in the absence of seeking any cancellation. More particularly, section 31 says cancellation of instrument based on 3 grounds.
No, no, you
23 of the,
no, you can't be called upon to seek cancellation,
yes, my lord.
but you have to seek a declaration. You have to
Not
cite,
bind.
you have to cite the transactions and
Yes.
you have to say that these transactions do not bind on me for these reasons.
Yes, ma'am. That was not in the, yes, ma'am.
The point.
Therefore, even main section,
Because you are not party.
yes, we are not parties.
You need not
Therefore,
seek cancellation.
yes, ma'am. As rightly said by your lordship, the division bench judgment also which I have read out.
Correct.
Yes,
My lord, moreover, the judgment which I have cited is a constitutional bench judgment, my lord.
ನೋಡಿದೆ ನಾನು ನೋಡಿದ್ದೀನಿ. I have read the judgment already. Mahesh,
yes.
Mahesh, I am going to allow all those delay applications. Your objections are there, no?
Delay application,
ಇದು ಇಲ್ಲಿ ಬರ್ಕೋಬೇಕು ಒಂದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ದಿ ಕೌನ್ಸಿಲ್ಸ್ ಆನ್ ರೆಕಾರ್ಡ್
in that judgment which I have relied upon, if one of the appeal delay is condoned, the other party with the same challenging the very same judgment cannot claim the delay if it is beyond it. ಆ judgment
ನಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಂತೂ ಡಿಲೇ ನಾವು ನೋಡಲ್ಲ, ಮೆರಿಟ್ ಇದ್ರೆ ನಾವು
30
ನೋಡೋದೇ ಇಲ್ಲ.
12 years ago.
ನಾವು ನೋಡೋದೇ ಇಲ್ಲ, ಪ್ರಶ್ನೆ ಇಲ್ಲ.
Leave it to
And that is more, see, these appeals are offshoot. They
Yes.
are hinging, they rather hinge on
rights.
just one branch on which they are complete. These appeals are offshoot. They depend on what we decide in these appeals. Barcode. In RFA, 14 of 2023, there is inordinate delay of 9 years, close to 9 years. The plaintiffs have filed detailed objections to the delay application. And there is a serious contest. And there is a serious contest to this application filed under Section 5 of Limitation Act. So, delay in RFA 14 of 23 is found to be inordinate. This court needs to examine. This court is compelled to take cognizance of the orders passed in connected appeals where a delay of close to 8 years was condoned in RFA 342 of 2022. Next part, this court has to consciously bear in mind that the appeal under Section 96 is a statutory appeal. This court under Section 96, being a fact-finding authority, final fact-finding authority, has to decide the property rights of the party to the appeal when substantial rights are involved in immovable properties. Come on, time and again, Honorable Apex Court and this court have held that, have consistently held that liberal approach needs to be exercised in such cases, while main thrust should be on adjudication of the rights of the parties on merits rather than adopting hyper-technical approach. Having regard to the fact that this court has adopted a very lenient approach and inordinate delays condoned in connected appeals, this court is of the view that appellant in RFA 14 of 23 on parity is entitled for benefit and protection at the hands of this court to enable him to prosecute his appeal on merits. In the interest of justice, this court is of the view that this is a fit case to condone inordinate delay of so and so years, subject to appellant, yaru 14 ಅಲ್ಲಿ ಯಾರು apparable, subject to appellant depositing a cost of 2,500 payable to advocates class fund. ಅದ್ರಲ್ಲೂ ಎಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕೆಲ್ಲ ಲೀವ್ ಕೊಟ್ರೆ ಪ್ರದೀಪ್ ಹೌದು. Tell me, I'll not impose a cost of 2,500. You tell me. No, you tell me. ಹೋಗ್ಲ್ರಿ ಕ್ಲರ್ಕ್ ಫ್ರೆಂಡ್ ಹೋಗ್ಲ್ರಿ ಒಂದ್ ಸ್ವಲ್ಪ. Only lawyers will not make fortune.
For a very nominal amount, those appeals are fine.
I know they are all individual purchases. ಅಷ್ಟು ಕೊಡ್ಲೇಬೇಕು. They have to be put to terms to grant leave. ಎಷ್ಟು ಪ್ರತಿ ಅಪೀಲ್ ಅಲ್ಲಿ ಎಷ್ಟು
Few of them are very poor people. Few of them are very poor people.
ಪೋರ್ ಬೆಂಗಳೂರಲ್ಲಿ ಪೋರ್ ಏನು ಈಗಿನ ಕಾಲದಲ್ಲಿ 500,000 ಏನ್ ಪೋರ್ ರೀ. 1,00,000 ಮೇಲೆ ಅಂದ್ರೆ ಪೋರು BPL ನೋಡಲ್ಲ. ಎಲ್ಲ ಲೀವ್ ಅಂಡ್ ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಎರಡು ಸೇರಿ 1,000.
500.
ಅಲ್ಲ 500 ಲೀವ್ ಅಂಡ್ ಡಿಲೇ ಎರಡು ಸೇರಿ 500 ಕಮ್ಮಿ ಆಗತ್ತೆ. ಎಷ್ಟು ಅವರು 1,000 ಅಂತ
Combined both of the applications 500 would be proper.
500 ಬ್ಯಾಚ್ ಅಲ್ಲಿ
In 8.51 in the 20 appeals, Srinivas Rao is not even appearing. Non-compliance of office objection alle ide.
ಕರೆಕ್ಟ್ ಮಹೇಶ್.
Alla, we don't.
It all depends.
No. That is what. That is what. If he is also not appearing in which appeal.
ನೀವು it's your responsibility. ಯಾರವರು?
ನಾನು ಹೇಳ್ತೀನಿ.
You know him?
I know.
Why is not appearing?
At least he should appear and make submission to that effect. It is all.
They have engaged Pradeep Mahesh.
ಅದು ಅಷ್ಟೇ ಹೇಳ್ಬಿಟ್ರೆ ಸಾಕು. 851 ಇಂದ 860
ಅವ್ರು ಬಂದೇ ಅಲ್ವಾ ಮಹೇಶ್?
ಬಂದೇ ಇಲ್ಲ. We thought that he is also Srinivas.
Put a word.
Put a word ಅಲ್ಲ.
He is also
I can't
Srinivas.
decide those all appeals. Why is not appearing? What's his name?
Srinivas Rao CH.
I thought he is also Srinivas. He is only that, but after asking, he
You
said
know
he
him?
is different.
He has spoken to me. I'll just.
What's wrong with him? We'll refer his name to bar council. ಏನ್ರಿ ಅಪೀಲ್ ಎಲ್ಲ ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟು ಬರಲ್ಲ ಕೋರ್ಟಿಗೆ. You ask him to come at 2:30. ಆ ಬ್ಯಾಚ್ ಅಲ್ಲಿ ಮಧ್ಯಾಹ್ನ ಒಂದು ಫಾರ್ಮಲ್ ಆರ್ಡರ್ ಮಾಡುತ್ತೆ.
ಆಯ್ತು.
ಇದ್ರಲ್ಲಿ ಕಂಟ್ರೋಲ್ ಅಂತ ಕಂಡು ಪಾಸ್ವರ್ಡ್.
Just one submission. In all of this appeal, 52 acres, there is no record available to correspond each of their extents. So all the defendants have a common ground. 41 rule 4, each of the defendant.
Will not see. Mahesh has got a very important point. He has to be appreciated the manner in which he has prepared his response to your appeal. A very valid ground, but I will answer that also.
Yes.
Subject matter is whether this plaint is maintainable in the present form. So extent may not be of consequence, but I have to answer his question.
Yes.
I'll answer.
Assisted.
Pass over and come
Yes.
back. ಇದೆಲ್ಲ ರಿಸರ್ವ್, ಮೇನ್ ಮ್ಯಾಟ್ರಸ್ ಎಲ್ಲ ರಿಸರ್ವ್. ಈ ಬ್ಯಾಚ್ ಗಳ ಮಧ್ಯಾಹ್ನ
2:30.
ಅದೆಲ್ಲ ಕಂಪ್ಲೀಟ್ ಬ್ಯಾಚ್ ಮಧ್ಯಾಹ್ನ. ವಿಲ್ ಕನ್ಸಿಡರ್, ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಆನ್ ಲೀವ್ ಅಂಡ್ ಡಿಲೇ.
No, sir, on the 17 of the appeals are not here, madam.
Is list ಕೊಡ್ತಾ ಇದೆ. List
Not connected.
List we have. Maybe. After that he has filed while arguing the matter. ಆಯ್ತು ಲಿಸ್ಟ್ ತಮ್ಮ ರೆಫರೆನ್ಸ್ ಇದೆ.
ಅದ್ರಲ್ಲಿ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಹೋಗಿ ಅಲ್ವಾ ತಗೊಂಡೆ?
ಅದು ಪುಟಪ್ಪೇ ಆಗಿಲ್ಲ.
ಪುಟಪ್ ಆಗಿ
I'll take notice.
ತಗೋ.
Yes.
ಇದಷ್ಟು ಮಾಡಿ ಬೇಕಾದ್ರೆ ಅದನ್ನ ಟ್ಯೂಸ್ಡೇ ಹಾಕೊಳ್ಳೋಣ. ಅದನ್ನೆಲ್ಲ ಟ್ಯೂಸ್ಡೇ ಹಾಕೊಳ್ಳೋಣ.
It was not connected to this batch matters.
They are not
They
connected.
were not connected.
ಇದನ್ನ ಮಂಡೆ ಹಾಕಿ.
ಇನ್ಯಾವ್ದಾದ್ರು
ಮಂಡೆ ನಮ್ಮ
ಅಷ್ಟೇ ಇರ್ಲಿಲ್ಲ. ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದು ಅಷ್ಟೇ, ಆದ್ಮೇಲೆ add ಮಾಡಿ.
Those matters will be listed on Monday.
Please.
Yes. Lordship may direct me to accept notice for responding.
ಅದಲ್ಲಿ ಮಂಡೆ
Common, yes. Two 30.
Yes, sir, 2:30, Pradeep.
A previous counsel is asking me to, he has filed retirement memo, still his name is, he has asked me to delete. First ಅಲ್ಲಿ ಬಂದಿದೆ ಅವ್ರು
ಆಯ್ತು.
ಹೇಳಿದ್ರು.
ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಾ ನೋಡಿ.
ಆಯ್ತು.
ಎಸ್ ಎಸ್ ಸರ್.
Yes.
ಅದಿದು ಪ್ರಸನ್ನ ಕುಮಾರ್ ಆಮೇಲೆ ನಿತೀಶಿದಾರ ಇಲ್ಲಿ ಬಂದಿದಾರ. ಪ್ರಸನ್ನ ಕುಮಾರ್ ಆಮೇಲೆ ಇವ್ರದ್ದು ಆದೇಶ ಇದೆ ಸೀರಿಯಲ್ ನಂಬರ್. That is substantially hard. ನಿಮ್ದು your right to comments or what? ಇದ್ರಲ್ಲಿ
Last time ತಾವು argument ಕೇಳಿದ್ರಿ ನೀವು, ಕೇಳ್ಬಿಟ್ಟು ಸುರಾನ ಅವರೇನೋ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಕರೆಕ್ಟ್.
ಆ cases.
ಆಗಲ್ಲ ಬಿಡಿ.
And even
Got too many partnered matters in. ಆಗಲ್ಲ.
short issue ಮಾಡಿ. ಅವರು ರೆಡಿ.
ಶಾರ್ಟ್ ಇಶ್ಯೂ ಏನಿಲ್ಲ ಬಟ್
List it immediately after vacation.
My lord, so far as 23A, I have summons, my lord, I file it in the.
File it in the office.
In the meantime. So far 24, my lord, 20, respondent 24, even he has expired and I have filed an application to bring the legal aids on record.
Whether they listed today,
Yes, it is listed today.
you have to take notice.
I mean, at the order illa under hand summons.
No, I think you want to take hand summons there also. No, you have to take both, court notice and hand summons. ಎರಡು ತಗೊಳ್ಳಿ.
ತಗೊಂಡಿದ್ದೀನಿ, ಇನ್ನ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ.
ಇನ್ನೂ ಆಗಿಲ್ಲ. ಅವೇಟ್ ಅಂತ ಹೇಳೋಣ ಬಿಡಿ. ಆಲ್ರೈಟ್. ಒಂದ್ ಡೇಟ್ ಕೊಟ್ಬಿಡೋಣ, ದಿಸ್ ನೋಡೋಣ. ಲಿಸ್ಟ್ ಇಟ್ ಒಂದ್ ಡೇಟ್ ಕೊಡ್ರಿ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಯಾಕಂದ್ರೆ ಕನೆಕ್ಟೆಡ್ ಮಾಡ್ರಲ್ಲ ಅವರು ಹ್ಯಾಂಡ್ ಸಮ್ಮನ್ಸ್ ತಗೊಂಡು ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
ಎಸ್ ನೋಡೋಣ, ಡೇಟ್ ಕೊಡ್ರಿ ಒಂದು. ಎಸ್ ಸರ್. ಹಾ Till number 10.
For the respondents, my lord.
ಕಲ್ಯಾಣ್
Right,
ಭದ್ರಾಜ್
My lord, I request
Retired
for a
ಆಗಿ-
passover.
Passover.
He's in the other court hall, my lord. He's addressing the arguments. I request for a passover.
All right. ಏನಾಯ್ತಾ ಸಿಟ್ಟಲ್ ಆಯ್ತು?
ಸೆಟ್ಲ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಕೇಳಿದೆ ನಾನು. ಇಲ್ಲ ಇದ್ರಿ
He's in another court hall. He's in the next court hall.
Okay, we'll pass over, we'll see it at 2:30, sir.
ಅಲ್ಲ ನಂಗೆ 2:30 ಆಯ್ತು ನೋಡೋಣ. ಐ ವಿಲ್ ಟ್ರೈ ಟು
Yes.
7 ಅವ್ರಲ್ಲ ಶುರು ಮಾಡ್ಲಿ, ನಾನು ಅಕಸ್ಮಾತ್ ಇದ್ರೆ I have other two
Okay,
matters.
ಅದ್ ನೋಡೋಣ ಸರ್, ಇವತ್ತು ಆಗತ್ತಿಲ್ಲ ನೋಡೋಣ. Some parted matter.
ಇದು ಪಾರ್ಟ್ ಮಾಡಿದ್ವಿ.
ಇದು parted ಇದೆಯಲ್ಲ?
ತಾವು ಕೇಳಿದ್ದೀರಿ.
We'll hear it. I have substantially heard it.
ಆಯ್ತು.
All right, pass over.
Judgment.
11. Yes, sir.
The synopsis of the case is in brief. The food for specific.
Wait a minute, I have prepared notes. Let me go through the notes.
I just wanted to read one.
Synopsis on file ಆಗಿದೆ.
ಆಗಿದೆ ನಾವೆಲ್ಲ ಮಾಡಿದ್ವಿ.
3823.
ನೀವು ಇರ್ಲಿಲ್ಲ ಅವ್ರು ಹಿಂದಿನ ಕೊಟ್ಟಿರೋ ನಿಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ. ಕೊಡ್ತೀನಿ ಮಧ್ಯಾಹ್ನ ಬೇಕಾದ್ರೆ ನಿಮ್ಗೆ.
I think you stopped where you made a submission that dependents 4 and 5 have put up a construction. They made a statement that it is not by them.
So far as I know, it's a temporary construction, not a permanent construction. And there is a construction subsequent to the filing of the suit, according to me. And in fact, an application was filed for an order of injunction restraining them from putting up a construction. This court has also granted it. Now, your lordship may kindly see, the learned judge's findings are, the trial court finding is that I have not proved the ready and willingness, that I didn't have the balance of self-consideration. The fourth and fifth defendants are the bona fide purchasers, pendant light purchasers are held to be bona fide purchasers.
There is a finding that they are bona fide purchasers.
Yes, bona fide purchaser. And the defendant's claim is.
Agreement is proved.
Agreement, everything is admitted.
The readiness and willingness, and they are held to be bona fide purchasers.
That's all. The defense of the defendants were the vendors are that I did not have a funds. So I asked them to return the amount. They returned the amount, the agreement, the original agreement was handed over to them. The defense of the original vendor, that's the 1 to 3, is that I did not have enough funds. So I requested, please give me back my money. I will cancel the agreement. Accordingly, they came to the defendant's first defendant's brother came to my office. He is calculated that the 2,05,000 is the amount you have paid. 50,000 is the interest. 2,55,000 he paid it to me and took back the original agreement. That agreement, they produce it along with the written statement saying this is the agreement that was entered into. The court, after hearing while dictating the judgment, sent the records to the FSL to find out whether the document produced by the defendants 1 to 3, which according to them is the original agreement, is an agreement.
You have the cancellation.
Cancellation agreement.
That is held against them.
That was held against them and in prosecution was instituted against them under 340. Now, the learned judge also entertains some confusion which I am unable to comprehend. He says, the agreement, you are an advocate, the agreement is one-sided. You have no right to institute the suit at all. I don't know where he gets it. Anyway, that's the finding. On that ground also, your lordship may kindly see the para 14 of the judgment. In the 14, the judgment of the at page 272. At page 272 of the paper book and page 25 of the internal page of the judgment. I mean, I am unable to comprehend how did he arrive at this conclusion. Para 14, your lordship got it?
Yes.
Apart from that, on perusal of exhibit P1, the default clause, which shows the defendant has to approach the court for specific performance of a contract in failure of the terms of the agreement by the plaintiff. In my considered opinion, the default clause made by the plaintiff himself being an advocate, the terms of the agreement was one-sided and it is in his favor that cannot be acceptable.
Whether that was complained by the defendants?
No, no plea. No plea. It's not even argued before the court. Even if it is taken into consideration, as per the default clause, the plaintiff cannot approach the court for a specific performance, specific relief. Therefore, the plaintiff is not entitled for the relief of specific performance of a contract. However, the defendant has failed to prove the termination of the contract and also failed to prove the refund of the advance amount, and therefore the plaintiff is entitled for refund of the earnest money from defendants 1 to 3 along with interest, hence. So he says, I have no right to institute a suit at all.
Yes.
I mean, I don't know what is the confusion that prevailed upon the learned judge's mind. I am unable to understand. If there is a breach, if the parties are have no right to approach the court, where else they can get it decided?
Where he says that I cannot approach the court.
This is what your lordship may kindly see.
Noted.
After about 6 lines,
Yes,
even if it is taken into
Yes, sir.
consideration, as per the default clause, the plaintiff cannot approach the court for specific relief. Therefore, the plaintiff is not entitled for the relief of specific performance. He holds clearly that I cannot come to the court. It's on that ground I am also not entitled to the relief of specific performance.
Yes.
So I think this particular observation of the learned judge is patently erroneous. It doesn't call for a wider discussion about this subject. Because in case of a breach, a party has to go to the court, has to approach the court. He says you have no right to come to the court is patently erroneous, which cannot be accepted.
Yes.
Now, the second aspect, the learned judge feels it, the plea of the defendant that they admit all amounts except the amount received on 29,595. Your lordship may turn to the agreement, exhibit P1 at page 96. Endorsements are made. Page 96, your lordship may kindly see.
25,9.
25,9.
1,50,000.
This particular amount has not been paid. That's the defense of the defendants. And that is accepted by the court. This amount, he says, is interpolated. The learned says it's interpolated. So you have not proved the payment of
D1, sir. D1.
ಏನಿದು page 200?
Endorsement made on the agreement. Original agreement, good agreement. Good agreement, I got it to the court, notice in the court that even the endorsement is there. He said, I had obtained the xerox copy of it. That shows that endorsement is just for interpreted by the applicant. By cross-examination of license pertaining this, I said, I have suggested the things that you have taken the xerox and removing these entries.
Yes, what's his answer?
At page 57, the license pertaining this, at page 57, cross-examination that you can one.
He's examined as DW1,
Yes, BW1.
page,
Page relevant thing is a very fact that you know.
yes.
May I read that to the court coming on procedural?
Yes. Yes, sir.
Now, I have seen the previous show to me, appearing at on video, they are not. This is a myself and my great concern. One, in Malaysia and Ashok Naidu have signed agreement as people as attesting witnesses. The legal agreement is attested between two witnesses. One is Malaysia and Ashok Naidu. It is true that the signature of the witness of people are not taken in the Xerox copy. The signature of the witness are not there. It is not to present that I got the Xerox of the agreement and we were excluding the signature of the witness. It is not to present that I also got Xerox
All right, you can bank on only that admission where he says his signatures of witnesses are also missing.
Yes.
So that is relevant.
Part of this, according to them, according to me, on 29/5/95, I paid 1,50,000.
Yes.
According to the defendant, this will not be for a moment, I accepted. And they returned amount to me on 21/5/1995, the whole amount. For this prior to the last. They paid to that 55,000. Took back the one. Let us see the notice. Before I just issue a note. That notice. In that notice, I have taken the. So the conduct of the party is prior to 6 months to transaction is paid amount and it is should be not a response. In any man who feels who according to the rules to cancel having paid amount. Who is not accept those who are looking for the past, we have paid that. Now, what is the evidence? Those others do that.
Already you referred to your legal notice marked as exhibit.
It is the notice. Article 99. The third notice was sent under the certificate of posting by courier and by register. Certificate of posting is that it will be more.
Yes.
Three filing the acknowledgement by the person as far as sent by courier. The register posting register is a future remember. When you turn to the last examination on this aspect, because I just want to lay down easily.
Courier is accepted
He says that he admits there is single notice.
through courier.
He admits. When I
Yes.
asked him, he admits it.
Alright, exhibit P5 is courier.
When you turn to the cross-examination, the first defendant,
Page,
58.
yes. Yes.
I have not received any notice from the plaintiff. The witness states that they have received the notice sent by the plaintiff who is advocate. I have not given his reply to send the notice. Apart from who, this is acknowledgements by the plaintiff, the defendant also admits. And his conduct of not repaying the notice belies his contention that he has not received 1,50,000 and that he has cancelled the agreement by paying to.
Yes.
Now, so far as the evidence regard to 255, he says, I did not happen. I did not happen. So I requested my brother to pay the 2,55,000 rupees. My brother went to the office of the change it. Of course, he said, okay, he put 2,05,000 is the amount that I have paid. 50,000 is the interest, 2,55,000 is the note. You paid it with cash in my hand. I returned it. Both of them. And the both cross-examination, he admits the defendant admits that he did not accompany.
He did not. accompany his brother for cancellation. His brother alone went. And he does not have the money to pay the amount. The transaction was with defendant number one. He says a brother went and got it cancelled. Now he says my brother went there alone. The person and said, okay, I don't have money to pay the balance of the same cancellation. So return the amount, they return the amount in the month of May 95. Yes. Now, to show that the entire report is not so fast. Page 57. Yes. You have to first, second line from the top. The second agreement was kept by another. You have to receive the amount from me, it was paid back to the date. There is no advancement on the agreement returned by the plaintiff for having cancelled the said agreement. Since the plaintiff has received that amount. Now, I see the signature showed to be likely legal. They are back in the last time we come to page 56 and forward. Page 55, at about 10 lines in the bottom. Yes, from bottom, when my brother gave Jairam a Daypal in amount submitted on my behalf. When my brother demanded to plaintiff for insurance in the receipt of the, for having received the amount, at that time the plaintiff disclosed before it, stating that he had handed over the record, I will not say. An amount of 2,000 was paid to the plaintiff. My brother had paid the said amount out of the amount received by him by sale of the site and also out of amount earned by him from business. I have not prepaid any remarks to show that my brother has paid the amount to the plaintiff. I have not prepared any remarks to show that my brother was having that amount to me. When my brother paid the amount to the plaintiff, myself or wife, myself are not present. All the three evidence. It is true that on the basis of the statement made by the brother for having paid the amount to the plaintiff, I impose the report stating that my brother has paid amount to the plaintiff. It is not true to suggest that brother has not at all paid the amount, any amount to the plaintiff at any point of time close to terminate the agreement. So, he does not have a contact information that he did not have it, he asked his brother told him that I paid brother to the agreement. Now let us look into the DW2 brother. Who is supposed to update on to me? Let us see the cross examination of the brother. Cross examination is passive basis. In fact, yes. I was not present during the
transaction between the patient and my vendor is plus 1. I do not know constantly about the amount paid by the patient to the defendant for 1. I take to the from the patient to my vendor to the defendant for 1 after transaction. It is true that my brother friend need to the patient to inquire about the transaction. I met the candidate in his office in Guardianship, but I do not know the date on which I met him. On inquiry with the candidate, he has told me that he was unable to accumulate the money for the payment of the sale consideration. Hence, he has requested to return the advance amount. I am having time to doing manufacturing business of it. I am not an income tax assessee. I do not go really record to prove that I was holding 2,55,000 on 25,995. That is the rate the book of the city. There is no receipt to show that he had returned amount of 2,55,000 to the trade. I do not have any document to show that actually is that amount to be paid by me. I received the said amount to the defendant of Baba. Though the evidence has taken place somewhere in the after 10 years, 2005 the cross-examination. He has not had the record to show that the amount is reported by his brother to him. Incorrect today, I did not pay 2,55,000 to pay this. It is incorrect to say that it is created by me and given to the defendant in order to cheat my brother. But the exhibit P2 was $100 given by the plaintiff. It is incorrect to say that the exhibit P2 is not the document entered into the plaintiff and the defendant of one. It is incorrect to say that the plaintiff was having sufficient money to pay the balance. If the government says pick the box, I do not accept it and reject the claim of having. Now, the last question that I now, except the 1,50,000, all amounts paid by the man being paid by the defendant, he goes to the further extent of saying, whenever after money he gives, even 5,000 rupees when you ask it, now, according to me, 3,05,000, 3,55,000, 1,55,000, what's supposed to be the balance? I have produced the passport. Exhibit P2. 1,30,000.
They have gone through, ನೋಡಿದ್ದೀನಿ ನಾನು. P2. Page.
Page 98.
Yes, sir.
Other 28, 25, okay. So that is 1,30,000, page 922. As on 31/12/1995, the last year, I had balance of 2,60,246.
Balance of?
31/12/1995. 2,63,245. I had the balance.
2,63,000 ಎಲ್ಲಿದೆ ಅದು?
After the day, after the 2,68,372.
2,68,000.
I got that. Then 14,60 was there, 31/12/95 was there. The amount to deposit on the school there, I can balance that statement now. Was at the town, 1,30,821. The second rating is 1,98,000. At my deposit is so much money, 1,98,000. Then I deposit to 1,50,000 rupees. So 2,69,531. Balance has been struck. So, as on 31/1995.
Yes.
I had the amount.
From where you collect the date, 31/12. And Xerox copy of sale deed display.
That they have not denied that you can't have a problem. They only said they are not aware. That means so, sir. That's everything I have to do is.
A Xerox copy is marked, that copy is marked as exhibit P13. It's a residential house or site?
For 3,50,000.
3,50,000.
Actually, 173.
Yes.
The property was sold by me on 10/7/1995.
Ten, 7/1995.
And the 3,50,000 is reflected at page 173. I have a house
Yes.
So, I had the balance. From May to December 1995. The probability of the plaintiff's contention that I had no belief does not fit into the picture, because whenever he asked me again, he wanted to perform the marriage. He wanted to perform, first he performed the marriage of the second offer. Like he asked me again, we are good. Then it was done to marriage. Then I said, having performed two marriages in a gap of 1 or 2 months. Probably he asked me one action people. I get it. It looks logical and accurate. Not only in the light of the environment, but also in the fact that it does not relate to this point. So, my agreement is to the extent that I had paid in that 55. And the balance I had filed the passport. I also come to the operative, I had filed the also. The government said 1,30,000 he needs to do 30,000 in this one day. 1,30,000 rupees only he saw it and says, because he was under the impression probably that the agreement was in agreement. Contract has been completed. So as on date, as on the date of enter the date, you did not have, you had only 30,000. Besides, I had already negotiated, I had told it, I have to be, I had potential to legalize to get the agreement. There is nobody who would support that I have the money. If I am capable of the potential to raise the money, that is readiness. A big, for example, a big business may not have balance, but at one stroke they can get 1 to 5%. The potential of money. I have a practicing it, and I had that. I mean, this money I had it. And I had a property which I had agreed to sell it because I wanted to shift it value get it to the education because the value was posted to the domain of some particular class of people who wanted to stay in them. He had a money, he had a house in English or not, just about 4 kilometers. Very uncomfortable, he wanted to come here.
Yes.
The entire conduct of the state is in admitting all the transactions except the statement. So that I will always, in fact, himself says clearly, categorically, in the court to the process normally, whenever I report that money, it is the limited comes to the conclusion, apart from that, we don't have to. You are supposed to pay the bank duty. But the property is not the as we do not, we can accept the back. The remaining amount, about 3 lakhs, have to be paid to the bank. Yes, I did not pay the bank. Why I did not pay the bank? He could pay different income than this, my second document. About my whom they are married. Please give me. Please, let's see.
All right, now what's the cross examination on purchaser? I was not informed.
He said, I was not informed at all. I am not bona fide. That's all. Because his evidence does not have any weightage in the fact that it is not choose to make any employee's reasonable. He then the defendant admit after issue of the note after issue of the summons from the court yesterday. And he conveniently supported the other. I did not inform the proposed what yes, sir. The beneficiary, the more maximum beneficiary is the vendor. He collected 3,55,000, 3,55,000 from me. He collected 5,10,000. Okay. He at the time of argument, he submitted files for more seeking retirement of the help from the defendants. The court having voted permission to retire. Because the purchasers after the summons issue a notice to him, saying that you are valid so and so. That notice is returned. He just returned. Now, put the court say under the subject and dependency there. The court provided there.
The short point, 19(1)A ಬರಲ್ಲ, 19(1)A ಬರಲ್ಲ. Section.
I don't want to read more issue to the top of the line to the last to say what is. Now the Supreme Court is out there. The court purchaser private direction not intentionally.
ಬರಲ್ಲ ಅದು. There's a distinction between 19(1)A and section 52. Not all.
Now, the original vendors are not going to go to difficulties.
Now by, in view of later judgment, a pendant light purchaser or a subsequent purchaser at the most can contest this appeal and try to substantiate that you were not ready and willing. And to that limited extent, he can argue. I will step into the shoes of vendor. ಅದು ಹಳೇದಾಯ್ತು, ಹೊಸದೇನ್ ಹೇಳುತ್ತೆ ಈಗ? ಇಲ್ಲ, ಅದು ಹೋಯ್ತು ಈಗ. No, what happens because a vendor may wash off his hands. He may not contest. So he can't take away that right. To limited extent, he may step into the shoes and he may try to substantiate that your suit has to be non-suited only on the ground of readiness and willingness. ಈಗ ಅದಷ್ಟೇ ನೋಡ್ಬೇಕೀಗ. Because your agreement is proved now. Reappreciation only to find out whether that 1,50,000 is paid, then finding on readiness and willingness. ಅಷ್ಟೇ ಈಗ. Yes, sir.
Does not use the benefit of
No.
because he intended to cheat them. And in fact, the notice issued by them to the defendant was something that they have cheated us. That notice is here to the student.
Is it marked? Is it part of record? Then you said that.
Exhibit D4B.
Legal notice by defendant number 3 or 4 or both? ಅದೇ ಯಾರು 3 and 4 ಪರ್ಚೇಸಸ್ ಯಾರು?
4 and 5.
Yes. Yes, para 5. Para 5 of the notice at page 241. Yes. And who are not aware of any of the family restrictions, you are treating my client, supposing the material information fact, thereby having the eligible under section 420 of the penal code. And also your commitment breach of trust for which offenses you are liable to be commitment and my client intend to start with complaint against the Against litigation is has arisen in the schedule property as undertaken in the same date 27/8/97 you are become liable to settle the dispute yourself and keep the schedule property free from all elements for being recorded and my client both free as an absolute owner and also indemnify my client in the matter of expenses depending on right now, I was trying to support the 6,000 we are liable to people 3% amount. I tried hereby notify you to their intention of disputing the suit area. So protest the protect the right and also in the commission. But nothing has happened beyond that. On notice was there. Refused. Audit.
ಇಲ್ಲ ಸರ್ ಜಾರಿ ಆಗಿದೆ 14A ಅಲ್ಲ ಎಲ್ರಿಗೂ ವಾಪಸ್ ಬಂದಿದೆ.
Probably that was intended to demonstrate or strengthen his case so that he's a bona fide purchaser. All right. 2:30. Madly then brief reply if required. Madhana, continue, sir. Not on Monday, after vacation. No, I'm sorry. Note, yaad note. Serial number? List 4. Monday, all Monday.
Serial number 13
Extend.
Serial number 13
Wherever there is an interim order, please mention, it will be extended.
kind permission. Serial number 13, my lord. Yesterday I was not well. My mother is there. Serial number 13.
ಎಂಟರ್ ಪ್ರಾಪರ್ಟಿ ಲ್ಯಾಂಡ್ ಸೇಲ್ ನಮಗೆ ಮಾಡಿದ್ರು ಆಮೇಲೆ ಉಳ್ಕೊಂಡು ಅಂತ ಅವರಿಗೆ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾವ್ದು ಸೇಲ್ ನಮ್ಮ ಪಾಟಡ
ಅಂತ ಹೇಳಿ ಜಸ್ಟ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ, ಪಾರ್ಟೆಡ್ ಆಗಿಲ್ಲ. ಇನ್ಯಾವುದು ತಗೊಳಲ್ಲ ಕೆಟ್ರೆ ಆಗಲ್ಲ. ಆಫ್ಟರ್ ವೆಕೇಶನ್.
Serial number 14, my lords. My lords, serial number 14, my lords. 14, my lords.
ವಾಟ್ ಯು ವಾಂಟ್?
ಸೀನಿಯರ್ ಇವತ್ತು ಅವ್ರ ತಂದೆದು ಕಾರ್ಯ ಇದೆ ಸ್ವಾಮಿ, ಮಂಡೇ ಹಾಕೊಬಹುದು ಸ್ವಾಮಿ. ಅವರ ವಿ ಹಾವ್ ಆಲ್ಸೋ ಇನ್ಫಾರ್ಮ್ ದ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್.
13%.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ. ಮಂಡೇ ಇಟ್ ಮೇ ಬಿ ಟೇಕನ್.
Your lordships, 10 and 12 is number 3. Lordship may have it at already.
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
Sir, what officer, sir?
ಎಲ್ಲಾರು further here. Even more work
The court list ಏನಾಯ್ತು?
Court officer. ಒಂದು, ಎರಡು, ಮೂರು, ನಾಲ್ಕು, ಐದು, ಆರು, ಏಳು, ಎಂಟು.
ಸರ್ ನಮ್ದು
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರೇ. ಸರ್ ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಸರ್ ಸರ್ ಗಿರಿಧರ್ ಸರ್. ಸರ್ ಕೇಳ್ತಾ ಇಲ್ವಾ?
ಹೇಳಿ
ಸರ್ ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 6.
ನೆಕ್ಸ್ಟ್
ಸೀರಿಯಲ್ ನಂಬರ್ 6 ನಮ್ಮ ಸೀನಿಯರ್ ಇದ್ರು ವೈಕೆಎನ್ಎಸ್ ಅವರು. ಅದು ಏನು ಡೇಟ್ ಹೋಯ್ತಾ ಸರ್ ಏನಾದ್ರು?
ಆಗಿದೆ ಸ್ಟೇ.
ಅಲ್ಲ ಲಿಸ್ಟ್ ಸರ್, ಲಿಸ್ಟ್
ರೆವೆನ್ಯೂ ಎಂಟ್ರೀಸ್ ಮೇಲೆ.
ಸರ್ ಲಿಸ್ಟ್ 2 ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 6 RFA 302.
ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಇಲ್ಲ, ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಇರೋದು. ಹಂಗೆ ಇದೆ, ಹಂಗೆ ಇದೆ.
ಹೌದಾ? ತಗೊಳ್ತಾರ, ರೀಚ್ ಆಗ್ಬೋದಾ?
ಮೋಸ್ಟ್ಲಿ ರೀಚ್ ಆಗಲ್ಲ, ನೋಡ್ತಾ ಇರಿ.
ಹೌದಾ ಸರ್? ಥ್ಯಾಂಕ್ ಯು.
Court officer, sir, list 3 reach ಆಗ್ಬೋದಾ final hearing matter? Court officer, sir.
ಧಾರವಾಡದ ಯಾವ್ದು ಇದೆ ಇವತ್ತು? ರಿಸರ್ವ್.
My lord,
Yes, sir. Reserved.
obliged.
Petition is dismissed. Dismissed. Mohammed Ali ಅಂತ. Mohammed Ali.
ಮೊಹಮ್ಮದ್ ಅಲ್ಲಿ ಅವರೇ ರಿಸರ್ವ್ ಆಗಿದೆ.
Repetition is allowed.
Milord, WP connected one WP is there, Milord. 103, 102,312. It has become infructuous, Milord.
That has become infructuous. All right.
Yes, Milord. WP 102,312.
All right.
Up to
Yes.
2014.
Yes. ಅದು ಯಾವ್ದು ನೋಡಿ connected has become infructuous.
Milord, that is reserved for orders
Yes.
tomorrow.
Yes.
Tomorrow, Milord.
Noted. Note.
My lord, in this case, number 17, my lord. Whether notification also passed or
ಯಾವ್ದು?
C number 17, notification,
Circular held to be illegal.
circular, man,
Held to be illegal.
please,
I've dealt with it. ಓದಿ ಆಮೇಲೆ ಓದಿ.
please.
ನಾವು ಮುಗಿಸ್ಬಿಡಿ ಅಲ್ವಾ? 14% ಆಕ್ಟ್ ಪಾಪ ಅವ್ರಿಗೆ ಹೇಳಿಲ್ವಾ ಸೋಮರತ್ನ? ಅವ್ರೇನೋ ಯಾರು ತಿರುಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ
ನನಗೇನು ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ.
ಹೇಳಿದ್ದೇನಂತ ಹೇಳಿದ್ರು.
ಹೇಳಿಲ್ಲ. ಸುಮ್ಮನೆ ಡಿಸ್ಕಸ್ ಮಾಡೋದು ಇಸ್ ಡಿಫರೆಂಟ್.
Your statement was that telephonically you informed him.
ಅಲ್ಲ ನನಗೆ 12:45 ಹೊರಗಡೆ ಇದ್ರು ಸ್ವಾಮಿ. ಅವಾಗ ಹೇಳಿದ್ರು 12:45 ಹೇಳಿದ್ರು. ಹೇಳ್ತೀನಿ ಅಂತ. ಆಯ್ತು ಸಾಹೇಬ್ರು ಏನ್ ಹೇಳ್ತಾರೆ
ಮಂಡೆ
ಅದನ್ನ ನಾನು
ಆಯ್ತು ಮಂಡೆ
Milord, may I mention, Milord?
Yes, Muhammad Ali.
Serial number, it is reserved for judgment, Milord.
Reserved.
Much obliged, Milord, because it was not audible at that time, Milord.
All right. Yes.
Sorry, Milord.
Yes.
Number 11, Prashant Kumar.
ಇಲ್ಲ ಅವ್ರದ್ದು ಮಾಡ್ಬಿಡ್ಬೋದು, ಇದು ಬ್ಯಾಚ್ ಅದನ್ನು ಬಹಳ ತರ್ತಾನೆ. Just a minute, give me 5 minutes. Yes, Pradeep. Where is the council?
ಲಿಸ್ಟ್ ಪ್ರಕಾರ
ನೀವು ನೋಡಿ.
ಇಲ್ಲ, ಒಂದ್ ಸ್ಟೇಟಸ್ ಅಲ್ಲಿ ನೋಡಿದೆ IA ನಾಟ್ ಫೌಂಡ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ.
Delay applications are not filed.
Status ಅಲ್ಲೇ ನೋಡಿದ್ರೆ ನಾಟ್ ಫೌಂಡ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ಸಬ್ಜೆಕ್ಟ್ ಸ್ಪೆಷಲ್ ಲೀವ್ ಇಲ್ಲ. ನೋ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಬಟ್ ವಿ ಹ್ಯಾವ್ ಟು ವೆರಿಫೈ. ಸ್ಟೇಟಸ್ ಅಲ್ಲಿ ಐಆರ್ ನಾಟ್ ಫೌಂಡ್ ಅಂತ ತೋರಿಸ್ತಾ.
I listed tomorrow 10:30. Please go through, verify, and ask that lawyer to be present also. What kind of a lawyer is? The appeals are being listed and he doesn't appear. Just go through the records. I'll list it tomorrow. Pradeep, I'll list it tomorrow. 10:30 ನೋಡೋಣ.
It's much obliged.
ನೋಡ್ಕೊಂಡ್ಬಿಡಿ. ಇಲ್ಲ ಲಾಯರ್ ಬರ್ಬೇಕು. Yes.
So number 11.
Before my learned friend
Oh,
commences, I am relying on the judgment which I wanted to inform you.
yes, sir.
Sorry, sir. Regarding readiness and willingness,
Ah,
throughout it is necessary.
correct, correct.
Yeah.
Law is clear. Law is clear.
Someday judgment.
That has to be examined in the context of each case. Each case. Yes, sir. Yes. Page? Page 79. For 6th line in the bottom. Yes. It is difficult to state that myself in conclusion with the defendant going to be not removing the defendant to decide the right to change. I have not taken any action in the defendant not proceeding to the court. The witness was not resist. So, as my single doubt arises that there was a thing, or you could have there. We are not accepted to apply. That section 20, section 20, ಏನು ಕಂಪೇರಿಟಿವ್ ಹಾರ್ಡ್ಶಿಪ್ ಬರಲ್ಲ ಅದು ಎಲಿಮಿನೇಷನ್ ಇದೆ. Yes, sir.
So the question of willingness, saying that you are not willing to does not arise. Yes, sir. And the question of guilty does not arise into the fact that the defendant has asked this from the court. The defendant only by have no defense. Say that we are the bonus regularization because after the put that and the grant of income. Yes. So. Who does it? And now, one more point. The property that was actually before was that is the important factor. And the rate of property. But the property that is goes with the dependent 4 and 5, 33 into 30, at the rate of 5%. So he made a good profit. Correct. Yes. Yes, sir.
I may be permitted to bring to your Honor's kind notice the contents of Agreement P1, that is the agreement of sale. The agreement of sale by the plaintiff with the defendants 1 to 3 was entered into on 19th of January 1995. Now the content, the agreement reads like this. That is, your Lordship gets at page 91 of the paper book. Whereas
Yes, sir.
yes, whereas the first party is the absolute owners in possession and enjoyment of the house property situated in number 100, new number 69/1, third block, Tyagaraj Nagar, Bangalore 28. They acquired the said property under registered partition deed dated 11/3/1985 between Kadari Shetty, the father of the first party of the first part. The said property was developed after raising loan of rupees 4 lakhs with the Bangalore District Cooperative Central Bank Limited, number 6, 5th Mine, Chamarajpet, Bangalore. Now that the outstanding balance amount due to the said bank is 4,52,000. The first party are husband, wife and son, who were allotted this portion of the property measuring 75/45. Now, after they purchased after they were allotted this property, they borrowed loan from BDCC Bank for construction. Then the outstanding balance amount due to the bank is for 4,52,000. The first party decided to dispose of a portion of their property to clear the said loan. They have offered a portion of the said property described in the schedule, and the second party has come forward to purchase on the following terms. The sale consideration fixed is 5,10,000. An amount of 40,000 only is paid by cash on this day, which has been duly received. Acknowledged by the first party against the separate stamped receipt. So they take another receipt from the defendants 1 to 3. Out of the balance amount, it is agreed between the second party, it is agreed between the party that the second party shall remit the above mentioned 4,52,000 to the BDCC bank, get released all the title deeds in original. The bank has assured the first party that the original title deeds, white deed made at 20th of June, would be released on payment of the outstanding due. the tenure for completion, the sale deed is fixed on or before the end of May 1995. Oh, this particular class, the defendants had agreed to sell the property for clearing the loan which was pending with BDCC Bank. So 5,10,000 was the agreed amount, out of which the loan that was outstanding was 4,52,000. Out of 75 by 45, they had put up construction by availing this law. In the frontage, where there was a vacant space, that was agreed to be sold in favor of the defendants, in favor of the plaintiff. With a condition that 4,58,000 shall be paid by them and the balance only to be paid.
Yes.
So this particular condition was embodied in the agreement itself. Subject to that, the plaintiff paid 40,000 rupees, less than 10% of the advance. He takes a receipt as per Exhibit P3. He has obtained a receipt also for 40,000 rupees. Then he has paid 10,000 and 5,000. That was on 2/2/1995. So 40,000 plus 10,000 by 5,000. Then the plaintiff deposited 1 lakh with BDCC Bank. That was on 25/2/1995.
Yes.
Thereafter, on 24/3/1995, he paid another 50,000 rupees. That endorsement Shara has been made on the agreement. That we find it in Exhibit P1. The first one is 2/2/95. 10,000 received 10,000.
All right, up to 24/3/1995, there is no dispute.
No dispute. Now, on 29/5/95.
29 or 25?
29/5.
It's 29/5. One lakh 50,000.
That's right. Now, this 29/5/95 payment of 1,50,000 is also alleged to have been paid by cash.
Yes.
Now, he doesn't take any receipt. He says that he has paid it by cash. Now, the plaint government gives a go by to this. The plaint governments are, insofar as the governments in regard to, may I draw your kind
Allah,
attention?
sir, just a minute. Sorry to interrupt you. How you can question the payment and transaction between plaintiff and defendant, number one? Can
Readiness.
make out a case on readiness
I'm restricting it only for readiness and willingness. That's all.
readiness and
ನಾ ಇನ್ನೇನು ಹೇಳ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ ಈ ಪೇಮೆಂಟ್ ನ್ಯೂ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಕ್ ಬರಲ್ಲ.
Payment due ಬಗ್ಗೆ 1,50,000 ಗೆ, that he has not produced any document apart from the endorsement. Can I not plead that it is not paid?
No, but you can argue on readiness and willingness. You can substantiate that even if he has succeeded in substantiating even that payment of 1,50,000, you can still demonstrate that this court need not exercise discretionary relief in his favor. On those two counts, you can do it. You can't trust to this transaction, you are not a party.
The trial court has rightly observed,
Yes.
in regard to 1,50,000 is concerned. The learned judge says 1,50,000. When he pays 40,000, he takes a receipt. 1,50,000. Where was the money for him to pay? He is not an income tax assessee. Then when he entered into an agreement, what was the amount that was available with him? That we get it under Exhibit P15, passbook. Kindly permit me to go refer to passbook. That is Exhibit P15, page 183. As on the date of the agreement, he was holding 36,000 only. That was the amount available with him.
Sir, you can't really look at the actual cash. Is the ability to mobilize fund is a question. Capacity
That's why I made available that judgment.
and lawyers are capable of mobilizing funds.
Capable of mobilizing.
He has a capacity to mobilize. He may not
Yes,
hold.
even that he has not proved.
Alright.
Where is the document to show that he had means to pay? No. It is well settled, the judgment which that the division bench. ತಾವೇ ಮಾಡಿದ್ರು. Your lordship was sitting with the division bench. There, that was a case where I argued the matter on behalf of the owner.
You argued.
I lost. That was a case where my client was a billionaire,
Oh, 10 lakhs.
10 lakhs.
ನಾನು ಬರ್ದಿದ್ದೇನೆ refund ಬರ್ದಿದ್ದೇನೆ. ನಿಮ್ಮ prayer
10 lakhs.
ಅದೇ ಅಲ್ವಾ ಇದು judgment?
ಹೌದು.
What happened to the judgment? This is intact or
I lost the case.
subject to challenge? Is it
No,
challenge?
it is not challenge.
Not challenge.
10 lakhs, his turnover per day was 10 lakhs per day. He was a leading cloth merchant.
Correct.
That was a case where this honorable court held as throughout the conduct of the person would be, this is what the trade law that person seeking benefit of specific performance of contract must manifest that his conduct has been blemishless throughout, so that the court would grant relief on the basis of the conduct of the person seeking relief. Readiness and willingness. The readiness and willingness has to be analyzed on the basis of the conduct of the parties, attendant circumstances, and also evidence on record. Then para 9.
Ali, your client had tampered the agreement.
Huh?
Your client had tampered.
No.
He had altered, correct. He had made some alterations.
No. What
That's why
happened? ಇಲ್ಲ ಟ್ಯಾಂಪರ್
Against
ಮಾಡಿದ್ದಲ್ಲ ಅದು.
ಹಾ.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ ಸೂಟ್ ಕೇಮ್ ಟು ಬಿ ಡಿಕ್ರೀಡ್. ನಾವು ಬ್ಯಾಲೆನ್ಸ್ ಕಟ್ಬಿಟ್ವಿ. ಯಾರೋ plaintiff deposited the entire amount. Then the defendant filed an appeal saying that he had not given an opportunity. It was remanded. Once after it was remanded, with the permission, I took back the money. So 1 crore which I had deposited, 1 crore 88 lakh, I took it back. That this honorable court finds it fault, saying your conduct in taking it back shows that you were never willing to pay. Therefore, the willingness, which in this case also, as on the date of the suit, as on the date of when he entered into an agreement, he was having 38,000 rupees. That is depicted from Exhibit P15. Then he pays 1 lakh to the BDCC bank. Now, as I read the agreement itself, the condition was that he should clear the loan. The defendants wanted to sell the property because they were unable to clear the loan. Therefore, they agreed to sell a portion in the frontage.
Correct.
So, the main crux of the matter is the defendants were bound to pay the amount to the bank. They were not required to pay to me.
There you may not be correct, sir. You may not be correct. Because it is his intention. The recitals indicated why he is selling the property. He wants to clear the bank debts.
Therefore, he wanted to sell.
But post agreement, he says that there is a subsequent development. He says, of course, bank debt is to be cleared, but there's a priority wise, I need that money to perform a marriage. When a vendor requests, the buyer cannot say that under the agreement, I have only agreed to discharge the bank debt and I can't pay you money. That can't. That is not how the transactions work out. Isn't it?
Could be.
So you can't hold it against agreement holder.
It is not his case that the contract has been altered. The terms of the contract altered. Nobody's case.
Contract alter ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
Payment ಎಲ್ಲಿ ಮಾಡಬೇಕಾಗಿತ್ತು ಬ್ಯಾಂಕಿಂಗ್
Terms of the contract never came to be modified. The terms, the specific contractual obligation was that he had to pay the loan to the bank.
Then he has elicited in cross examination.
Paying what?
Your argument is
ಹಾ,
covered under the cross
ಹೇಳಿದ್ದಾರೆ
examination.
ಏನು
ನಾನು ಅವ್ ಯಾವಾಗ ನಾನು ದುಡ್ಡು ಕೇಳಿದ್ದೀನಿ ಅವಾಗ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು 10,000 5,000 ಒಂದ್ ನಿಮಿಷ 10,000 5,000 50,000 ಅದ್ ಮೂರೇ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿರೋದು.
Correct.
ನಾವು 50,000 10,000 5,000 together makes around a lakh of rupee 40,000 area. If so far as 1,50,000 is concerned, why he ought to have paid it to the bank instead of paying it to me. Now, number one, 1,50,000 he has not paid to me, paid to the defendants.
Whether what you're arguing is reflected in the written statement, your vendor has not objected. That stand is not taken by your vendor.
It is taken. It is taken.
ತೋರ್ಸಿ.
Written statement.
ಅಲ್ಲ, he should not have made payment to me in cash, rather he should have
ಆ ತರ ಅಲ್ಲ.
paid it clear. ಮತ್ತೆ
ಅಲ್ಲ,
it is not his grievance.
he has paid only 1 lakh.
Correct.
ಆವಾಗ್ಲೂ the remaining amount he should have deposited to the bank.
Correct.
Now, in the plight he says, I called upon the defendants 1, 2, 3 to clear the loan. He giving a go by to the terms of the agreement. Now, the very color, the stand taken by the plaintiff is contrary to the terms of the agreement.
Order payment to defendant number 1 is contrary to agreement. That's how it has to be.
ಹಾಗಲ್ಲ ನಾ ಹೇಳ್ತಾ ಇರೋದು.
That is how it has to be read now.
No.
Correct.
Payment of 1,50,000 is not made to the defendants.
And this is a very critical question also. You have raised a valid ground that under the agreement he was required to clear the debt.
Throughout.
Then clear the debt within the stipulated time. Within
Yes,
the
May 95.
May 95.
Did he do that? No. May 1995 till May 1995, what was the amount that was available with him? As on May 1995, he had 1,30,000 rupees. In April, we see from Exhibit P15, in the month of March, he was having 39,978.
What was the debt, outstanding debt of 4,50,000?
4,58,000.
Yes.
4,58,000. Supposing he had paid me 1 lakh, he paid 1,40,000, 10,000, 5,000, 55 aitu, plus 50. He paid me 1,05,000. That is admitted. Now the remaining, at least he should have credited to the bank. Now 1,50,000, he says he has paid it to the defendants 1, 2, 3. Now Exhibit P1 is the document on which he says that he has made payment and taken an endorsement. Exhibit P1. The defendants file into court Exhibit D1, true copy of Exhibit P1. While effecting payment of 50,000 rupees, it is the case of the first defendant that he received, after he paid 50,000, he took this, he took this signatures. He wanted the signatures of first defendant, defendants 2 and 3, leaving a blank space, saying that he has to incorporate that in respect of payment of 1 lakh paid to BDCC Bank. Now, Exhibit P1, when they made payment, Exhibit D1 is the true copy which was taken by the plaintiff, by the defendant. Exhibit D1 may kindly be seen. My learned friend brought to the notice of the court Exhibit D2. The trial court holds Exhibit D2 is tampered, it is not proved. But Exhibit D1 is the true copy of Exhibit P1. There are 2 documents here. Exhibit P1 is the agreement entered into between the plaintiff and the defendants 1, 2, 3. Exhibit D1 is a copy of Exhibit P1. Exhibit D2 is the one which the defendant set up a plea, 1 to 3 set up a plea, that when they repaid the entire amount of 2,55,000, 5,000 plus 50,000 damages, the plaintiff returned the original. That according to them is D2. The trial court, after examining, a commissioner was appointed, finds that D2 is tampered. D2 is a document which the learned judge holds that it is not the original which is stated to have been entered into between the plaintiff and defendants 1 to 3. D2 is not the document which is given to the defendants 1 to 3 by the plaintiff, and the contentions of the defendants 1 to 3 that they repaid the amount through their brother of the first defendant has been disbelieved. The court holds Exhibit D2 is not the document which they entered into agreement.
Now, if D2 is held to be a tampered document, why we should not doubt the credibility of this defendant number 1? His conduct is found to be grossly unfair.
Quite true.
Tampered. He has placed reliance on a tampered document before a court. Now, D1, there is an explanation forthcoming. It's all about probability.
No, the probability, the plaintiff is not overboard. His conduct. Kindly consider this. Plaintiff contends that he has paid 1,50,000 by cash. The trial court holds that it is not proved. He is not an assessee. He had no money. The endorsement is by the plaintiff himself, who is an advocate. There is no witness to that. Then the gap is filled up, could be seen from examining Exhibit D1. The trial court does that. Therefore,
what Exhibit D1 did. P1 and Exhibit D1.
The conduct of the plaintiff, first of all, in contending that he makes payment of 1,50,000, how could it be? The court doesn't believe him. Nobody is examined. There is no witness to that. And he has produced the document P2 and 15. Where do one day passbook? He had only one account. Where did he get 1,50,000? How did he get it? No.
Whether defendant number 1 made an attempt to get his disputed signatures referred to expert. Whether an attempt was made.
No, it was not done. No, not done. Kindly permit me.
Why?
D1 may kindly be seen. D2 ಅದು ಒರಿಜಿನಲ್ 2 ಒರಿಜಿನಲ್ ಅಂತ ಹೇಳಿ ಕೋರ್ಟು D2 ನ This exhibit D1 and P1, the learned judge compares it and finds that it is one and the same. So far as D1 is concerned, the court holds that it is the copy of D1, P1. Now, when 50,000 payment was made, then he insisted for signatures being taken down below, leaving some gap. This gap is filled up.
Yes. ಇದು 1,50,000 ಪೇಮೆಂಟ್ ಇಲ್ಲಿ ಬರೀಲಿಲ್ವಾ?
ಇಲ್ಲ.
ಅಮೌಂಟ್ ಬರಲಿಲ್ಲ. ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಕೊಡ್ರಿ.
ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಇದೆ.
ಅದೇ ಅಲ್ಲ, you show it from the original. ಅದೇ just show it from exhibit P1 ಅಲ್ಲ.
There is a thing that I was around to, I have made it right after this. That is video 20 report. Having heard that is the person who produced fabricated document.
It is written by the plaintiff himself.
The signatures are marked through plaintiff.
No, cross-examination, admission.
Signatures,
Only he said, place was laptop, you fill it up.
We admits it. ಇದನ್ನ ಹೇಳಿಲ್ಲ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅವರೇ ನೀವು ಇಲ್ಲ ಮರ್ತ್ರಿ
All places were admitted by him.
ಅಲ್ಲ you should have taken me through this ಅಲ್ಲ maybe you argued but you should have
They are told by him. And in the course of the cross-examination, elicited, P1 is not a Xerox copy, it is a manipulated Xerox copy. Because the Lakshmi ADC, exhibit P1 contains the.
ಯಾರು DW1 ನ who admits dependent
Page 7. In fact, the statement itself, they are not signature. Cross-examination ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
signatures ಒಪ್ಕೊಂಡಿದೀವಿ ನಾವು. ಸುಮ್ಮನೆ ಒಪ್ಕೊಂಡಿದೀವಿ.
ಅಲ್ಲ ಸರ್ ಅಲ್ಲಿ ನೋಡಿ then how this content goes missing
That is the crux of the matter.
no it is for defendant number 1 to explain
That he has explained in para 6 of the written statement.
ಏನಂತ
The plaintiff had agreed to tear the entire loan of 4,52,000 within 1 month from the date of the agreement, as the plaintiff had paid only 1 lakh to the bank. That too after 1 month, the bank insisted the defendants 1 to 3 to pay the entire amount in lump sum to get interest concession. The defendants 1 to 3 brought this to the knowledge of the plaintiff and to pay the balance of 3,52,000 to the bank. The plaintiff failed to pay the amount in time. However, during discussion, plaintiff agreed to pay additional advance of rupees 50,000. Accordingly, the payment of 50,000 on 24/3/95 was written and the first defendant had signed the shara before making the payment. The plaintiff requested the first defendant to put his signature and get the signatures of second and third defendants after leaving some gap. When the first defendant questioned about the same, plaintiff replied that the gap will be utilized to enter the details of the payment made to the bank. The defendant believed the same and accordingly signed the last page of the agreement, leaving some space. At that time, the defendants had retained a Xerox copy of the agreement, and the same is herewith produced as Annexure A. ಇದು ಅವಾಗ ಏನಾಗುತ್ತೆ?
Yeah, but really you have to appreciate the skill of lawyers, sir. Ultimately, it's for the judge to digest, but appreciate it. The best possible defense.
It is a real
Very inventive, and this court appreciates. Inventive, sir. ಇದು inventive.
ಇಲ್ಲ
ಇಲ್ಲ
ಇಟ್ಸ್ ಅ ಫ್ಯಾಕ್ಟ್. ಈಗ ಎಕ್ಸಿಬಿಟ್ D1 ನನ್ನ ಹತ್ರ ಹೇಗೆ ಬರುತ್ತೆ ವಿತ್ ದಿ ಸಿಗ್ನೇಚರ್ ಬ್ಲಾಂಕ್ ಅನ್ಲೆಸ್ ಐ ಹ್ಯಾವ್ ಟ್ಯಾಂಪರ್ಡ್ ವಾಶ್ಡ್ ಇಟ್ ಆಫ್ ಬೈ ಕೀಪಿಂಗ್ ಸಮಥಿಂಗ್.
Sir, if there are
could we see that?
Now, if there are 2 originals of one document, you can appreciate it. Xerox ಏನು ಈಗಲೂ ಮಾಡ್ಬೋದು. ಒಂದ್ 2 ಪ್ಯಾರಾಗ್ರಾಫ್ ನೀವು ಬಡಾಗಿದ್ದು which really affects you, You can cover it and you can take a Xerox.
Correct.
I'll tell you where your clients, not your client, where dependent number one is misled. You should have got rid of the signatures also. You should have got this, rid of the signatures. ಇದು ಏನೂ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ.
ಅದು ಮೋಸ, ಅದು ನಾವು ಮಾಡಿಲ್ಲ. ಇಲ್ಲ ಇಲ್ಲ ಈಗ ಒಂದ್ ನಿಮಿಷ, ಇದು ಡಿಫೆಂಡೆಂಟ್ಸ್ 1 to 3 ಕೇಸು. 1 to 3, if 1,50,000 was really paid, for a moment assuming that he had paid.
How we are visualizing,
ಅದು ಹೇಗೆ ಅಂತಂದ್ರೆ,
ಈ ಪೇಮೆಂಟ್ ಬಗ್ಗೆ ನೀವು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಕ್
ಬರಲ್ಲ ಅಂದ್ರೆ,
no, you are not party to this. You were not witness to this document. You were not present when these payments were made.
1,50,000 ಅವ್ರ ಹತ್ರ ಇತ್ತು ಅನ್ನಕ್ಕೆ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. He was not capable of paying 1,50,000. Assuming that he had paid 1,50,000, as per the terms of the agreement, he should have paid it to the bank. The contractual obligation under
That I will accept.
obligation under P1,
Yeah, the explanation is that para 6 of the written statement.
para 6.
ಅದು ಕ್ಯಾನ್ಸಲೇಷನ್ ದ ಟ್ಯಾಂಪರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯಲ್ಲ ಎಕ್ಸಿಬಿಟ್ D2 ದಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಬಂದಿದ್ಯಾ ಕಡೆಗೆ ಇಷ್ಟು ಸ್ವಲ್ಪ ಪೇಮೆಂಟ್ ಮಾಡಿ he was required to clear off the debts of the bank. He has not done it, but he had also secured my signatures in advance, assuring me that he would clear off the debts, and he had not done it ಅಂತ ಆ ಟ್ಯಾಂಪರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಅದ್ರ ಇದೆಯಾ ರಿಸೈಟ್ ಅಲ್ಲೂ
ಇಲ್ಲ.
ಮತ್ತೆ
ಅದು
ಅರ್ಲಿಯಸ್ಟ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಅಲ್ಲ
ಅದು ಒರಿಜಿನಲ್ ವಾಪಸ್ ಕೊಟ್ರು ಅಂತ
ಅಲ್ಲ, ಬಟ್ ಅಲ್ಲಿ ಬರ್ಬೇಕಾಗಿತ್ತಲ್ಲ ಅದು. That was a very relevant piece of material fact.
But the fact is,
when you set up a case, when a narrative is set up, you have to clear all the dots.
all the dots, absolutely. That's what I am
yes.
asking the plaintiff to do that.
Correct.
Now the dots are, number one, I deliberately read exhibit P1. There is a clause, there is a preemption clause. This partition, the defendants 1 to 3 got this property
Yes.
under a partition deed. There was a preemption clause under clause 10 of the partition deed, para 10, that the plaintiffs, in the event of the defendants effecting sale, the option should be given to their siblings. The first defendant has 2 brothers and a sister.
Yes.
So the partition deed, the plaintiff was aware of that. The plaintiff took the copy of the partition deed, looks into it, he drafts the agreement. He pays 40,000 plus 15,000 plus 50,000, no dispute. So far as 1,50,000 is concerned, the learned trial judge has categorically convinced and held that 1,50,000, if you have really made payment, you would have taken a receipt. You took a receipt for 40,000, mere 40,000. You did not take any receipt. 1,50,000, your passbook does not show that you are having money to that. He had no other source of payment except he has made payment, shown only passbooks. His income, he has not produced any records other than producing the passbook, and then belatedly he makes a sale of the property, produces a copy of true copy. Now, in this background, my humble submission would be the conduct of the plaintiff in not paying the loan to the bank. Is it not a serious concern? When the defendants were under a lot of tension and worry because it was supposed to have, it was being brought to auction. Unfortunately, those records are not made available. So they were deliberate to clear the loan. Therefore, out of sheer necessity, they offered it for sale. Now, what is the conduct of the plaintiff? He pays 40,000, not even 10%. Then, what is the deposit he has made? 1 lakh. That I also admit. For 1 lakh, the balance of 358 was required to be paid by him. Now, what is the effort on the side of the plaintiff as to showing his bona fides as to what is the effort he has made to repay the loan? 358 balance it. Instead, he says, I paid 1,50,000. You celebrated the marriage of your two daughters. Even in regard to that evidence, there is no clear evidence whether he sought loan for the marriage of his daughter. Not clear. The learned judge has also made it clear that in regard to that also there is no proof. But he has made payment of total 1 lakh rupees, 1,10,000. So far as 150 is concerned, absolutely no evidence other than the endorsement. Now, so far as this endorsement is concerned, 1,50,000.
Yes.
The learned judge has held that he has not proved. Then, supposing he had 1,50,000 paid, even then, he owed the balance payable. What is the record to show that he had money? That is why I may be permitted to read the cross-examination, only 2 pages.
Wait.
Examination in chief, page 25. In page 26, kindly permit me to read one para in the chief examination to show the conduct of the plaintiff. The conduct of the defendants is so bad that apart, he has approached the court. Now, chief exam,
Yes.
para number 2. On the date of the agreement at exhibit P1, I paid rupees 40,000 in cash as an advance money. They had agreed that they will clear the loan with BDCC Bank within the period of 4 months and immediately thereafter execute a sale deed in my favor. This is not the case pleaded in the plaint. So, kindly look into the conduct of this gentleman. He gives a go-by to that. He says, no, you have to clear it. Then, kindly permit me to go to the cross-examination. Page 33. I myself drafted this agreement. I have not done the etc. Para 2. I have gone through the contents of the partition deed before entering into the
Page, Elisa?
page 33.
33.
Page 33. Ali, the agreement is drafted by the plaintiff. I myself drafted this agreement. I have gone through the contents of the partition deed before entering into the agreement. I do not know whether defendants 1 to 3 knows English language. I talked with the defendant only once in connection with the transaction. After the sale transaction, I might have met the defendants 2 or 3 times. It is not true. I was knowing the fact that the defendants were not knowing English language. On the date of the execution of the agreement, I paid rupees 40,000 by way of cash. It was also agreed to hand over the possession of the property before the registration of the sale deed. It is true that there is a recital in the agreement that possession was handed over to me on the date of execution of the agreement itself. Our draft madavaga agreement by way of part performance, possession is delivered anta kuda barkonbittidare. That he says, it was agreed to hand over possession at the time of sale deed. It is true that the recital in the agreement to the effect that possession was handed over to me on the date of the execution of the agreement itself. The witness volunteers that the defendants also agreed to the said recital of the agreement. The defendant signed the agreement admitting the recital of the agreement in respect of the possession. According to me, defendants handed over possession of the property on the date of the agreement itself. It's very strange. The possession was with the defendant, and presently it is with the defendants 4 and 5. I have present suit And I have filed the present suit on the basis of the agreement of sale executed by the defendants. I myself gave instruction to draft the plaint. After knowing the contents of the plaint, I have put the signature. The contents of the para number 11 of the plaint are true and correct. It is not true that defendants never handed over possession of the property to me. It is not true that since myself drafted the agreement of sale, I had written in the agreement for having handed over possession to me just to cheat the defendants. I have acted as per the terms of the agreement. It is true that as per the terms of para 1 of the agreement, I had to discharge the loan of the defendants with BDCC Bank. 4 months' time was stipulated under the agreement for completion of the transaction, except issuing check for 1 lakh in favor of the bank to discharge the loan of the defendants. I had not paid any other amount to the bank within the stipulated period. I have produced the documents before to court to show that I was having sufficient funds with me by the end of May 1995. That is the time duration. I am having the bank passbook with me. As per Exhibit P15, the bank account extract by the end of May 1995, I was having rupees 1,30,921 in my account. I have also withdrawn some of the amounts in the month of May and June 1995. So this was the amount he had. Out of 5,10,000, this was as on May 1995. Earlier to payment of 1,50,000. So what was the balance he had? 1,30,921. So he had paid only 1 lakh to me, 1 lakh to the BDCC Bank. So he owed 3 lakhs and 3,10,000 was the remaining balance. He had only 1,30,000. Even that amount I have withdrawn. Some of the amount I have withdrawn in May, June and 1995. I had not issued anything in writing before the expiry of the stipulated period immediately after the expiry of the time to the defendants, calling upon them to execute the sale date. The witness volunteers and states that the time was extended. As such, he did not anything in writing. Now his case is, apart from acknowledging 1,50,000, the time is extended till end of December 1995. The witness volunteers said time was extended. As such, he did not issue anything in writing. There is an endorsement on the agreement regarding extension of time. The endorsement effected on the agreement regarding extension of time is P1J. The endorsements are in my handwriting. It is true, first defendant alone signed the endorsement. Even though I asked the signatures of 2 and 3, they did not turn up and sign the endorsement. Whenever I made the payments, the endorsements have been effected. It is not true that I had taken the signatures of the defendants on the ground that the signatures were required on the agreement to effect an endorsement for having paid an amount of 1 lakh to the bank. It is not true that I obtained the signatures along with 2 and 3, along with the signature of defendant number 1, stating that their signatures were required in connection with the payment made as per P1G to H. I do not remember whether I had issued a check in favor of the bank on 25/2/95. There is no endorsement on the agreement in connection with the payment made by me to the bank. So even for that, there is no endorsement. It is true that I had paid 50,000 on 24/3 and obtained an endorsement to that effect. I had not felt to obtain an endorsement in connection with the payment to the bank. It is not true that since I was not having sufficient funds by the end of 1995 May, I asked the defendants to dispose of the property to the third parties. It is not true that I had not paid 1,50,000 to the defendants as per the endorsement P1J. Except the defendants, no other persons were present when I made further advance. Prior to execution of the agreement of sale, I had gone through the Xerox copy of the documents. I had not taken consent from the brothers of the defendant number 1 prior to execution of the agreement of sale. That's because of the preemption clause. I asked the defendants to purchase the stamp paper in my name. Accordingly, the defendants purchased the stamp paper in my name. Prior to purchase of the stamp paper, there were talks regarding the sale transaction. Except payment of 1 lakh to BDCC Bank, I have not paid any other amount to the bank. but the defendant themselves received the amount. As on the date of execution of the sale agreement, I was knowing that what was the amount payable to BDCC Bank. It may be a fact that after payment of the amount to BDCC Bank, the defendants were required to receive rupees 20,000 only. Whenever I asked the defendants at the time of payment of the amount, whether they had paid the amount to the bank, for they replied stating that they had paid the amount to the bank. I do not know whether the defendants agreed to sell the property in my favor as they were unable to clear off the loan to the bank. What is this? This very strange. It is not true that I was knowing then. Next paragraph. Except acknowledging in the agreement having paid finally rupees 1,50,000 to the defendants. I have no other separate documents. The defendants received this amount to discharge the debt pertaining to the marriage of their two daughters. The defendants have failed to discharge the loan to the bank even though they have received the amount from me. It is not true to suggest that I was not having amount. As such, I failed to get the registered sale deed. It is true that I asked the defendant to sell away the suit property in favor of third persons and to pay the amount to me which was received by them. A sentence is a mistake. Huh? It is true to suggest. Not.
ನೋಡಿದೆ ಅದು ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ. ಐ ಥಾಟ್ ಆಫ್ ಕಂಪೇರಿಂಗ್ ಇಟ್ ವಿತ್ ಒರಿಜಿನಲ್ ಅಂತ ನಾನು ಪೆನ್ಸಿಲ್ ಇಂದ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ. Yes, sir.
Then the cross-examination by defendants 4 and 5. No, the defendants 4 and 5, they verified the encumbrance certificate. They purchased the property. They were not aware about the earlier agreement. This is the cross-examination.
Yes.
Then the judgment, kindly permit me to read only those two paragraphs.
Yes.
The learned judge.
Page
256.
Yes, sir.
He takes up additional issue number 1. Additional issue number 1 is whether the defendants 1, 2, 3 prove that the contract between them and the plaintiffs for sale of the suit property was terminated. Now, suo moto, the learned judge, while dictating the judgment, suo moto referred exhibits P1 and D2. We get it at page 260. Page 260. The contention for repayment has been disbelieved. Then para 9. Apart from the alleged document exhibit D2 said to have been delivered by the plaintiff to the DW2, they came to know that the document was fabricated by the plaintiff and given to DW2 by receiving the amount. DWs 1 and 2 asserted in their evidence that it was given by the plaintiff himself. On the other hand, plaintiff denied he has not at all received. The plaintiff produced exhibit P1, agreement of sale pay, said to be executed by defendants 1 to 3 in favor of the plaintiff, and their clear contention that D2 was handed over. Admittedly, defendant, then kindly permit me to go to the next page. Therefore, this court, while dictating the judgment in earlier occasion, suo moto referred P1 and D2 to the FSL Bangalore for getting the opinion of the handwriting expert. Accordingly, the handwriting expert, Lakshmi Narayana, after receipt of P1 and P2, P1 and D2 verified signatures and filed the report. Thereafter, this court summoned the handwriting expert Accordingly, Lakshmi Narayana examined the CW1, got marked 6 documents. As per the evidence of the handwriting expert, the signatures of dependents 1, 2, 3 on P1, which were the admitted signature. Signatures of dependents 1, 2, 3 on D2, that is a disputed signature compared by the expert. He has filed report as per his opinion. The signatures of 1, 2, 3 on P1 and also the endorsement and also the disputed signatures on the exhibit D1 belong to one and the same. And person Ganeshan, Kasamma, Vagnarajan, that is dependents 1, 2, 3. The evidence of the commissioner not been challenged. C1 is the report, C1A is the opinion, C2 is the reasoning, C3 are the admitted signatures of defendant number 1, C5, 6 are the admitted disputed signatures of D2, C7, 8 are the enlarged signatures. Even on a comparison of the signature of plaintiff on P1 and D2, it clearly differs from each other. Even otherwise, I am reading T262 in the Madhyadal. Even otherwise, exhibit D1 is the Xerox copy of the original agreement of sale, wherein the signatures of the plaintiffs are differs from the alleged signatures of on the exhibit D2. Even the letter compared with D1 and D2 differs. Comparison of P1 and D1 clearly goes to show D1 is the Xerox copy of P1.
Correct.
Correct. ಅದ್ರಲ್ಲಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಲ್ಲ.
ಅದು ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಇದೆ. 100%.
ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಇದೆ. ಆದ್ರೆ ನಾವು ತೆಗೆದಿಲ್ಲ ಅದನ್ನ. ದಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಸ್ ಏನೇಹೋ.
ಅದು ಹೇಗೆ ಸರ್ ಅದು? ಅದು ಮಧ್ಯದಲ್ಲಿ ಒಂದು ಪ್ಲೇನ್ ಪೇಜ್ ಇಟ್ರೆ ಏನಾಗತ್ತೆ ಹೇಳಿ?
ಅದ್ ಗೊತ್ತಾ?
ಅದು ಅಷ್ಟೇ ಅದು.
But if at all exhibit D2 was fabricated, we could either. Issue number 1, kindly permit me to
Yes,
go to correct. I should have directly come to that. It is an admitted fact that the defendants 1, 2, 3 are the owners of the scheduled property. They agreed to sell the suit property to the plaintiff for 5,10,000, executed agreement of sale, exhibit P1 on 19/1/95. As on the date of the agreement, the plaintiff paid 40,000 to defendants 1, 2, 3 under exhibit 1, 2, 3 under exhibit P14, receipt acknowledged by the defendants 1, 2, 3. And 40,000 one receipt, exhibit P14. It is an admitted fact that the defendants 1, 2, 3 mortgaged the property, suit scheduled property to BDCC Bank. There was an outstanding loan of 4,10,000. As per the terms of the agreement of sale, plaintiff required to discharge the said loan to the bank directly, and remaining amount shall be payable to the defendants on or before the registration of the sale deed, and the sale deed should be completed within May 1995. It is an admitted fact that the plaintiff paid 1 lakh to the BDCC Bank directly on 25/2/95. It is also an admitted fact that on 2/2/95 paid 10,000 plus 5,000 to the defendants 1, 2, 3. It was acknowledged by him by endorsing on P1. It is also an admitted fact that on 24/3/95, again the plaintiff paid 50,000 to the defendants. The same was endorsed by the first defendant on the backside of P1. As per the contention of the plaintiff, again the defendant demanded 1,50,000 for the purpose of marriage of the daughter of the first defendant. Accordingly, plaintiff paid 1,50,000 to the defendant, and the same was endorsed by the defendants 1, 2, 3 on the backside of exhibit P1 on 29/5/95. And the defendant also extended the time limit up to December 1995 for execution of the sale deed. As per the contention of the plaintiff, he has already paid 355, request to pay 150 only to the defendants. When the plaintiff demanded the defendant to execute the sale deed, defendants have not executed the sale deed on the ground that they require some more time for discharging the loan. The defendants, though admitted receipt of 2,05,000, denied receipt of 1,50,000 as on 29/5/95. However, the defendant number 1 admitted in the cross-examination the signature found on exhibit P1 and the endorsement belong to them. But the defendant taken a contention while receiving 50,000 on 24/3/95. Plaintiff obtained the signatures of 1 to 3 by leaving some space. Thereafter, it was added by the plaintiff showing 1,50,000. Whereas plaintiff denied it Same, in order to prove the contentions of the defendant, they have mainly relied on Exhibit D1, Xerox copy of P1. On perusal of P1 and D1, both are same. D1 is the Xerox copy of P1. On the perusal of the last page of D1, it does not show the endorsement said to be made by the defendant number 1, extending the time till December 95. The signatures of 1 to 3 were found on Xerox copy. Comparison of P1 and D1 goes to show that it is obtained signatures of 1 to 3 on the blank space. He has inserted the endorsement said to have been received. It is pertinent to note that on the execution of the agreement of sale, while paying 40,000, plaintiff obtained separate receipt as per Exhibit P14. Such being the case, how a practicing advocate could have paid 1,50,000 only on the endorsement behind the agreement of sale. Apart from that, he has not produced any other document before the court to show that as on 29/5/95, how he got 1,50,000 to pay to the defendants. Even Exhibit P2, the statement of the bank passbook also does not reveal he had more than 1,50,000 in order to pay to the defendants 1 to 3. As per the bank passbook, the plaintiff had 13,208 as on 2/6/95. Even otherwise, for a sake of argument, if we take into consideration, plaintiff paid 1,50,000 as on 29/5/95 for the marriage of the daughters of the first defendant. Plaintiff has not produced any document to show the marriage of the daughters of the first defendant held in May 95 or June 95. Apart from that, as per the terms and conditions of the agreement of sale, plaintiff required to discharge the loan of 4,10,000 directly to the bank. Such being the case, being an advocate, why paid 150 to the defendant on 29/5? Even if he has paid, plaintiff has not attempted to discharge the remaining loan of rupees 3,10,000 to BDCC Bank. If at all he had sufficient money, there is no question of paying the money to the defendant directly. He was required to discharge the loan to BDCC Bank. Therefore, the contention cannot be accepted that he has paid 1,50,000. The bank passbook, but by taking advantage, admittedly, the endorsement in the handwriting of the plaintiff himself, P2 and P15 bank passbooks are not sufficient to hold that the plaintiff was ready, willing to perform his part of the contract and ready to pay the sale consideration to the defendant. Since it is an admitted fact, then he sells the property in July 95, long after May. Now, supposing he has paid 1,50,000 plus 1 lakh plus 1 lakh, 355 agate, let's say. Even then, if it falls short by 1,50,000 rupees, where is the money? Now, I have no money. Defendants 1, 2, 3 have no money to discharge the loan. That is why they were frustrated to effect sale. Now, assuming that he has paid 355, what would be the consequence? How to get out of the situation, forgetting that I have purchased? Supposing I had not purchased. Avaga, in which case, who has to discharge the loan? He openly knew all along that he was the obligation for him to discharge the loan. He pays only 1 lakh. The contractual obligation is different and sympathy is different. ಹೆಣ್ಮಕ್ಳು ಮದುವೆ ಕೊಟ್ಟಿರೋದು 1 ಲಕ್ಷ ಒಪ್ಕೋತಾ ಇದ್ದೀವಿ, 40 ಸೇರಿ 1,50,000 ಕೊಟ್ಟಿದ್ರು ಪಕ್ಷದಲ್ಲಿ ಕೂಡ. The remaining 2 lakhs has to be paid to the bank. That is where the learned judge finds fault with the conduct of the plaintiff. In such an event, the learned judge has rightly said, rightly ordered for refund of the money. Now, specific performance, if it is ordered, then who has to pay the money, get the loan discharged, is the question that would prop up. Unless it is their case that the defendants 1, 2, 3 said, very well, we will clear the loan. You pay the balance. No, nobody's case. Where is the pleading? The question would be, still short of 1,50,000. Therefore, the plaintiff throughout has shown that he had no money and he sells it after May 1995. The endorsement says it is extended till December 1995. Why? Why should it be extended when he ought to have paid it to the bank? That is what I could foresee. The conduct of the plaintiff and the defendant's conduct 1 to 3 is maybe another aspect of the matter. Kindly consider the conduct of the plaintiff. He has no money, he has no income other than bare necessities. For purchasing of an immovable property in those days, he ought to have made efforts to show that he had money. He never paid money to the bank. 1 lakh kotru, aladmele kodla illa.
Yes.
So, my humble submission would be this judgment which squarely applies. Throughout, it is necessary that as on the date of this, when he entered into agreement, despite owning a property may not be a criteria. Willingness, ready and willingness. This is what your lordship wrote, considering almost identical case anta ನನಗೆ ಅನ್ಸುತ್ತೆ. Para number 14 and 15. 14. Readiness, willingness has to be analyzed on the basis of the conduct of the parties, circumstances, evidence on record. Then the entire material on record indicates that the plaintiff never intended to keep the contract subsisting with preparedness to fulfill his obligations and accept the performance when the time for performance arrived.
Para?
Judgment.
The paragraph?
Paragraph 14. Para 14.
Para 14.
He had opened a new showroom. I had furnished document to show that he was a person of means. Adike, he may have purchased another property.
ಅದೇ ರೆಡಿನೆಸ್ ಇತ್ತು ನಿಮ್ದು ವಿಲ್ಲಿಂಗ್ನೆಸ್ ಇಲ್ಲ ಅಂತ.
Willingness. That is absent here. That is absent here. That then para 16. If the government same would clinch the entire issue. It is straight law that the agreement holder has to prove his readiness and willingness from the date of agreement till the litigation attains finality. So, as on the date of this agreement, he had only 40,000 rupees. And the trial court has proceeded on the assumption that he was a big reputed businessman.
Yes, sir.
Then illi 75 by 45 is the total property measurement, out of which he had defendants 1, 2, 3 had constructed ground and first floor, and they were living there. And the frontage matra our sale ಕೊಟ್ಟಿರೋದು. ನನಗೆ the agreement is 33 by 45, out of which he has sold 33 by 30 to the defendants for 45. The remaining property is already sold and somebody has already built a construction home.
ಅದೇ we can't accept.
ಅದಕ್ಕೇನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ, ಅವ್ರನ್ನ ಪಾರ್ಟಿನೂ ಮಾಡಿ. No, this is a case where my humble submission would be refund of money is the only relief that could be awarded in favor of the Otherwise, unfortunately, I am stuck up, I am bona fide purchaser ಅಂತ ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. Nevertheless, we have invested all our life savings over there.
With all grace and politely, you argued for defend number 1.
No, no. I had no other go. I had to support him. Otherwise, I had no other choice. But I have
Correct.
made out a case is my humble submission.
I kept on objecting, but you very politely, you took me through all. You really conveniently stepped into defendant number 1's shoes. Yes, sir. Not I'll examine. ಹೌದು ನೀವು ಅಲ್ಲಿ 3,50,000 ನೀವು ಕೊಟ್ಟರು by May 1995, you were required to clear at least that balance amount, not the entire 4,50,000. ನಿಮ್ದು ಗೊತ್ತು. Yes.
What all he said now arguing for 1 hour, not an iota of it there in the cross-examination of me.
ಆ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇತ್ತಾ?
ಇಲ್ಲ.
ಪಾರ್ಟಿಷನ್ ಪ್ರಿಯಂಪ್ಷನ್.
ಪ್ರಿಯಂಪ್ಷನ್ ಇತ್ತು. ಅದನ್ನ ನಾವು ಕೊಂಡ್ಕೊಳ್ಳುವಾಗ 4 and 5, they obtained NOC from the brothers and sisters pursuant to the preemption clause. That exhibits are produced before the court. So the effort for complying with the preemption clause was there on behalf of the defendants 4 and 5. Whereas the first defendant plaintiff never took initiative. He is not a person who was seriously inclined to purchase. That's why he never did all that.
ತಾವ ಆದ್ಮೇಲೆ NOC ಹೆಂಗ್ ಬಂತು? ತಾವ ಆದ್ಮೇಲೆ ಇಮಿಡಿಯೇಟ್ಲಿ NOC ಬಂತಲ್ಲ?
ತಾವ ಹಾಕಿರೋದು ಕೂಡ after 1 year. ಹೌದು. From the date of the agreement 2006.
December 553 to 1996, within 3 months. Not even 3 months.
Yes, sir.
Now, the letter is, and my letter from argument, that you have not proved when the marriage, whether somebody was thought from marriage of the thought of the first defendant. So that is, doesn't get bored, you have not said anything to show that the marriage is taken off the thought of the first defendant. The last one is the application the cross examination of the at page 52. At page 52, last 3 days.
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಓದಿದ್ರಲ್ಲ? ಅದು ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ಪ್ರಿಯಂಪ್ಷನ್ ಕ್ಲಾಸ್ ಇತ್ತು. ಅದು ಎಲ್ಲಿದೆ? ಅದು ಮಾರ್ಕ್
Paragraph 10 of exhibit. Partition deed.
Partition deed is part of
P12, para 10. Para 11, sorry. Page 139.
Yes, sir.
Then,
correct.
ಅಲ್ಲ, ಇದು ಒಂದೇ ಒಂದು ಸೆಂಟೆನ್ಸ್. ಇದರಲ್ಲಿ ದಾವಾ ಒಳಗೆ ಹೇಳ್ತಾ ಇರೋದು 1,50,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿರೋದು for discharging the loan incurred for the marriage of the daughters. So this is a new development. 50,000 ಮ್ಯಾರೇಜ್ ಕೊಟ್ಟೆ, ಮ್ಯಾರೇಜ್ ಮಾಡಿರೋ ಸಾಲಕ್ಕೆ ತೀರುವಳಿಗೆ 1.5 ಕೇಳಿದ್ರಿ.
ಒಪ್ಕೊಂಡ್ರಲ್ಲ ಅವರು ಡ್ಯೂರಿಂಗ್ ಟ್ರಯಲ್, ಒಪ್ಕೊಂಡ್ರಲ್ಲ. D1 accepted.
No, 150 ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿಲ್ಲ.
ಮದುವೆ ಆಗಿದ್ದು ಒಪ್ಕೊಂತಾರೆ.
ಮದುವೆ ಆಗಿರೋದು ಒಬ್ಬಳ್ದು ಮಾತ್ರ ಒಪ್ಕೊಂಡಿದೀವಿ. ಸೆಕೆಂಡ್ ಡಿಪೆಂಡೆಂಟ್ ಯಂಗರ್ ಸಿಸ್ಟರ್ ಡಾಟರ್ ಗಾಟ್ ಮ್ಯಾರಿಡ್ ಅರ್ಲಿಯರ್. ಸೆಕೆಂಡ್ ಎಲ್ಡೆಸ್ಟ್ ಡಾಟರ್ದು ಮ್ಯಾರೇಜ್ ಹೇಳಿಲ್ಲ, ಒಪ್ಕೊಂಡು ಇಲ್ಲ. ದೇರ್ ಕೇಸ್ ಈಸ್ 1,50,000 ಕೂಡ ಮದುವೆ ಖರ್ಚು ಮಾಡಿರೋದು ಅಂತ. ಮತ್ತೆ ಇಲ್ಲಿ ನೀವು ಮದುವೆ ಮಾಡಿರೋ ಸಾಲ ತೀರುವಳಿಗೆ 1.5 ಕೊಡಿ ಅಂದ್ರಿ. So all that,
Go.
ಮ್ಯಾರೇಜ್ ಮಾಡಿದ್ದು ಒಪ್ಕೊಂಡಿದೆ, ಆವಾಗಲ್ಲ, ಮೇ ಜೂನ್ ಅಲ್ಲ. ನಾವು ಕೊಟ್ಟಿದ್ದೇನೆ ಮಾಡ್ಬೇಕಾ? ಇಲ್ಲ.
Yes, sir. Dictating and reserves.
Okay.
ಎಷ್ಟಿದೆ?
234 matters. Srihari.
Where is the government?
Manoj, I appear for respond. I appear for response. For 1 and 2, I appear for respondent number 1 and 2, Manoj.
1 and 2.
I did not have any transaction with realization. Section 226 of the Income Tax Act provides the authorized.
Section?
226 of Section 3 Income Tax Act.
You have called out in your repetition? This is not the roster court. Quadri. Quadri 226.
Initiated under chapter 2 of the Income Tax Act are not valid. Normally, when the chapter 2 proceedings for recovery, initiated normally when they have no resort at all to recover the money from the assessee. Only then they go beyond the assessee onto the useful third parties. This case is not clear whether chapter 2 proceedings have been initiated or not. I do not know whether the assessing order or the practical guidance. That apart, all are given in section 3. That very
Yes.
The assessing officer or the practical guidance at any time from time to time. I notice in my first something money is due or money paid due to the assessing. Or any person who votes or may subsequently vote money or any or the assessing. He takes the assessing officer working on the money revenue or any
All right, your case is that your case doesn't fall under subclause 3. Nothing to do with us.
They cannot, for the reason that the associate in respect of their pursuing, partner in that clause, ask me to pay the money.
You're not even remotely connected. Yes, sir.
Manoj, one submission. Plus, there are 3 parties. Default, Manoj, in this case.
Hey,
default
first you
is
answer
but-
is, You better answer the first question.
Manoj,
Now whether-
I'll point out from
Is
their
it by-
reply, I'll point out from their reply itself, Manoj, page 62, Annex D.
Ah.
Manoj, may I read?
Page 62.
Please. Manoj. Page 62, Annex D. This is the reply filed by them. Manoj, point number 1, as it says, I have entered into an MOU dated 11/7/2019 with Rajesh VR and Srimati Nagavalli for development and sale of sites of land situated at so and so. The details of land to be developed as per MOU are so and so. Manoj, in bottom, Manoj, in terms of MOU dated so and so, an advance of 2.8 crores was to be given. This amount is outstanding due as on date. I have no business transaction with Manoj, that is Manoj, they say Sri Vaibhav Patina Sahakara or even Vaibhav Society. Manoj, this is their statement, Manoj, there is no transaction with Manoj. The society is only a conduit, Manoj. The amount is gone from the society, but the actual transaction is between Rajesh and the petitioner herein. Only the amount is gone, Manoj, and there is, and subsequently there is one more reply filed by them, Manoj. I'll point out that also. They file a contradictory reply again at page 66, Annexure F. May I read, Manoj? Page 66, Annexure F. Manoj, in the first reply, they say, Manoj, they have no connection with Vaibhav developers.
Yes.
Manoj, and the MOU also has not been produced in this writ petition. Manoj, may I read? I have received a notice under section 226(3) of the Act regarding the payment of tax dues from.
Next line. In this connection, I have to state that in my books of account, so and so is credited as an advance received from.
Please,
Sribai.
Manoj, even in the case of Rajesh, Manoj, as on today, Manoj, it's shown as advance given to the petitioner herein, Manoj. It show in the books, Manoj, of Rajesh, who is the defaulter, it is shown as advance given, Manoj, and on the society is used only as a conduit, Manoj, for transfer of money. The actual transaction is between the petitioner and Rajesh, who is the defaulter. Manoj, assessee, Manoj, the defaulter, Manoj, has not paid 1 single rupee. Now, Manoj, we've issued this notice. Rajesh has given advance to him, Manoj, the petitioner herein. We want to recover that advance, Manoj. The petitioner herein simply wants to support the defaulter by not paying 1 single rupee. And Manoj, kindly see the Annexure G, the notice issued. It was issued on July 19th. And I don't see any urgency suddenly at today. They have not even replied to this notice.
July 19 notice.
Please, Manoj, the impugned notice, Annexure G, your lordships may kindly see the prayer. Annexure, they have not even replied. Straight away, they've come before your lordships.
Yes.
And then, Manoj, what? I'll make myself. Manoj, I'll read the Annexure G, which is impugned before your lordships. Manoj, page 86. This is the notice issued, Manoj, last and 68 Annexure G.
Yes.
Manoj, it's 70 is the relevant portion, Manoj. In contradiction to the facts already submitted by you, you have.
Where are you reading?
Manoj, page 70, starting Manoj, 3.1 para. Manoj, the first, it starts from
Yes.
para 3. In contradiction to the facts already submitted by you, you have, by submission dated 5/6/2024, claimed that certain amounts were returned on various dates before year 2022. Your aforesaid submission is not backed up by any evidence or bank transfers, but only through ledger account extracts, which is unverifiable in absence of supporting evidence. You have not submitted any bank statement showing repayment of money by you
to any of the persons. Further, you have claimed that you have received check from Shri Vaibhav Builders and Promoters. In the caption notice 226(3) of the Act, it is clearly mentioned that the amount of money owned by you to Rajesh.
Any
Nagavalli.
precipitative action is contemplated in the coming two days.
My lords, this notice is defaulted.
Sir, I've got another two, so my roster, two parted matters, we are at 4 o'clock. I'm have to hear it today. Any urgency, can't you wait till Monday?
My lords, let them file a reply to this notice. My lords,
Then why you're not replying to this? Why you straight away rush to the court? Where is the reply? Where is the reply? You can't, no need to visit the department. You have to tender your reply. Why you're not replying?
my lords, that is. My lords, they admit that they have received the advance money.
The 16/5/2024 order. You have kept quiet till now. When this was filed? Huh? Your file?
My lords, everything.
Now, no, it requires.
They have not submitted any of these documents, your lordships. In the impugned order, we've specifically asked submit all these details. They've never submitted any. Before your lordships, they come
Wait.
straight away.
He says,
My lords, we've recorded specifically in Annexure G. Your lordships may kindly see, my lords.
no, Monday, please. Sri, what's your name? Monday. List
Serial number 2.
List it. No. No.
Serial number 2,
No,
Rajesh
no.
PL.
List,
Mobilized.
Monday. No, not an urgency, sir. Yes, next, Rajeshwara. Any urgency? Why you moved it? It's only attachment. It's only attachment order. It's only attachment order, Tanya. All right, go and file the objections, seek vacation of the order. Nothing has happened, it's only attachment after award, Allah. Before, all that, what is the remedy to you then? No. No. Dispute is raised by whom?
The safety of my vendor is a period 2015. The dispute raised by one of the members of the society before.
Refer an appeal, why you come before this court? So what? Make it a ground. Make it a ground. You can't go on filing writ petition before this court. You have a remedy, efficacious remedy. What is this? And what will happen? What has happened? There is an attachment order, that's all. That's not put to sale, no. You give an undertaking and seek modification of the order. Go before the court. No. Simply because you file a writ petition, no stay, no interim orders can be. No, this is not the way to, you have a remedy, efficacy remedy. No, no, no. No, 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 not in such cases, madam, not in such cases. Not in such cases. And you know that it is appealable and you come and file a petition here. You should have advised your client to file an appeal. Yeah, provision an appeal. Nothing will happen, madam. There is no urgency. You should not have moved it at 2:30. It is an attachment order. You could have challenged it. I can understand the sale proclamation, sale, or other, I can understand. Award agilla. Huh? Yes, madam.
There is an alternative remedy.
That's all. Quarter 105, quarter no. Yeah, this is passed under what? 103 order. It violates subclause 2 of 103. Huh? Subclause 2. No. Procedural error according to
106 provision, my lord. 106.
ಏನು 106.
Appeal to the.
Allah, madam, this attachment order is passed in violation of procedure contemplated under subclause 2 of 103. Court, you have the counsel for petitioner, Leonard AG is directed to. He directed to accept notice to respond number 1. Prima facie, this court is satisfied that the attachment order passed by first respondent clearly contravenes the mandate enumerated under subsection 2 of section 103 of Karnataka Cooperative Societies Act 1959. Petitioner is aggrieved by the order as the same is not preceded by an opportunity of a show cause notice which is contemplated under subclause 2 of 103. Matter requires consideration. In that view of the matter, same is stayed till next date of hearing. Odbardu, Adre. Number 3. Issue emergency notice to 2 to 4.
Anja ready? Sir, ready?
Yes, sir. Ready, sir. Here is urgency.
Transfer certificates ಕೊಟ್ಟಿಲ್ಲ.
What is the main relief?
Main relief ಅದೇನೆ, but
ಇದು mandamus ಅಂತಿದೆ ಈಗ.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ ಲಾಸ್ಟ್ ಡೇಟ್ ಆಗೋಗುತ್ತೆ. You lost my hand summons hand delivery ಕೊಡಿ some. I will take notice to
ಯಾರಿಗದು?
2 and 3.
Under the AGA is directed to accept notice to respond number 1. Petitioner issue emergency notice to respondents 2 and 3. Simultaneously, petitioner is permitted to take notice by way of hand summons on respondents 2 and 3.
2 and 3.
Returnable by
Monday.
Monday na.
ಸರ್ವ್ ಮಾಡ್ತೀನಿ ಆಮೇಲೆ.
Monday, release this patent preliminary on.
Publish.
Number four. Four.
Petitioner, my lord, the interim measure sought is, the main relief sought is, my lord, for mandamus for the revenue and planning authorities to clear the illegal layout. My lord, even according to the revenue and planning authorities, it is a illegal layout. Multiple notices are issued by the revenue authorities, DC's office, as well as MUDA, that clear the illegal layout and as against private respondents. My lord, there is a title dispute pending between the petitioners and the private respondents. It is pending since 2016. They apply, my lord, for conversion, deemed conversion they obtain. Subsequently, rightly or wrongly, my lord, the DC cancels the conversion order. And the planning authority says they have not at all issued any sanction plan.
You moved it at 2:30.
My lord, they're building now, my lord, they're starting construction. It will prejudice 2000, my suit, my lord, title suit is pending.
Take notice.
My lord, private respondents, my lord, at least until next date of hearing, let them stop construction, my lord, because right from 2016, title suit is pending, my lord, and they suppress all this.
We don't know. It ಬಂದ್ injunction ಇಲ್ಲಿ.
My lord,
226 ಅಲ್ಲಿ injunction.
My lord, I have filed in pleading application. I have filed 39(1) and 2 before the trial court. It's still pending, my lord. Still
You
pending.
can't maintain a writ petition. What is this?
My lord, my rights in the property would
Writ
be
court
serious.
you are converted into
My lord, even,
a general court where all reliefs are sought before this
my
court.
lord, even according to the planning and revenue authorities,
A
my lord,
suit is pending.
suit is pending, my lord,
That's
no
the
doubt, my
best,
lord.
best place to seek injunction.
My lord, I filed an application, my
Then
lord,
you
they're trying to
insist-
drag on the matter, my lord. Now, my lord,
No,
my lord,
cut this.
my lord, my submissions, even according to the revenue and planning authorities, as per exhibit P1 to P3 and exhibit PQ, my lord,
You are
when
seeking
annexure, my
injunction.
lord, sorry,
You are seeking injunction, mister.
not injunction, my lord, my lord.
Not to
because-
construct ಅಂದ್ರೆ ಏನದು?
Not to change the nature of suit, my lord,
ಅದೇನದು?
as regards the,
ಏನದು? Virtually injunction.
otherwise, my lord,
And
this
your
will
suit is
frustrate
pending.
the
Is
trial.
it a
my lord.
comprehensive suit?
The comprehensive suit is filed, my lord, it is pending.
When
from
you filed the suit?
2016, my lord, they were the ones who filed it, my lord. They were the ones who filed it, private respondents.
Tenanted is directed to accept notice to respondents 1 to 5. Issue a major notice to respondents 6 to. Notice ಅಷ್ಟೇ ತಗೊಳ್ಳಿ 6 to 13.
Lord, and at least until next
ಅಷ್ಟೇ
date of hearing.
notice. Notice.
Lord, at least till next date of hearing, my lord, I have
No, no,
produced
sorry.
photographs, my lord.
No. Without examining, we can't, sir. We don't know why you are not granted
This
injunction.
date may be fixed for
2016.
consideration of interim prayer, my lord, after vacations, my lord,
Release this matter preliminary on so and so date.
for consideration of.
The question of the interim consideration of interim order will be examined on the next date of hearing.
Date may be fixed after vacations.
Date ಕೊಟ್ಟಾಯ್ತು.
Number 5, Bhanu Prakash, HV Bhanu Prakash.
Yes, sir.
For petitioner, this is election matter, cooperative, milk cooperative election matter, without my name mentioned in the voter list, they have conducted the election, election petition,
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ವೋಟರ್ಸ್?
voters 160 members, 160 members, sir.
They are not challenged to provisional list. I have already announced.
Announced.
Final list.
ಯಾವಾಗ
also
ಆಗಿದೆ ಅದು ಅನೌನ್ಸ್?
that time.
Recent, no
Recent.
notice has been given.
Even calendar of event is issued. They themselves
When the elections are scheduled?
610 members,
6:10 na?
610.
Already listed on Monday?
Why? Nomination get day after tomorrow last statement. At least permit to conduct the election, inserted my name in the.
Election ಆಗಿಲ್ಲ. You can only participate subject to what?
they are actually, their contention is administrator appointed. That case is pending before DRT. That is the reason.
DR.
DR. DR, that is the reason that they have come before the honorable court stating that they are not allowing, because as per section 28B2, they are not eligible to contest the, vote.
Why? ಏನ್ ಹೇಳ್ತದೆ 28? 28B2.
They were failure to conduct the election, my lord.
That's why we filed appeal before the DR, my lordship. Direct conduct the election anta. That is our appeal.
ಏನೀಗ ಇದಕ್ಕೂ ನೀವು ಎಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕ್ರಿ. What is the latest judgment on this point?
Idರಲ್ಲಿ general body meeting is conducted on 25/9, my lordship.
Provisional list ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿದ್ದು?
5/8, my lordship. 5/8 agri.
You are not objected. You are not challenged that.
The appeal is pending. Appeal is pending before the deputy registrar, my lord.
Now also
Then-
it is pending, my lord. Today it was posted, but they are not appeared.
ಅಲ್ಲಿ ಅಪೇರ್ ಆಗಿಲ್ಲ, ಅವ್ರು ಇಲ್ಲಿ ಅಪೇರ್ ಆಗ್ತಾ ಇದಾರೆ.
ಅಲ್ಲ ನಿನ್ನೆ ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ ಪೊಲೀಸ್ ಫೋರ್ಸ್ ತಗೊಂಡು ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಏನೋ ಪರ್ಮಿಟ್ ಟು ಕಂಡಕ್ಟ್ ದಿ ಎಲೆಕ್ಷನ್, ಮೈ ಲಾರ್ಡ್.
ಕಾಂಟೆಸ್ಟ್ ಬರಲ್ಲ. ನಾನು ವೋಟಿಂಗ್ ಅಂದ್ರೆ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್, ಸಪರೇಟ್ ಬಲಾಟ್ ಅಲ್ಲಿ ಇಟ್ಟು ಮಾಡಿ ಅಂತ ಸಬ್ಜೆಕ್ಟ್. ಟೋಟಲ್ 160
ವಿತೌಟ್ ರೀಸನ್
160 ಮೆಂಬರ್ಸ್.
ಹೌದು 147 ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರೆ ಪ್ರೀವಿಯಸ್ ಯಾರ್ಯಾರು ಮೆಂಬರ್ ಇದ್ರು ದೇ ಆರ್ ಮೆಂಬರ್ಸ್ ಲಿಸ್ಟ್
ಚಾಲೆಂಜ್ ಇಟ್ ಬೈ ವೇ ಆಫ್ ಎಲೆಕ್ಷನ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್. We will not stall the elections.
ಅಲ್ಲ ಕಂಟೆಸ್ಟಿಂಗ್ ಪರ್ಮಿಟ್ ಟು ಕಂಟೆಸ್ಟ್ ದಿ.
No. You are not eligible. You list ಅಲ್ಲಿ ಇಲ್ಲ.
ಇಲ್ಲ.
ನೋ ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ ಕಂಡಕ್ಟೆಡ್ ಸಿನ್ಸ್ ಫ್ರಮ್ 1 year, my lord.
ಅದನ್ನ ಎಲ್ಲಿಗ ಈಗ 226 ಅಲ್ಲಿ ನೋಡಕ್ಕಾಗತ್ತಾ? 28B ನಾ? Madam?
Please, my lord, 28B2.
This is a kind of disqualification.
My lord,
Disqualification, no notice has been issued, nothing.
filed an objection before the DR, my lord.
Elections are not conducted before expiry.
No,
Before expiry period of election conduct
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಅದಕ್ಕೆ they have incurred a disqualification.
Correct.
ಇವ್ರು ನಿಮ್ದು ಟೆನ್ಯೂರ್ ಯಾವ ಮುಗೀತು? You were already the office bearer.
ಹೌದು 15/7/23 ಮುಗಿತದೆ.
ಮುಗಿತದೆ.
ಹೌದು.
Law what 28B mandates that you have to conduct. GM ನೀವೇ
ಅಲ್ಲ
conduct ಮಾಡಿ.
DRS appointed administrative officer. That is the reason DRS administrative appointed administrative officer, my lord. You know, that's why he filed an appeal before the DR.
Why?
He filed an appeal on,
Within time period, the administrator is,
they have not conducted.
The expiry administrator is
ಹೌದು.
appointed. Then you have already incurred a disqualification.
No, my lord, you filed an appeal on July 9, my lord. Appeal ಸುಮ್ಮನೆ ಲಾಂಗ್ ಆಗಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. It permit to conduct the election and contest the election, madam. Voting and contest. Do not give any notice to us, which is
We can't permit you. ಈಗ ಹೆಂಗ್ permit ಮಾಡಬರ್ತದೆ?
ಅಲ್ಲ day after tomorrow nomination filing last date.
Participation I can understand, not contesting. Contesting ಬರಲ್ಲ. ನಮಗೂ ಪರ್ಮಿಟ್ ಮಾಡಿ ಟು ಪಾರ್ಟಿಸಿಪೇಟ್ ಅಂಡ್ ವೋಟ್ ಅಂದ್ರೆ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಸಪರೇಟ್ ಬ್ಯಾಲೆಟ್ ಅಲ್ಲಿ ಇಡಕ್ಕೆ ಕೇಳ್ಬೋದು.
ಅಲ್ಲ it is a right of the Guardian without notice, my lord.
No, we can't permit you to contest.
Okay, committees how can you conduct the, my lord?
ಆಯ್ತು, ಅದನ್ನ
The
election
administrative officer is appointed, they are duties.
ಅದಕ್ಕೆ
That's why he filed
ಅದಕ್ಕೆ ಎಲೆಕ್ಷನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಹಾಕೊಳ್ರಿ. ಐ ಪರ್ಮಿಟ್ ಯು ಟು ಕಾಸ್ಟ್ ವೋಟ್. ಅದು ಬರಲ್ಲ ಈಗ, ಡಿಸ್ಕ್ವಾಲಿಫೈಡ್ ಅಲ್ಲ. ಅದನ್ನ ಮಾಡ್ಬೋದು, ಸಪರೇಟ್ ಬ್ಯಾಲೆಟ್ ಮಾಡಿ. ಟೋಟಲ್ 160 ಅಲ್ಲ, 160ದಲ್ಲಿ ಇವ್ರು ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? ಎಲ್ಲ ಆಫೀಸ್ ಬೇರರ್ಸ್ ನೀವು?
ಹೌದು 5 ಜನ ಇರೋದ್ರಿಂದ ಆಯ್ತು 5 members.
ಏನ್ ಇದು ಸರಿ ನೀವೇ ಕಂಟ್ರೋಲ್ ಮಾಡಿ ಇಡ್ಬೇಕಂತಿದ್ಯಾ?
ಅಲ್ಲ ಆ ತರ ಯು ಆರ್ ಕಂಟೆಸ್ಟಿಂಗ್ ಎಲೆಕ್ಷನ್, ವೋಟ್ ಯಾರು ಆಗ್ತಾರೆ ವಿನ್ ಆದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಸರ್.
I'll permit you to cast vote if you want. Otherwise, just notice. ಯಾರು ಏನ್ ಬೇಕು? ಅದ್ ಮಾಡ್ಬೋದಾ? ಸಪರೇಟ್ ಬ್ಯಾಲೆಟ್ ಅಲ್ಲಿ ಇಟ್ಬಿಡಿ, ಮತ್ತಿನ್ನೇನ್ ಮಾಡೋದು? And if that differential is if the less than margin ಇದ್ರೆ then it becomes inconsequential. ಮಾಡ್ಬೋದಾ? ಏನ್ರಿ?
ಅಲ್ಲ ವೋಟಿಂಗ್ ಕೊಟ್ಟ ಮೇಲೆ ಎಲೆಕ್ಷನ್ ಕಂಟೆಸ್ಟ್ ಮಾಡಕ್ಕೆ ಪರ್ಮಿಷನ್
ಅದಕ್ಕೆ ಬೇಡ ಬರ್ಕೊಡಿ. Leonard is directed to accept notice to respondents 1 and 2 na vote permission. Issue emergency notice to respondents 3 to 5. The elections scheduled on your date 6/10 will be subject to outcome of the writ petitions.
ಅಲ್ಲ voting for our
ಬೇಡ. Next.
Otherwise Monday ಮೇಲೆ
ಮಾತಾಡ್ ಕರೆಯಿಲ್ಲ. These two serial number.
and ಸಮಸ್ಯೆ ಮಂಡೆಗೆ ಇದೆ ಸರ್.
All right, Monday ಹಾಕ್ರಿ ನೋಡೋಣ.
Issue and summons to Monday.
Emergency notice and bidding. Petitioner is permitted to take notice by way of hand summons to private respondents, returnable by Monday, list it in implementing on Monday. Yes, madam.
Yes. I appear for respondents 3 to 9 in this.
3 to 9.
3 to 9. They are the.
ಹೌದು ಇವತ್ತು ಆಗಲ್ಲ, you need not wait. Monday, Tuesday ಆಗಲ್ವಾ? ಎಲ್ಲಿ ಸಂಪತ್? Monday? Monday 2:30.
Serial number 10, sorry. Last one.
ನಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ, ಬರ್ಬೇಕಷ್ಟೇ. ಕೇಸ್ ಕರೆದ್ರೆ ಒಂದೇ.
I was here, sir.
ಅವ್ರು ಬರ್ತಾರೆ, ಅವ್ರು ಕಲಬುರ್ಗಿ ಬರ್ತಾರೆ ಅನ್ಸುತ್ತೆ, ಅವ್ರ ಜೊತೆ ನೀವು ಬಂದ್ಬಿಡಿ. ಮಾತಾಡೋದ್ ತಗೊಂಡಿದ್ದೀನಿ ನಾನು, ಇಲ್ಲ
ನಾನು ಆಲ್ರೆಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೀನಿ, ಡೀಟೇಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ತದೆ, ಅರ್ಧ ಜನಕ್ಕೆ
ಪಾಟರ್ನ್ ಮಾಡಿ ಇಡಿ ಸಮ್ ಆರ್ಡರ್ ವಿಲ್ ಪಾಟರ್ನ್, ಇಟ್ ಇಸ್ ಟ್ರೀಟೆಡ್ as ಪಾಟರ್ನ್. Tomorrow virtually I'm not sitting. Monday, Tuesday, we have only 2 days on hand and. Pardon. Pardon. Respondents, madam, 3 to 9.
3 to 9.
3 to 9.
The prayer sought in this writ petition at page 17, my lords. Issue a writ of certiorari quashing the order of the land tribunal, respondent number 2, in LRF number 1 of 7980, dated 13/7/1982. The writ petition is filed in the year 2016.
2016. Land tribunal order is dated
13/7/1982.
13/7/1982.
After a lapse of more than 34 years.
Yes, madam.
Now, I would like to take your lordship to the order in LRF 1 of 7980 dated 13/7/1982. The chairman and members are present, and Munyappa alias Doomanna is the petitioner.
Where you find it? Page number?
Page 46 from
Page
of
40.
yes, of the writ petition, my lords. Oh, I'm sorry.
Yes.
I'm sorry. Twenty-eight of the writ petition, my lords. Page 28, annexure B.
Page 38 and
It's a handwritten order.
Also,
38.
handwritten order.
38 typed copy.
Typed
Page 38.
order. The typed copy is there, madam.
Yes, my lords. The first, the petitioner is Munyappa alias Doomanna. The
Yes.
first respondent is Muniswamappa, son of Doomanna. Muniswamappa R2 is Hemanna, son of Muniventa. R2, the LS of R2 are before your lordship in this writ petition.
This is the order under challenge now?
Yes.
Yes.
I would like to take your lordship to the entire order because this is the base of the. On 17/1/1979, the petitioner filed an application in Forum 7 praying registration of occupancy rights under Section 48A of the Karnataka Land Reforms Act 1961 as amended in respect of 2 acres 8 guntas in survey number 6 and 1 acre in survey number 4 of Satnur village, Jalahobli, Devnalli Taluk. He has impleaded first respondent Muniswamappa as landlord. His application was accompanied by an affidavit to condone the delay in filing the application. Subsequently, on 4/7/1979, the petitioner filed one more application to implead the second respondent, Hemanna. He has been impleaded on 4/7/1979.
Yes.
As party to the proceedings and to proceed with the case. Again, on 12/7/1979, third petition was filed seeking orders of the tribunal under Section 48C of the Act, requesting the tribunal to issue orders of temporary injunction, restraining the second respondent, Hemanna, from interfering with his peaceful pursuit and enjoyment of these lands. In support of his claim, he had produced extract from the RTC pertaining to the survey numbers claim. Individual and public notices were served and published in the village. And on the respective parties, in response to this, the petitioner and the respondent Hemanna appeared before the tribunal on 12/7/1979. The tribunal recorded the statements and examined the certified copies of RTC produced by the petitioner for the year 68/69 to 78/79 and took decision to appoint the revenue inspector Jalahobli to be receiver of these lands under Section 48C1 of KLR Act. Notice to first respondent could not be served. This is important, my lords, as his whereabouts were unknown to the tribunal. Because this
I've
is
already marked it.
yes,
I have marked it. Your father.
that's it.
Your father has gone missing.
Yes, he's gone missing at the day to this one. Since 69, he's gone missing and that is the evidence on record. Agreed by the orders of the land tribunal, the second respondent Hemanna filed writ petition number 12045 of 79 before the Honorable High Court of Karnataka. The Honorable High Court in the writ petition 12045 of dated 6/11/1979 was pleased to modify the orders of the tribunal and appointed second respondent Hemanna himself as the interim receiver of these lands till the disposal of application filed in forum number 7 by the petitioner Sri Dumanna with the directions to deposit the value of crops after deducting all expenses incurred by getting necessary instructions from the tribunal from time to time in the management of these lands. The second respondent thereafter is continued to be the interim receiver of these lands under the orders of the Honorable High Court of Karnataka. The lands are now in possession of the second respondent. The tribunal proceeded to conduct inquiries on 11/12/80. The second respondent, Hemanna, filed his written statement. He has stated that he is the owner in possession of the lands claimed by the petitioner. He admitted that these lands originally belonged to the first respondent, Muniswamappa, who is none other than the father of the petitioner. He has admitted that according to partition among the petitioner and his brothers and his father, the lands in question fell to the share of the petitioner's father, Muniswamappa. The said Muniswamappa borrowed 2 items of loan from Primary Land Development Bank, Devnalli, on 13/8/65 and on 29/11/65 on the security of these lands and became the defaulter. In order to realize these two items of loans, these lands were brought to sale and put in auction on 17/4/1978 by the PLD Bank, Devnalli, and the respondent Hemanna got these lands as the highest bidder in public auction. The sale was also confirmed by the Assistant Registrar of the Cooperative Societies, Doblapura, on 12/12/78, and the fact was also notified in the Gazette dated 28/12/78. He further states that he has been in possession of these lands ever since the date of sale from 28/12/1978. Earlier, he has been appointed as the interim receiver only by this honorable court on 6/11/1979. Here he says he has been put in possession under the sale deed dated 28/12/78. The respondent, that for the reasons quoted in his written statement, requested the tribunal to dismiss the prayer of the petitioner in the instrument. On 23/12/81, the petitioner filed his written statement stating that these lands bearing survey number 4 and 6 of Satnur originally belonged to the joint family of the petitioner, his father Muniswamappa, first respondent, and his brothers Avlappa and Chinnappa. There was a partition of these lands on 7/9/1965 anta ide Swamidu. The document is produced by the petitioners. It is 1955. The document is
7/9/1955.
55. They have filed a set of additional documents
Yes.
on 28/11/2016. And partition deed, which is a registered partition deed of the year 1955, is produced at page 44 of the additional set of documents produced by the petitioners.
So you admit that these are ancestral property?
Ancestral and divided.
Correct,
Division has taken place here.
correct.
And I would like to take your lordship to whether a petition by forum number 7 by a son against the father is maintainable is the point that happened. Yes. The definition under the Land Reforms Act, Section 212,
Family.
Family minor sons and unmarried daughters, and of course the husband and wife.
Code, Land Reforms Act.
I would. Family. In the case of an individual who has a spouse or spouses, such individual, the spouse or spouses, and their minor sons and unmarried daughters, if any. And there is also a judgment of this honorable court definition, section 212 ಬರೆಸ್ತೀನಿ.
Yes.
So it is only spouses, the individual spouse or spouses, and their minor sons and unmarried daughters.
This definition is in context of a tenant's family or a landlord's family?
ಯಾವುದಕ್ಕೂ ಇಲ್ಲ ಅಂತಾನೆ ಇದೆ ಸ್ವಾಮಿ. There is no definition with regard to whether
It is in context of a tenant's family,
tenancy. Tenants.
not a landlord.
ಇಲ್ಲ landlord ಅಲ್ಲ, because Land Reforms Act tenancy.
By applying, madam, by applying this definition,
Yes.
you want to exclude a son of a joint family, a landlord's family. Can you exclude by applying this definition?
Yes, because the tenancy is in respect of the land.
Now,
If I file forum number 7,
you're trying to lay a foundation on the ground that son in this case is a major son. Therefore, he doesn't become a part of a family as defined under section 212.
yes,
And therefore, he's an outsider.
not an outsider.
The
There has
context
been
of 212.
partition. There has been partition.
Partition, yes.
Yes, partition, and there is division, and therefore the son can maintain
No,
a petition.
partition is between his father and his uncles.
No. Even the petitioner,
He is also.
his father, his brothers, and the petitioner. Petitioner is a part of the partition.
He is allotted some of the land.
Yes, some other land, and these 2 lands were allotted to his father.
And when the lease, when he was inducted as a tenant?
After 2-3 years, anta order bandide some. Very same order that.
No, what is the date of when he was form number
After
7?
partition,
Let us
he
see
cultivated. Yes, ma'am.
form number 7. We'll see your form.
Forum number 7. Yes, my lords. ಇಲ್ಲಿದೆ. The very same set of documents furnished by the other side.
Yes, where is the form?
Dated 28/11/2016 ಅಲ್ಲಿ one set of documents ಹಾಕಿದ್ದಾರೆ, additional documents. ಅದರಲ್ಲಿ
Record Silva. Form number 7.
page 12 and 13 ಇದೆ. 11 and 12.
Only one land, madam?
2 lands.
2 lands.
2 lands. And not the entire. One survey number is the entire extent 2 acres, 8 guntas. Another, only 1 acre out of 3 acres, 21 guntas. The remaining land, 2 acres, 21 guntas, are in the possession of the petitioners. They have purchased that land also under the very same auction. And they are in, even today, they are in possession. That is
They are
not,
in possession.
yes,
They are-
that is not challenged.
Form number 10.
Forum number 7 ಅಂತ ಇದೆ ಸ್ವಾಮಿ ನಮಗೆ ಕೊಟ್ಟಿರೋದು.
Yes. Let us see RTC. RTC is from 1956 to 74.
56 ಇಂದ ಇಲ್ಲ ಬರಲ್ಲ ಸ್ವಾಮಿ. It's only after 68 RTCs.
ಯಾಕೆ?
ಅಲ್ಲಿಗೆ ಮುಂಚೆ RTCs ಬರ್ತಾರೆ.
ಎಲ್ಲಿ?
68 ಇಂದ onwards RTC. That is also furnished. And
ಶಾಸ್ತ್ರಿ ಸರ್,
Series I have. Annexure V series I have
ಇಲ್ಲ
produced.
ಬಟ್ ಇಲ್ಲಿ RTC ಇಲ್ವಾ?
RTC
ಇಲ್ಲಿರ್ಲಿಲ್ವಾ?
ಇದೆ.
ನಮ್ ಕಡೆ ಇದೆ ಅಪ್ ಟು 15 ಸಿಗತ್ತೆ ನಮ್ ಕಡೆ.
15
ಸರ್ ನಿಮ್ಮಲ್ಲಿರುವಷ್ಟು ಇಲ್ಲಿ ಸಿಗಲ್ಲ ಸರ್.
ಸಿಗಲ್ಲ.
ಆದ್ರೆ ಇಲ್ಲಿ
68
ಮಂಗಳೂರಲ್ಲಿ ಏನೂ ಸಿಗೋದಿಲ್ಲ. ರೈಟ್, ಮಂಗಳೂರು ಕಡೆ ಆದ್ರೆ 69 ಇಂದ ಅಷ್ಟೇ ಸಿಗುತ್ತೆ. ಅದು ಎಷ್ಟು 3 yearsಗೆ. ಆಮೇಲೆ 81 ಇಂದ ಸಿಗುತ್ತೆ. ಇವಾಗ ರೆಗ್ಯುಲರ್ ಆಗಿ ಮಾಡ್ತಾರೆ. ಇಲ್ಲಿ ಬಟ್ ಇಲ್ಲಿ ಬೆಟರ್. ಬ್ಯಾಂಗ್ಳೂರ್, ಓಲ್ಡ್ ಮೈಸೂರು ಇಸ್ ಬೆಟರ್. ವಿ ಗೆಟ್ ಓಲ್ಡ್ ರೆಕಾರ್ಡ್ಸ್.
All right, we'll see 1374 ನೋಡೋಣ.
From 68-69 I have
68-69 ಇಂದಾನೇ ಇದೆ. And Dumana name is shown in both, in respect of both the survey numbers.
No, what is the mode of cultivation?
self. ಸ್ವಂತ ಇದೆ. Do.
Because there is no written lease, madam.
ಹೌದು.
Huh?
ಹೌದು.
Where? ಎಲ್ಲಿದೆ? Mode of cultivation ಏನಿದೆ? ಡುಮ್ಮಣ್ಣ ಯಾರು?
Dumana is the petitioner who has filed forum number 7. His father is Muniswamappa. Pitrarjita Muniswamappa anta.
Yes, madam.
So ever since 1968-69, his name is shown
in respect of 1 acre in respect of one survey number and 2 acres, 8 guntas in respect of the other survey number. And I'm not claiming the entire property because it has gone to my brothers. And that is also purchased by the petitioners under the very same auction purchase. And that is not challenged.
ಯಾವುದು?
2 acres, 21 guntas. ಅದು ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಲಿಲ್ಲ. And it has remained with the petitioners, purchased under the. But nevertheless, the sale certificate is set aside. Award is set aside.
Award is set aside, but
Yes.
not sale certificate.
Award is set aside, and consequently the sale certificate goes.
They have not challenged it.
That's not challenged. Now, I would like to take your lordship to the 60 and took decision to appoint revenue inspector Jala Hobli to be there. Notice to first respondent could not be served, and I have taken your lordship to the entire. The lands are now in the possession of the second respondent. The tribunal proceeded to conduct inquiries, and that paragraph is also covered. In order to realize these two items of loans, these lands were brought to sale and put to auction on 17/4/78 by the PLD Bank, Devnahalli. And the respondent Hemanna got these lands as highest bidder in public. The sale was also confirmed by the Assistant Registrar of Cooperative Societies, Doddaballapura, on 12/12/78. And the fact was also notified in the Gazette on 28/12/78. He further says that he has been in possession of these lands ever since the date of sale from 28/12/78. The respondent, that for the reasons quoted in his written statement, requests the tribunal to dismiss the prayer of the petitioner in the interest of. On 23/2/81, the petitioner filed his written statement stating that these lands bearing survey number 4 and 6 of originally belonged to the joint family of the petitioner, his father Muniswamappa, and his brothers Avlappa and Chinnappa. There was a partition of these lands on 7/9/55 amongst his co-partners, including the petitioner. And this fact is proved by the partition deed registered in the office of the sub-registrar Devnahalli on 7/9/55. The first respondent, the father of the petitioner, after partition of the lands claimed by the petitioner in this case, were cultivated by the first respondent for 2 years. This is where he cultivated after partition only for 2 years. And thereafter expressed his inability to cultivate them personally due to his old age, and leased these lands to the petitioner Dhumanna for Vara cultivation. The extent of land that was leased to the petitioner was 2 acres, 8 guntas, and in survey number 6, and 1 acre in survey number 4 of Satnur Way. These lands were being cultivated for the past 23 years by the petitioner uninterruptedly and as tenant under the first respondent. The alleged purchase of these lands by the second respondent Hemanna in a sale conducted without the petitioner, because he was not, his whereabouts were not known after 1969. And he was not, there was no service of notice with regard to the auction sale to the first respondent. Without the petitioner being made party to the proceedings, the sale held by the sale officer by the Primary Land Development Bank Devnahalli on 17/4/78 and the execution proceedings taken in this case by the authorities of the Cooperative Department therefore do not bind the petitioner. The petitioner has denied having made over possession of this land to the respondent too in consequence to the execution proceedings. He has further submitted that under the provisions of Karnataka Cooperative Societies Act, it is mandatory that he should obtain possession through the deputy commissioner, because this was the tenanted land. 89 of the Cooperative Societies Act demands that the possession has to be delivered by the DC, Deputy Commissioner of the district, observing the required formalities contemplated in section 89C2B of the said act. Thus, he clarifies that the possession of these properties were never made over to the second respondent who claims having taken possession of these lands. He accepts that the respondent too is in possession of the lands by virtue of the orders of the Honorable High Court in WP number 12045 dated 6/11/1979, appointing him as interim receiver till disposal of application filed under Section 48 of KLR Act. The petitioner further averred in his statement that these lands were in his possession actually cultivating as Vara tenant under the respondent, and at present his whereabouts are not known. He has in addition stated, since the first respondent is none other than his father, he was not obtaining any receipts for having delivered the grain. He added the award passed by the arbitrator of the Cooperative Society in respect of these lands in dispute number 73 of 73/4 has been set aside by the KAT in appeal number 544. So that order has been set aside. The sale certificate, the award, has been set aside in the appeal 544 of 1979 dated 11/7/1980, manus. And it is also admitted yes. He has also furnished the certified copy of the said order in appeal for the perusal of the tribunal. He has also stated that his right as tenant would sustain under the provisions of Karnataka Land Reforms Act 1961, and the respondent too, who claims his right as purchaser by virtue of sale, would be entitled only to the occupancy price for the land earned under auction sale if the same is sustained. The petitioner has also filed a certified copy of the order passed by the principal civil judge in MA number, where the prayer of the petitioner, Dumanna alias Munishamappa, for an injunction against the respondent is dismissed as the civil court is barred with the jurisdiction of deciding the tenancy matter. The petitioner has mainly contended that second respondent Hemana has no right on the land as the sale conducted by the PLD bank authorities is set aside by the Karnataka Appellate Tribunal in appeal number 544 of 79 dated 11/7/80. He also averred that the provisions of Section 89C2B of the Karnataka Cooperative Societies Act 1959, which reads as under, have not been complied with by the cooperative department. This is not complied. And the 89C is extracted in the order. On perusal of the evidence adduced by the petitioner, the tribunal felt that the petitioner was in possession and enjoyment of the lands in question as tenant under the first respondent, even if the bank authority sold the lands in public auction to realize the loan amount due to these lands. The tenancy rights do exist on these lands, and the purchaser is entitled to get only the compensation payable on the said lands if the sale is sustained. In other words, the bank authorities have no right to sell away the tenancy rights existing on the lands, as it is absolutely vested with government as on, that is Section 44 of the Land Reforms Act. Vesting takes place as early as 1/3/1974 when the amendment was brought into force. Now, the order says because it has vested as on 1/3/1974, the PLD bank had no powers to auction, to sell the property under auction, and therefore all the proceedings are void. Thus, the lands in question are tenanted lands on the said land, said date. The petitioner is to be registered as an occupant. These lands under Section 5 of the Karnataka Land Reforms Act 19 amended. Therefore, the tribunal is of the unanimous opinion to register the petitioner, Dumanna alias Munishamappa, as an occupant of the said lands. It is therefore ordered to register the petitioner, Dumanna alias Munishamappa, as an occupant over 1 acre in survey number 4 and 2 acres 8 kuntas in survey number 6 of Satnur village, Jala Hobli, Devnali Taluk, under Section 45 of the Karnataka Land Reforms Act 1961 amended, subject to payment of premium. It is further ordered to pay the entire amount deposited by the second respondent to the petitioner, being the value of crop raised by the second respondent as interim receiver of these lands, because he was the interim receiver during the pendency of forum number 7. Therefore, the order, under the order, he is directed to deposit. Now, this order was challenged before this honorable court in WP number 28672 of 1982.
This order was set aside?
Yes, my lords.
This order was set aside by this court.
By the writ petition, in the writ petition by this honorable court, writ appeal was filed and the writ petition order was set aside.
Set aside.
Set aside. That is also the next document, Annexure C. Annexure C is the writ petition order by Justice Bopanna at page 46 form.
Yes.
In the circumstances, para 3, last paragraph of the order, this petition is allowed the impugned order as also the order, if any, made on 13/7/82 in LRF number quashed and the matter is remitted to the land tribunal for fresh disposal of the application of respondent 1 after holding a fresh inquiry. Since the petitioner has been appointed as a receiver of the land in terms of the interim order of this court, he shall continue to act as such till the disposal, till the parties obtain a fresh order from the tribunal. This is the order of the in the writ petition, which was again challenged by Muniappa alias Zumanna at page 52 is the order of the writ appeal 667 of 1985. This is the division bench order. Here, even in the writ proceedings, very same Ramachandra advocate for petitioner is shown in the cause title of the order. And even in the writ appeal, very same Ramachandra for R1.
Yes, ma'am.
And here, the operative portion of the order, page 3. In the result, the writ appeal is allowed. The order made in writ petition 28672 of 82 is set aside. The writ record stands transferred to the appellate authority constituted for Bangalore Rural District to treat it as an appeal presented against the orders of the land tribunal and to dispose of the same in accordance with law, after affording an opportunity to both the parties to adduce additional evidence if need be and of being heard. The parties are directed to appear before the appellate tribunal, appellate authority on 1/6/1987. And further, it was extended on the next page. The party shall appear before the appellate authority on 14 September 1987. Thereafter, in 1990, the appellate authority was abolished. And the CP had to be filed before this honorable court. That's how the petitioner.
Why the CP is listed before division bench in this case?
Division bench.
Then
Then it
that
was.
was the procedure.
Yes.
That was the procedure.
Yes, ma'am.
Then that was the
Yes.
procedure, my lord.
No, single judgment the CP ಹಾಕಿ convert ಮಾಡ್ಕೊತಿದ್ರಲ್ಲ.
ಇಲ್ಲ. Division bench.
ಆವಾಗ ಅದನ್ನೇ ಅದು ಬಹುಶಃ ಅಪೀಲ್ ಹಾಕಬಾರ್ದು
Yeah, I'm
ಮಾಡಿದ್ರು.
I we have appealed in good number of cases. CPs were converted. into
Initially, as your lordship's correct, initially,
the single judgment ಬರ್ತಿತ್ತಲ್ಲ.
initially it was single judge.
Or
But
then
later some policy, I don't know, it was
they were all
being
listed
placed before the, probably to prevent appeal or something like that. Number of appeals from
ಇಲ್ಲ,
Writ
ಅದು
again.
ಬರಲ್ಲ. ಅದು for limited purpose ಅದು. Only for conversion ಅದು.
ಈಗ ಯಾತಕ್ಕೆ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ ನನ್ಗೂ ನೆನಪರಲ್ಲ.
ಅಲ್ಲ, but ಅಲ್ಲ CP ಅದು convert ಆದ್ರೆ those writs were heard by division bench.
Yes.
Division bench.
Yes, the order is made by a division bench.
ಹೌದೌದು.
That is exactly what I would like to bring the,
But order passed by LRRA was amenable to writ jurisdiction or writ appeal?
CRP revision jurisdiction.
ಅಲ್ಲಿ single judge.
ಅಲ್ಲಿ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಅಲ್ಲಿ ಸಿಂಗಲ್
ಸಿಪಿ ಹಾಕಿ ಇದನ್ನ ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೋಗ್ಬಿಡ್ತು.
ಅದು ಯಾಕೆ ಮಾಡಿದ್ರು ನನ್ಗೂ ನೆನ್ಪರ್ತಾ ಇಲ್ಲ ಇವಾಗ.
So then you lost one right of appeal.
ಸಿಸ್ಟಮ್ ಇತ್ತು.
ಹೌದು.
ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ರಾಜೇಂದ್ರ ಬಾಬು ಮಿರ್ಜಿ ಅವರು
ಹೌದು.
ಕ್ಲಿಯರ್ ಮಾಡಿ ಮಾಡ್ತಾ ಇರೋ ಡಿವಿಷನ್ ಬೆಂಚ್. ಐ ಥಿಂಕ್ ಸಮ್ ನೋಟಿಫಿಕೇಶನ್ ಹ್ಯಾವ್ ಬೀನ್ ಇಶ್ಯೂಡ್.
Notification was issued, all spending CPs.
ತಂದೆ ಅಲ್ಲ, ಈ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಇತ್ತಲ್ಲ, ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಪವರ್ assigned to the learner single judge was withdrawn and it was assigned to the division. Land acquisition matters ಹಾಗೆ ಆಗಿತ್ತು, land records matters ಆ ತರ ಆಗಿತ್ತು.
All right, you can continue, madam. Monday.
Yes,
Monday ಮಾಡ್ತೀರಾ? Continue on Monday.
yes,
Monday and Tuesday we'll see.
yes,
Conclude or we'll take it as partial and we'll hear it.
yes.
ಇಲ್ಲ ಶಾಸ್ತ್ರಿ ಸರ್, ಅವಾರ್ಡು ಚಾಲೆಂಜ್ ಮಾಡಲ್ಲ. ಇಲ್ಲಿ 34 ವರ್ಷ ಆದ್ಮೇಲೆ ಅವು ಅದ್ ಬಿಟ್ಟು ಇನ್ನೊಂದ್ ರಿಟ್ಟು.
ಸರಿ ಇಲ್ಲ, ಒಂದ್ ದಿವ್ಸನೂ ನಾನು ಸುಮ್ಮನೆ ಇದ್ದಿಲ್ವಲ್ಲ, ಒಂದ್ ದಿವ್ಸನೂ ನಾನು ಡಿಫೆಂಡ್ ಮಾಡದೆ ಬಿಟ್ಟಿಲ್ಲಲ್ಲ. ಓನ್ಲಿ ಮಿಸ್ಟೇಕ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ ಆರ್ ಡಿಫಾಲ್ಟ್ ವಾಸ್ ನಾಟ್.
ಎಲ್ಲಿ ಡಿಫೆಂಡ್ ಮಾಡ್ತಾ ಇದ್ರಿ ನೀವು? Award, you have some, that award is staring at you. You have not challenged that award.
Yes.
No, award is not against me. It is against the municipal. Order of the award in cooperative proceedings is against the father of the present petitioner, applicant Dumanna.
Correct. That award was set aside.
Award was set aside after 1979. The daughters file an appeal 554 of 79 stating that we are not divided. We are joint family members. I have rights over the property. And on that ground, it is remanded. I am not a party.
You are not a part.
I am not impleted. That's fair, my lord. I say fraud is there. That is.
I want view of the order passed by Honorable Justice Shailendra Kumar. There he declared that the transaction of mortgage and auction, it's a voided transaction after vesting.
Adana,
Then that
please read it once again. We'll see.
That finding is
I
confirmed
think
by the
you
division.
both together in Shastri's absence, probably you read that order.
yes, my lords. Very
Because
first,
the order was
yes,
the
very
first-
first
on the
day.
first day, I said then nothing more to be looked into. That was the impression.
On arising out of the same issue,
All right,
now
well,
one
let's-
more writ appeal is pending before the division bench at my instance on behalf of the present respondent.
Respondents.
ನಾನು ಹಾಕಿದ್ದೀನಿ ಮೊನ್ನೆ
ಅವರ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. ಅಂದ್ರೆ ಇನ್ನೂ ಕೇಸ್ಗಳಿದೆ ನಮ್ದು ಹಿಂಗನೆ ಗುದ್ದಾಟ. ಅದು ಇನ್ನೊಂದು ರೌಂಡ್ ಲಿಟಿಗೇಷನ್ ಬೇರೆ.
ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಆರ್ ಕನ್ಸರ್ನ್.
ಅದ್ರ ಮೇಲೆ ರಿಟಪಿಲ್ಲ.
ಅವರು they are trying to get their name entered, which my client is
Trying to-
resisting.
yes, ma'am.
That is all.
Our name was.
They want to get into possession, they can't get into possession because possession is delivered through lawful mode. And I have continued, I was also receiver. And then RTC is transferred to my name. I am not allowing my right to get the RTC change. That is the proceedings.
You know, section 5,
I don't.
ಈಗ you want them to file a section 5 suit.
Though, yeah, probably, I don't know.
ಅಷ್ಟೇ 5 suit ಅಲ್ಲ, ಅದ್ ಬಿಟ್ರಿ ನೀವು.
ಅಲ್ಲ ನಾನ್ ಹೇಳಿದರೆ ಈ ಲಾಜಿಕ್ ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ ಬಿಟ್ರೆ ಯಾರು ಅಡ್ರೆಸ್.
ರಾಜಗೋಪಾಲ್ ನನ್ನನ್ನು ಚುಡಾಯಿಸೋದು ಬಿಡಲ್ಲ ಸರ್ ಅವರು. ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಆದ್ರು, ನಾವು ಫ್ರೆಂಡ್ಸ್ ಒಟ್ಟಿಗೆ ಬೆಳೆದಿದೀವಿ. ಅವ್ರು ಡೆಸಿಗ್ನೇಟೆಡ್ ಸೀನಿಯರ್ ಆದ್ರೂ ನನ್ನನ್ನು ಚುಡಾಯಿಸೋದು ಬಿಡದಿಲ್ಲ ಅವರು.
He has already put a caveat. He says that you are his good friend. So why the court should get between two friends?
ಒಂದ್ ಸಾರಿ one matter I have argued before Mohan Shantan Gowda, Andhra Pradesh. ಅವರು ಒಂದು 10 ನಿಮಿಷ ಆದ್ಮೇಲೆ he put me a question. ರಾಜಗೋಪಾಲ್, I wanted to ask one clarification. ಅಂದ್ರೆ ಏನು ನಿನಗೆ ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿಗೆ ಇಂಥ ಮ್ಯಾಟ್ರ್ ಬಿಟ್ಟು ಬೇರೆ ಬರಲ್ಲ. ನಾನು ಹೇಳಿದೆ ನಾವು ಹಣೆ ಬರ ಇದ್ದೆ. ಕಡೆಗೆ he only said that ಇದು ಹೆಂಗಾಗುತ್ತೆ ಅಂದ್ರೆ ಏನೂ ಆಗಲ್ಲ ಅಂತ ಫೈಲ್ ತಗೊಂಡು ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ನಲ್ಲಿ ಕೂತಿರ್ತಾನೆ. ಅವ್ರ ಪಕ್ಕದಲ್ಲಿ ಯಾರೋ ನಿಮ್ ಪರಿಚಯ ಇರೋರು ಕೂತ್ಕೊಂಡು ಅಲ್ಲಿ ಯಾಕೆ ಹೋಗ್ತೀವಿ, ಅವ್ರ ಇಬ್ರ ಹತ್ರ ಹೋಗು ಏನಾರ ಒಂದ್ ಮಾಡ್ತಾರೆ. ನೀವ್ ತಗೊಂಡ್ ಏನಾರ ಕಷ್ಟ ಪಟ್ಕೊಳ್ಳಿ, ನನಗೆ ಯಾಕೆ ರಿಸ್ಕ್ ಕೊಡ್ತೀರ ಅಂತ.
Correct ಹೇಳಿದಾರೆ.
It was the way it was happened in the open court.
We'll sit on Monday.
Yes, ma'am.
Can continue, madam.
Yes.
I think better to read that order once again.
Yes, ma'am.
Once you read that order, then you can cover up with the
I
document.
have to cover also the KAT order
Yes, ma'am.
under which the sale was set aside.
Ah,
Really,
he
as a
said-
cover.
Shastri sir says that only award was set aside. Your argument is that consequentially,
Once the award
Sale.
is set aside,
then yes,
the
how to read
sale
it?
automatically goes.
No, no, but please examine it
Yes,
because
ma'am.
yes, cited the apex court judgment directly on that point. It says that there a decree is set aside. Apex court says that doesn't affect the sale and sale certificate.
Yes, that is
So get the
under
counter,
EP
Raj Gopal sir.
proceedings. Agwatsan.
please. You have to get the counter to that
Yes,
and then you read the judgment also.
yes.
Think,
Yes, sir. Yes,
my,
Tomorrow.
I think my colleague is more effective than me. I may not, my presence may not be necessary. I'm
Be here.
We need it, sir.
grateful. Others matter, cell number 23. Basuraju.
LR applications are allowed, my lord. I will amend the cast rate.
ಹೌದಾ ಯಾವ್ದು ಒಂದ್ ನಿಮಿಷ
23.
ಎಲ್ಲಿದ್ದೀರಿ ಗಿರಿ?
ಅದ್ರಲ್ಲಿ ನಮ್ಗೆ ಇದು ವಕಾಲತ್ ಬಂದಿಲ್ಲ ಎಲ್ಲ
ಅಲ್ಲ, LR
ನಾವು
application ಅಲೋ ಆಗೋಗಿದೆ.
ನಮ್ಗೆ ವಕಾಲತ್ತು ಇನ್ನೂ ಬಂದಿಲ್ಲ ಎಲ್ಲರದ್ದು.
ಇನ್ನೂ ಬಂದಿಲ್ಲ. ಯು ವಾಂಟ್ ಟೈಮ್?
ಇಲ್ಲ, ನಾನು ಅಮೆಂಡ್ ಮಾಡ್ಬಿಡ್ತೀನಿ, ಅವರು
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ.
ಅಲ್ಲ, you undertook, Nagbhushan sir, you undertook to file wakalat.
ಹೌದು.
You undertook to file wakalat.
ವಕಾಲತ್ ಬಂದಿಲ್ಲ, ತಂದ್ಕೊಟ್ಟಿಲ್ಲ.
All right, but those applications are allowed now?
ಅಲೌಡ್.
Allowed, huh?
ಹೌದು.
You have to amend the cost.
Yes, yes.
All right, finally 2 weeks time to amend the cost.
Much of.
Cell number 24.
24.
Ms. Som Reddy. Wait, please.
No, wait.
Cell number 25.
Memo for repeating. death.
Filed a memo for reporting death of GP holder.
GP holder, please. All right, finally 2 weeks time to take steps.
26.
26. 2
Fine,
weeks,
Tribunal now.
2 weeks to take steps. ಆಯ್ತಾ?
27. Rajeshwara PM.
For dismissal of the appeal, ಯಾಕೆ? All right, none appears, list it on so and so date. ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Respondent advocate. 28.
ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ, list it on so and so date.
29.
Appearing for respondent in this case, my lords.
Date, list it on so and so date.
29. 29.
Appearing for respondent in this case, my lords, may be taken up on 15th next, my lords.
What after vacation?
20, 30.
30.
For the appellant, my lord.
Respondent. Is appellant during the appeal period, my lord, is appellant is died. Only one LRs is come on record. Other two LRs is not record, my lord. I filed the application for direct the,
List it on so and so date.
please.
Next.
31.
I don't know, I made this application to recall the order of imposing cost. ಅವ್ರೇನೋ ಬೇಡ ಅಂತ ಹೇಳಿದಾರೆ, ಅದು ಹಿಯರಿಂಗ್ ಆಗ್ಬಿಡಿ, ನಂದು ಅಲೋ ಮಾಡಿ,
ಆ
ಅಲೋ ಮಾಡಿ.
ಏನದು DNP ನಾ?
ಕಾಸ್ಟ್
recall-
ಕೇಳಿದಕ್ಕೆ ಕಾಸ್ಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು?
5,000
ರೂಪಾಯಿ ಹಾಕಿ.
ಯಾಕೆ?
ಅದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಅವತ್ತು ಜೂನಿಯರ್ ಬಂದು ಕೇಳಿದ್ರು ಮೈ ಲಾರ್ಡ್ಸ್, ಅದಕ್ಕೆ. We have no objection.
Calling. Council appearing for appellant has filed an application to recall order dated 4/9/24. This application is not seriously contested by the council appearing for contesting respondent. Accepting the cause, this court is inclined to recall the order. ಅದನ್ನ modify ಮಾಡಿ ಇದ್ದೂರು ಮಾಡೋಣ, completely recall ಮಾಡೋದು ಸರಿ ಕಾಣಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರು ಬೇಡ ಅಂತ ಹೇಳ್ತಾರೆ. ಮಾಡಿ ತಾವು ಮಾಡಿ.
500 payable to whom? 5,000 payable to whom? ಯಾರಿಗಿತ್ತದು?
ನಮಗೆ
Respondent.
ಅವ್ರಿಗಿತ್ತಾ? 500 payable to, ಯಾಕೆ ನೀವು ಯಾರು ಇರ್ಲಿಲ್ಲ ಅಂತ ಅದು ಕಾಸ್ಟ್ ಹಾಕಿದ್ದ?
ಇಲ್ಲ, ನಾವು ಇದ್ದು ನಮ್ಮ ಕೊಲ್ಲಿಗ್ ಕೇಳಿದ್ರು ಅದೇನು ಕಾಸ್ಟ್.
Then record in entirety. Record, yes.
Final hearing postponed.
List it in final hearing on.
In fact, I wanted to argue before your lordship, this is not.
Yeah.
Any date may be given, my lords.
KLR land reforms RFA all are ಕಷ್ಟ. ಆದ್ರೂ ಮಾಡಿದ್ವಿ ನಾವು 2 ದಿವಸ ತಗೊಂಡು ಮಾಡಿದ್ವಿ ಅಷ್ಟಾಗ್ಲಿಲ್ಲ.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
Lords, any date?
Next.
Krishna. I'm appearing for the appellate in 32.1, my lord.
Yes.
I filed an IA to bring on record the LRs of respondent. Respondent has passed away, my lord. on
Notice have to go
Notice has to go, my lord.
in both the appeals or
Uh,
only the first appeal.
Only in first appeal, my lord.
All right, issue notice on IA2 of 24.
Please, my lord, in 32.1, my lord, the appellant has passed away and I filed the death certificate of the appellant, my lord. They have not taken any steps. The advocate.
When he died,
26/4/2024, my lord.
26/4/2024.
4/2024. It's been 7 months agide, my lord.
You have filed a memo to that effect?
Please, my lord, on 3/9/2024, I have placed the death certificate on record.
Still appearing for respondents, contesting respondents, has filed a memo reporting death of appellant. Perusal of the memo, this court has noticed that appellant has died on
26/4/2024.
2024. No steps are taken to bring. ಆಗತ್ತಲ್ಲ ಎಷ್ಟು 7 months ಆಯ್ತಾ?
My lord,
26/4.
26/4, my lord.
ಅಬೆಟ್ ಆಯ್ತಲ್ಲ?
Abet agide. April 2024, my lord.
Beyond 90 days abatement ಅಲ್ಲ?
Beyond 90 days. It's been 90 days, my lord, more than 90 days.
The appeal is abated as no steps are taken
Yes.
to bring the legal heirs of sole appellant. Accordingly, appeal is dismissed as abated.
Please, my lord. My lord, sir, date may be fixed for 32.1, my lord, my appeal.
All right, list it in hearing on so and so date.
Notice,
Notice
sir.
only.
On IA number 2 of 24.
ಯಾಕೆ? ಅದ್ರ ನೋಟಿಸ್ ಆಯ್ತಲ್ಲ?
Notice agide, my lord. Any date may, my lord, for returnable.
List it on so and so date.
Not further, my lord, I filed NOC wakalat. The previous counsel has filed memo of retirement, my lord. The causes, the earlier counsel's name is showing. It may be kindly.
Go bari. Race office is directed to delete the name of earlier counsel who has already filed a memo for retirement. So and so has filed wakalat.
Please, my lord.
Race to reflect his name.
Please, my lord. Much obliged. Nagaraj. 32.2 abet agide. Abet agide. Second one. ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆ ಸರ್. Point 1.
Court officer, list 3 ದಲ್ಲಿ ಏನು ಸರ್? ಸರ್, ಲಿಸ್ಟ್ 3 ಎಲ್ಲ ಆಟೋಮೆಟಿಕ್ ಅಡ್ಜರ್ಮೆಂಟ್?
Date ಕೊಡ್ರಿ. ನೋಡಿದ್ರ ಇದೊಂದು ಕರೆಕ್ಷನ್ ಆಗಬೇಕು. ಅದೇ ಮೇಡಮ್ ಆರ್ಸಿ ವಾರ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ, ಫ್ಯೂಚರ್ ಮಾಡಬಾರ್ದು ಅಂತ.
The concerned officials are hereby warned not to repeat the same in the future.
ನೀವು seriously ಅಂತ ಹಾಕಿದ್ರೆ in future ಅಲ್ಲಿ ಮಾಡೋದು. Strong ಆಗಿ ಒಂದು note ಹೋಗ್ಬೇಕಲ್ಲ. ಅಲ್ಲ ರೀ, ಅದು RG note ಇದೆಯಲ್ಲ, ನೀವು accept ಮಾಡ್ಬಿಟ್ಟು ವಾರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. ಅಲ್ಲ, ಅದು ಇದು all certified copies and photocopies of the trial court record furnished by the counsel for the appellant is kept on the record. After vacation. Ravi avare adra Srinivas Rao ಬ್ಯಾಚ್ ಕೇಸ್ ಹಾಕೋ ಬ್ಯಾಚ್ ಅಲ್ಲಿ ಸಿಗ್ತಾನೆ ಇಲ್ವಲ್ಲ ಅವರು. ಈಗ ನೋಡಿ ಐಎಗಳು ಹಾಕಿಲ್ಲ ಅವರು, ಏನ್ ಮಾಡ್ಬೇಕು? ಲೀವ್ ಟು ಪರ್ಮಿಷನ್ಗೂ ಹಾಕಿಲ್ಲ, ಲೀವ್ ಟು ಅಪೀಲ್ ಡಿಲೇರಿಗೂ ಹಾಕಿಲ್ಲ. 44 ಮಾಡಿ ಏನ್ ಮಾಡೋದು? ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೋಗ್ಲಿ, ಯಾರೋ ಒಬ್ರು ಮಾಡಿದೀರ, ಅವ್ನ ಏನ್ ಮಾಡ್ಬೇಕು? TNP ಮಾಡ್ಬೇಕು.